required in navigating the affairs in the international legal market. My name is Mobolaji Oriola. I'll be your host for today. I'm a member of the Executive Committee of the Nigerian Bar Association section on business law. You're all welcome today. Today we have a number of presentations, panel sessions, where we'll be examining various topical issues with respect to the role of lawyers on the activities around international trade. But before we commence the program properly, we have some safety protocols we need to observe. So I'll be inviting a representative of 4 Points, please come up to come and give us a word on safety. Thank you very much. Please a round of applause for him as he comes up.
Good morning, my esteemed guests. My name is Gabriel Ocheja from the Security Department. I'm representing 4 Points to give a safety brief. Please, in case of any emergency, be calm and just listen to any further information from our security teams and the emergency response teams. During any emergency call, the elevator will be out of service. So in this building, we have 3 exit routes. And the one closest to this meeting room is opposite this meeting room, close to the Mercury Hall. For severe injuries, for mere injuries, we have our first aiders, trained first aiders, and we also have a qualified nurse in the building. But for severe injuries, we have affiliation with our neighboring hospitals, the Coptic Hospital and the Healing Stripes. Our muster point in case of emergency call is at the car park, close to the flag areas. In case you need any assistance in this very hall or outside the hall, we have our trained to you. The restroom in this very floor is close to the restaurant, the brasserie. Due to the emergency, due to the hotel privacy policy, we do not have cameras inside this meeting hall. And also, we do not have cameras in the restroom. So please, I will apply you to guide your items properly because the hotel will not be held responsible. Thank you. And we will not be having any drill. We will not be having any fire alarm testing. In case you hear any fire alarm, you know that it's real. Thank you all. Any question?
Thank you very much, Mr. Gabriel. Please another round of applause for him. Okay, so before we start today's program, I would like to establish some very important protocol. We have a number of presentations today and panel sessions where we'll be discussing various issues today. And we have very distinguished lawyers here present with us today. And I'll start by recognizing the presence of the President of the Nigerian Bar Association, Mr. Afam Osigwe, Senior Advocate of Nigeria. Thank you so much for joining us today. Your presence is really welcome. We also have Mr. Steve Richman, the Chair of the International Bar Association Bar Issues Commission. Please, a round of applause for him. I had to ask him for how to pronounce his name properly, being a Nigerian. So Mr. Ian Stanford, did I get it correctly? Mr. Ian Stanford, the Chair of the International Bar Association Bar Issues Commission on International Trade in Legal Services. Please, a round of applause for him. We have the first female chair of the Nigerian Bar Association section of business law, who's also the vice chair of the International Bar Association Bar Issues Committee on International Trade in Legal Services, Mrs. Mfor Osoro. Please a round of applause for her. We have the pioneer chair of the Nigerian Bar Association section on business law, who's also a co-opted member of the International Bar Association Bar Issues Committee on International Trade in Legal Services, Mr. George Itomi. Please a round of applause for him. He pioneered the establishment of the section on business law. Please another round of applause for him. Permit me to recognize all learned senior advocates of Nigeria present here today. I will not be able to go around. Members of the International Bar Association who are here present, members of the Nigerian Bar Association Executive Committee, and also members of the Executive Committee of the Nigerian Bar Association section on business law, fellow lawyers here present and non-lawyers here present, ladies and gentlemen, good morning and welcome to today's conference. Please a round of applause for everybody here. We're about to go into today's activities, and I would like to specially invite the chairman of the International Bar Association Bar Issues Committee on International Trade in Legal Services, Mr. Ian Sanford, to give us his welcome remarks. Please a round of applause as he comes up to give his welcome remarks. Please keep clapping until it comes up.
So thank you very much for that kind introduction. And let me begin by acknowledging President Afam Osigwe, SAN, distinguished guests, ladies and gentlemen, dear professional colleagues. So good morning. As chair of the, and I'm going to say this, I'm going to say the committee name once and then I'm going to call it the committee, but as chair of the International Bar Association's Bar Issues Committee on International Trade and Legal Services, it's my privilege to welcome, or at least to offer a few welcome remarks at today's conference on the internationalization of legal services. Thank you to the team from the Nigerian Bar Association and the NBA section on business law for hosting us and for your leadership in bringing this program to life. At the outset, I also want to acknowledge two distinguished former chairs of the NBA section on business law, George Itomi and Mafon Usoro. Both are active members of the IBA's committee. And Mafon serves as our vice chair. I look forward to hearing comments from both of them as we proceed through today's program. Now, let me begin with a few words about the IBA and the Trade and Legal Services Committee's role in it. The IBA was founded in 1947, inspired by the ideals of the United Nations and committed to supporting the administration of justice worldwide. The IBA is the global voice of the legal profession, bringing together more than 80,000 individual lawyers and nearly 190 bars from over 170 countries. Its core themes include justice, human rights, the rule of law, and the independence of the legal profession, as well as building cross-border connections and expertise. The IBA's work is organised through divisions and committees that span both professional interest and legal practice. Now, just to locate our committee in the IBA, so the Public and Professional Interest Division addresses issues that make law a profession more than just an occupation. It includes the Bar Issues Commission. And within the Bar Issues Commission, you'll find the International Trade and Legal Services Committee, alongside with committees on policy, regulation, and for bar executives. The committees, or at least the Trade and Legal Services Committee's role focuses on cross-border legal practice and how the rules that govern international trade affect the work that we do as lawyers. That includes the World Trade Organization's GATS framework, as well as bilateral and multilateral free trade agreements, and national regulatory regimes. We monitor developments within the WTO and across FTAs. We provide support, information and practical guidance to bars and law societies. And we do things like organise these conferences. Our aim is to equip bars and their members, individual lawyers like many of the people here today, to navigate change, manage risk and capture opportunities for cross-border work. Let me stress one point. We're here to help bars and their members to assess options. We don't push a single model. We respect the diversity of legal systems, the regulatory choices, that different countries make and different jurisdictions make, and market conditions. The committee's membership reflects that, and our role really is to share comparative experience, illuminate choices, and support locally led decisions. This approach underpins our dialogue with the WTO on trade and legal services. And it was a particular honour this year to engage with the WTO Director General, Her Excellency Dr. Ngozi Okonjo-Iweala, who is of course Nigerian. We value that ongoing conversation and the insight that it brings. So why do we promote conferences like this one, and why are we here in Lagos? Well, we've partnered with the NBA to co-design this conference for a clear reason. In many developing countries, in many developing markets, we've heard a concern from our members. When major cross-border transactions come to town, international firms can take the lion's share of the transactional work. Then when a dispute arises, arbitration may move offshore with local practitioners again on the margins. Our response in the committee to hearing this concern was to build practical programs with local bars to strengthen positioning, capabilities and networks in cross-border matters. The goal is simple: help local lawyers secure a better share of the international work that touches their markets, and do so on terms that protects professional values and client service. This is the 12th edition of this conference. Since 2016, we've convened in locations including Zimbabwe, Kazakhstan, Kenya, Zambia, Cambodia, Costa Rica, Indonesia, South Africa, Chinese Taipei, and Fiji. Across these events, including today, we've welcomed almost 1,800 participants in total. The appetite for practical, market-focused dialogue is clear, and it seems to keep growing. Evidently, Nigeria has a vibrant legal profession working in a sophisticated market. Your firms and counsel are already central to many of Africa's most complex transactions and disputes. Your courts, arbitral institutions and regulatory bodies are influential at home and beyond. But markets are dynamic. Rules, clients and value chains change and evolve. Today's program explores that reality. Together with the NBA and the section on business law, we've built sessions designed to be candid, practical and focused on actionable insights. I hope that all of us will find that this conference strengthens our ability to win, lead and retain cross-border work. So let me wrap up. Thank you again to the NBA and colleagues from the section on business law for your partnership and hospitality. Thanks in advance to our speakers and moderators, and thanks to the many delegates present here today and online. Your engagement is what gives this series its energy and value. I look forward to the conversations ahead. I hope that you'll all find insights today that you can deploy tomorrow when you return to the office. Thank you very much.
Thank you so much, Ian Stanford. There's another round of applause for him. So I have made a fundamental blunder. I'm a member of the executive committee of the SBL, and I did not recognize the presence of the chair of the SBL. Please, I have made a serious blunder, an offense that cannot be forgiven. So please help me recognize the presence of the chairman of the Nigerian Bar Association section of business law, Mrs. Ozofu Latunde Ogemudia. Please, a round of applause for her. Please keep clapping for her. Thank you so much. Thank you so much. My very sincere apologies for that blunder. I would like to also now invite to come and give his welcome address the president of the Nigerian Bar Association, Mr. Afam Osigwe, Senior Advocate of Nigeria. Please, a round of applause for him.
Thank you so very much. Let me join in welcoming all of us. Mr. Ian, the chair of the IBA Bar Issues Commission and International Trade Legal Issues. That's a very long name, you know. And other distinguished guests. I thought when Mobalaji admitted that he made a blunder, I think that would extend to recognizing the founding chair of the SBL, Uncle George Tommy, and the Mia Sen, Jane, Anisha, and all the senior advocates, and other distinguished colleagues here. Well, welcome. You know, it's always an interesting conversation when we talk about cross-border legal practice and all that. And you know, you can't blame us here in Nigeria when we're a bit skeptical when people like you from the developed world happen this. Our fear is that you actually want to be in on the take so that you also outcompete us locally. That is not about developing our capacity. But we would want to have cross-border legal practice that is fair, that does not look on us as persons to be tolerated, persons you may have to work with, but one about sharing knowledge, working as equals, working as professionals who all have something to bring to the table, and not as persons who just, well, for us to do this matter here, we just have to involve them, but don't take anything they do seriously. As presently a bill before our legislature, the National Assembly, to amend the Legal Practitioners Act. It has a section there, proposed section there, that would allow foreign lawyers to be permitted to do a transaction, but with Nigerian lawyers. And it is our hope that if passed into law, that would not be abused to become a perennial license to practice, or a license for Nigerian companies or IOCs or multinational companies in Nigeria to continuously engage foreign lawyers under the pretense of being a single transaction. We would want to benefit from the global international legal practice. The world is global, and so we are not insular. We want to benefit from it. We'd also want to see a situation where the arbitration you referred to take place here in Nigeria, where the lawyers leading these arbitrations and proceedings are Nigerian lawyers, leading lawyers from Europe and America. But we're open to the conversation, and we know there's a whole lot we can learn from you. And also assure you that there's a whole lot you can learn from us, and that we're willing to work, but not as junior partners. And we're all ready to benefit from this business, because it is indeed business, and we are coming in as quote-unquote major investors, not minority shareholders. So I welcome you to Nigeria, and I hope that the conversation here will be fruitful, and I will have a better insight and understanding as to how cross-border transaction and legal services work, and how all of us can benefit from it. And hoping that you also come back to Nigeria someday in near future to host the IBA conference. I understand we had the largest delegates to this year's conference in Canada. And I also think that more and more Nigerians should be involved in the committee work and others in the IBA. There's a lot you can learn from us, only that you don't know. Thank you so very much, and welcome to this program.
Thank you so much, the President of the Nigerian Bar Association. Please, another round of applause for him. Permit me to observe all protocols so that I don't make any further blunder. I recognize the presence of all senior advocates of Nigeria here present. I would like to then invite the founding chair of the Nigerian Bar Association Section on Business Law and Vice Chair of the International Bar Association Bar Issues Commission on International Trade in Legal Services, Mr. George Itomi. Please, a round of applause as he comes up. That clap was not really, please, a resounding applause for him. He has done so much in the legal profession.
You know, if I was a pastor, that clap would have been, I would have told you the one you gave was for you. Now give one for God. Let me join um, the welcome to Ian and Mikhail. By the way, Mikhail used to be the past chair of the Law Society of England and Wales. So we've had a long history. I actually visited him in London a few years ago when he was there. And Ian has been doing a great job steering a very difficult committee of the IBA. So, Umfon, I feel sorry for you when you step into his shoes. Let me particularly acknowledge and thank the president of the Nigerian Bar Association, Mazi Afam Osigwe, Senior Advocate of Nigeria. Now, just so you understand my relationship with Afam, we go way back to when he was the General Secretary of the Nigerian Bar Association. And in those days, when the whole conversation about cross-border legal work came about, we had been working very closely to address the concerns of Nigerian lawyers. In other words, what's the need for us? And in fairness to Umfon, she raised the first alarm in 2006 when the NBA was stepping out with its maiden conference. And she called me and said, Chair, there's something going on. They're going to open up legal services and we better get it on the menu in Nigeria. So we introduced it as a hot topic for that particular conference. And she gave a sterling paper on it. And that started the whole conversation about this cross-border legal work. The idea being to sensitize Nigerian lawyers about what we all considered inevitable and how we could, in a manner of speaking, get the best out of it. And I'm sure you all agree with me that from that time till this day, it's been high on the menu. And just across all sections, branches of the bar, the main body of the NBA, it's been very topical. And that's because the Nigerian Bar Association is very progressive. We acknowledge when events that affect practice take place and how we can do our best to support those events. And that's why we always have this very large contingents to these international conferences. It's very expensive. It's not as if they're going for tea parties. It's just so to integrate with the international legal community. And so I just ask, therefore, how do we, the same question we asked in 2006, how do we get the most out of cross-border legal services? First of all, I liken the entire debate to being invited to a banquet. The food is all laid out, everything is nice, very, very mouth-watering dishes. But first of all, to be able to participate in the meal, you've got to be in the room. So it's not enough to stay outside and be screaming and shouting, no, 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 we don't agree, we don't agree. You've got to be in the room. And then when you're in the room, you can then decide, okay, I want eba, I want okra, Ghana jollof. There are some Ghanaians here. Welcome, welcome. They said they had Nigerian jollof, which was very delicious. And then upon further inquiry, it was the Ghanaian chef that did it. So, and I'm glad you guys came because it's a regional concern, this entire issue of cross-border. And as we'll see later in this one-day workshop, the African Continental Free Trade Area also is discussing this. So all within the context of how we can integrate legal services. Because as the world becomes increasingly globalized, and I'm saying this tongue-in-cheek because I'm looking at Donny Boy in the US. He has a totally different worldview. But let's just assume that the world is becoming increasingly integrated. How do we benefit from it? Coming back home, we produce 10 to 11,000 lawyers every year. There are some members of the body of benchers here. It's our responsibility to admit new lawyers into the profession. And then I still remember when I first joined the body, we were talking about 5,000 to 6,000 lawyers a year. But by the last call, that number had gone to 11. And I cannot tell you that there has been a commensurate expansion of the profession to accommodate these new lawyers. So what do we do with them? I know the draft bill is looking at how you can sort of restrict or let me say, manage the progress of new lawyers into the profession. I don't know if that's the best way to go about it. But for me, baseline is how do we create more work in the profession? How do we deepen legal services? And how do we ensure that at the end of the day, this is about dollars and cents, it's about pounds and pence, it's about naira and kobo, and it's about CDs and dollars. How does it hit your pocket? How do you create good quality jobs that goes along with the pride of being a lawyer? That's, for me, is the baseline to all these debates. Now, we've seen that across Africa, but especially West Africa, there's been this penchant for the largest consumer of legal services, which is government and its agencies, ministry department and departments and agencies, to grab foreign legal services under the pretext that you don't have local expertise. They don't even know that so much has changed along the way. But for reasons that some of which cannot be said, they still prefer this option. Now, let me say something clearly. We have never, Nigerian lawyers have never been anti-foreign legal practitioners. We've never been. Our problem has been, let it be fair. I always say that even when we get briefed from abroad, the general pattern is that it's the foreign lawyers who brief local counsel on whatever is happening there. So your contact really is with counsel on the other side of the Atlantic. But in our own case, willy-nilly, they have access to even the highest decision-making agencies. And in that process, undermine and diminish the importance of Nigerian lawyers. And I think at times it's aided by some of these big firms. And that's why it is important that we're all here to discuss this. Because once the rules are set, then everybody must practice within those rules. And the president has just told you, under the proposed act, there will be, I won't use the word limits, there would be the circumstances well spelled out about how these collaborations can happen. And if anybody decides to fall outside of it, then there will be consequences, which is why it is important for us to have the discussion, never to shy away. Because when this entire discussion started, initially, we didn't want to hear. We didn't want to know. No, it was just no. And we had several debates, pros and cons. Until today, I'm not too sure if the cons are not more. Cons in the sense of no. But the pros are saying, no, let's at least have a discussion. And I think that's the correct way to go. And that's why we're here today. And as Ian mentioned to you, Umfon and I have been part of the ITILS. She was there before me. And we've been going round on missions like this. I have personally been to Zimbabwe, to Zambia, to Kenya as part of these missions to just help explain how we can get the best out of this. Because the future I would like to see for legal services is a future where young lawyers are assured that this profession that they've slaved for, they've angled to become members of, actually deliver on its promises. Today, the jury is still out as to whether that's happening. And it breaks my heart when I see many young lawyers having to, let me say, learn law in the streets. And the worry that I have, and that should concern every one of us, is that, once you are called to the bar, your years at the bar start counting. And it doesn't matter how the journey has been going. So once you clock 10 years, you're eligible to become a senior advocate. You can become a state attorney general or federal attorney general. You can become a judge. And if you have the right political contacts, you can get these things. So the question then becomes, what sort of law will come out of a foundation that's not solid enough? Which is why we keep, one of our asks in this conversation is, how do we have access, let me say, to back office support, which is actually one of the major advantages the large law firms have. Whether it's going to be through collaborations, whether it's going to be through partnerships or any other form of combination, one thing is very clear, we need collaboration. More importantly, we need the support of the government. Because you think about it, why do we quarrel? A brief comes in, it's given to a foreign firm. We don't know, let's for argument's sake, say the fees involved is $10,000. Then they do a beauty parade amongst, let me say, local firms. I hate the word local, but let's for today accept it. Local firms. And this beauty parade, as we've seen, leads to undercutting. And then you then come in at $500 out of a $10,000 brief. And of course, you put on your website how you worked on this fantastic case with XYZ firm. But baseline, it deprives you of the opportunity to actively benefit from that transaction. So our argument is that if we do it the way it's done anywhere else, brief local firms, let them in turn brief the foreign firms. That way you put them right in the middle of the transaction. So there'll be greater equity in sharing of the fees. And there will be more support because you all want the brief to work for everybody. So in other words, everybody's happy. And I think that's the message we must all take away from this workshop. And whether we're preaching it everywhere across the profession, we must begin to look at that, get to that point where we deepen legal services so that it helps raise the standard that we're looking for. Because at the end of the day, we're looking at how we can deliver the best to the clients. Let's not forget, it's about the client and in the most efficient manner. So I know in the course of the panel sessions, you look at specifics about what I'm discussing. But let me just touch briefly on how we in Africa can begin to harness our resources towards this whole topic of the globalization of legal services. In West Africa in particular, English-speaking West Africa, even though we're all bound by the common language English, that's probably where it ends. Our laws are discordant, they're not harmonized, and there's absolutely no guarantee that what attends to regulatory incidents in Nigeria will be the same in Ghana. The French West African countries have done a lot better than us because through the OHADA initiative, they have harmonized their business laws. And I think we should borrow from that because you cannot have this conversation when you're all speaking from different dockets and from singing from different hymn books. So that's one of the things I think we should be doing. And that applies even so for the African Continental Free Trade Area. You can't do it if your laws are not harmonized. I should be able to determine with precision that what obtains to business law incidents in Nigeria is what will happen in Ghana and Gambia and wherever. If we don't do that, then you'll have this scattered implementation of this whole globalization concept to our own detriment. So we now look at how then what we lawyers should do. Because it's one thing to expect the system to support you. It's another thing to help yourself. The whole importance of continuing legal education is so primary to becoming a good lawyer. I've always said that when I discuss with many of our colleagues. Even if you did a 5-year rigorous legal course and you did 5 subjects, if you let me guarantee 6 subjects a year, that's 30 subjects. Okay, law school adds another 4, so 35. So big deal. When you come into the real world, because law is life, it attends to every single incident of life. If you do not update your law through continuing legal education, you'll become a dinosaur, no matter how young you may look. So that's why these are so important. And I must give credit to the president of the NBA, because when the NBA insisted on giving continuing legal education points, there was uproar, and you go through all the discussions. Oh, you can't do that. What guarantees me practice is when I'm called to the bar and nothing more. No, that's not the way it's done. And I'm glad that Mazi Afam fought so hard to the point where it's going to form part of the law when the time comes. Because you can't, yes, he deserves it. He deserves it. Because, I mean, we had to initially get the chairman of the Board of Benchers to read it as part of his charge to new lawyers. I mean, that's because your position at times was coming from even senior quarters. Don't be mistaken that to think that I was only the young lawyers. So here we go. And I'm glad that if at the level of the NBA this is recognized, then we have no business not following it. Because the relentless pursuit of excellence is what will count when the time comes. There are no favors. Let's be honest, there are no favors. Even when we win the battle to be part of a brief, if you don't have anything to contribute to that brief, then you don't deserve to be there in the first place. So we cannot afford to let the side down. And I'm going to end with a heartwarming story, because you just need to know the origins of all of this. It's not as if we're plucking stuff from out of the air. You see, this whole talk about globalization in whatever form you look at it, it comes from international obligations entered into by various countries. And Nigeria signed on to the World Trade Organization agreement to open up or bring down barriers to free flow of trade in goods and services, including legal services. So we have an international obligation to do that. So it's not as if it's a discretion. And the head of state who did it in our time was Sani Abacha. So for somebody who was such an insular head of state to even sign on to it would tell you how important it is. And only a few months ago, Ian Umfon and I were at the WTO, where very, very proudly our own, the DG, our own Ngozi Okonjo-Iweala, it was so proud having, let me say, Nigerians in the room discussing global issues. So we basically reaffirmed our faith in the WTO and our desire to continue to collaborate with that body to ensure that we deal with all the issues concerning the incidents attaching to cross-border legal work. There were particular concerns raised about the advent of artificial intelligence and trade in the digital economy, because those ones tend, by reason of technology, to defy clearly defined borders. But that's not to say they cannot be regulated. It comes down at the end of the day to how you can regulate for all these things. So it's not a reason not to participate in it. And I'm glad that today we're back as part of a continuous and continuing journey to ensure that Nigerian lawyers become part of the global part of the international legal services market, but with the caution that the NBA president has mentioned, let us do it fairly, because equity is the name of the game. On that note, I want to welcome all of you, and I wish you a wonderful workshop. Thank you.
Please, another round of applause as he walks to his seat. He has given us a charge with his keynote speech: collaboration between international law firms and Nigerian law firms, not local law firms. So we're not local law firms. Fairness in the way we work together, and also what are the plans we have for young lawyers. He also highlighted the issues around undercutting between law firms. And I always tell people that there's only an extent to which you want to undercut if your operations and your overheads continue to increase. And on that note, I would like us to give another round of applause to Mr. Jordan Tomi for such a wonderful keynote speech. Thank you so much, sir. Now we'll have to go for a quick 15 minutes group photograph session. I would like to invite the representatives. Firstly, Mr. Ian Sanford forward, Mr. Steve Richards forward, and other representatives of the International Bar Association. Please step forward for group photographs. So join them will be the president of the Nigerian Bar Association, Mr. Afam Osigwe, senior delegate of Nigeria. Please, you can step forward. Photographers, please take step. We'll also invite the chair of the Nigerian Bar Association, Mrs. Ozofu Latunde Ogemudia. I'll also invite the vice chair of the IBA Bar Issues Commissions on International Trade, Mrs. Mfon Usoro. Okay, who's here? Other learned senior advocates here present, please. I would like to. What did you say? Okay, for this one. Sorry. Okay, sorry. Sorry, I would say sorry. I would have to. Sorry, I would do it after.
Tonight the music seems so loud. I wish that we could lose this crowd. Baby, it's better this way.
Steve Richards, please stay back. We have a presentation coming up. The topic is Introduction to International Trade in Legal Services and its applicability in West Africa. We'll be focusing on international trade in legal services, which involves cross-border provision of legal expertise through advisory services, dispute resolution, intellectual property protection, and regulatory compliance. We have the Vice Chair of the IBA Bar Issues Commissions on International Trade in Legal Services, who is the Managing Partner, Mrs. Mfon Osoro, please. Please, a round of applause for her. She comes up. Please, that one is for yourself. This one should, please, a louder applause for her, please.
Yes, so Managing Partner of Paul Usoro & Co., just to complete his introduction. Good morning, everyone. Permit me to adopt the protocol. We've had a good opening by the chair, Ian Sanford, and also by my chair. I called him his chair forever, Mr. George Itome. So now, this is one of the foundational presentations in our internationalization conferences. We give an introduction to trade and legal services, and now we apply it to Africa. Some might take it for granted. Why do I need to have this introductory presentation? But a recent experience that I had highlighted how critical it is for us to have this conversation in addition to the issues that George has mentioned. There was a private sector initiative to form a coalition of professional services. And it was like a trade in service of professional services coalition of professional services for trade in service, something like that. In any case, it was to be incorporated as an incorporated trustees. So the lawyer that was engaged by the group went to CAC to get it registered and was blocked. They did not want to register it. It got me to speak to a lawyer at the CAC. So the conversation went like this. The CAC person is a lawyer, and he said, Madam, there's trade in this name, trade in services. So it cannot be registered as an incorporated trustees. It has to be a company. So I had to give him a lecture on what we mean by trade in services. And for a group of professionals, those who offer professional services wanting to come together, does not mean that we are trading. The company is trading. This is the purpose for which the group is set up. He said, well, in that case, you mean you want to regulate services sector as a whole? I said, no. If we wanted to regulate, we'll go to the National Assembly for an act. We want to form a group, a private sector-driven group, so that we can interface with government officials who are negotiating for trade in services for us. So that just showed to me that it is important to keep explaining and keep talking about how legal services are traded. And as George mentioned, our government, unfortunately, we don't have the monitor, so I have to be signaling to them to change the slide. Everybody is affected by globalization. Our government, as one of their priority, is to encourage and attract foreign investment. That immediately means that the foreign company will engage a lawyer where they are residents, and the lawyer would advise that foreign company on how to set up. And lawyers follow their clients. So they might come physically to Nigeria to assist in the documentation or advice from the foreign country. Some of them might be engaged as sole counsel, and some might work together with local counsel. So in one form or the other, foreign companies are supplying legal services in Nigeria. The issue now is that we, as Nigerians, we need and we want to be able to key in. So countries then come together. Change the slide, please. Countries come together under different arrangements to negotiate and develop rules that will guide the provision of legal services from the exporting country to the importing countries. So we have lots, and the purpose is to have a smooth flow of international trade in both goods and in services. We have examples of rule-based approach, like the WTO, where everybody knows what is happening, what kind of rules, what kind of services, what type of legal services, and in what form that legal services could be delivered across border. And we also have regional arrangements like the AFCFTA, like ECOWAS, the one in the Asian countries, and also the EU, Mexico, and Canada free trade agreements. It used to be North Atlantic free trade agreement prior. We also have an arrangement that is bilateral, and that is Nigeria, for instance, might get into a bilateral agreement with China or any other foreign country, and they will have a holistic conversation or agreement on trade in goods and services without particularizing. And that is very dangerous, because if one is not aware or interested and tuned into what is happening, then the country may open up its services without any rules, without any protection, without any level of transparency. So we lawyers, we have to be able to understand what is happening and also be parts of the conversation. So the purpose is to negotiate a reduction of trade barriers among member states through the removal or elimination, where possible, of measures that restrict market access to service suppliers and measures that impose discriminatory practices against service providers. Because this now, not only are we as importing countries where foreign lawyers deliver legal advice to Nigerian companies, we are also an exporting country, because some Nigerian law firms also have established offices in West Africa, East Africa, and also in the UK. And some of us have entered into arrangements with foreign law firms on a best friend basis, or even more serious than that. I believe Ian and Mikel will talk about those arrangements. So the free trade agreement or the trade agreement on services aim to develop common principles, standardize terminology and understanding among the member states. And the next thing that they do is to schedule commitments. But prior to scheduling that commitment, the service sectors are grouped into different subsectors. For the WTO, which adopts the United Nations Central Product Classification, our profession, legal services, is under the business services. You can see on the board that I have two types of CPC. That is the Central Product Classification System, so that they will have common terminologies, common principles in discussing and negotiating the issue of legal services. So we have the old CPC, which was developed in 1991, and also there's a new one, version 2.1, developed in 2015. Our AFCFTA, and indeed, I think still the WTO, we're still using the terminology of the 1991 CPC, but they are similar, except that the most current one gives clearer understanding, clearer explanation on what constitutes legal services. So under the business services, which we fall under, you have legal services categorized into three main subsectors. That is the legal advisory and representation services. Legal advisory is clear. Representation is litigation relating to civil law, criminal law, etc. And we also have legal documentation and certification services, which is drafting certification of documents and commercial contracts, patents, IP rights, etc. And they now also have, as a separate subsector, arbitration and conciliation. The CPC defines arbitration and excludes representation services on behalf of parties in the disputes, because this has always been a serious issue. Should we allow foreign legal practitioners to come in and appear in arbitration proceedings in Nigeria? Our current LPA would not permit so because our current LPA says that it has to be a legal practitioner. And that legal practitioner must be somebody who has been qualified to practice law in Nigeria, which somehow tallies with this definition of CPC, and it's something that all of us have to be knowledgeable about so that we can also argue. On the AFCFTA, all of this as it applies to Africa, we know that the AFCFTA is fashioned after the WTO agreement. It also works with the CPC 1991 and currently has prioritized 5 service sectors for negotiation. And those are business services, financial services, communication services, tourism, and transport. And again, the legal profession comes under business services. This is the diagram that represents what we have in the AFCFTA. Next, business services, then professional services. Next slide. And we are under professional services. Again, under the AFCFTA, copying the WTO, it means representation and advisory services. So to understand and get prepared for negotiations, or even to understand what our negotiators are doing, we also have to appreciate the underlying principles governing multilateral or regional trade agreements such as the WTO, which we're a member, and also the AFCFTA that Nigeria and most African, I think all, except one, signed up to the AFCFTA. We have the non-discrimination between member states. How do they operationalize the non-discrimination? It is through the market access and also national treatment. Market access, we get to see it, a fuller explanation earlier, but members are granted access. It is assumed that you grant a member state access to each territory to perform services as scheduled in the a country schedule of commitment. Another principle is to continue on progressively liberalizing and removing the restrictions, and that is done through negotiations. And again, they also have the most favored nations status, and that simply means if you give market access to country A, you also have to give the same opportunity to another member state, country B, except if that has been, certain things has been exempted and put in the schedule of commitments under MFN exemptions. It also takes on transparency as one of the underlying commitments, and the transparency is by member states writing, scheduling what they have agreed to open up. So in all of this, we have something that is called schedule of commitments, schedule of specific commitments. But the first one that comes up is the horizontal commitment. And then you have the horizontal commitment applies across board to all the service sector. And then you have the schedule of specific commitments. And this is just a diagram that summarizes everything, but we'll come into it. But even before we go into that, part of the terminologies that we need to understand in this grouping of services and how it is being discussed and opened up is on the mode that services are traded. So how are legal services traded? It's not a commodity. You cannot see it like the beautiful suits that Judge is wearing. It's very easy to regulate that one. It's very easy to know that it came from maybe Italy. It came from Italy, and the Nigerian government imposes a tax for importing. Don't worry, they won't come after you for importing suits from abroad. But for legal services, how do we trade it? We have talked about it happening anyway. So it's divided into four modes. We trade our services through cross-border supply, which means that the advice, the service itself, crosses border. I am here, Polusoro & Co. is in Nigeria. We don't leave Nigeria, but we advise a company, a law firm, or whatever, in a foreign member state, like, say, the UK. So this has been going on forever, by email or Zoom, and we offer legal services. And then there's mode 2, consumption abroad. Consumption abroad means that a resident in a member state has the freedom to travel to another member state to consume legal services. So Company A in Nigeria goes to the UK to Follyhog, which is where Ian is a partner, to get advice on legal issues. That's consumption abroad. And then commercial presence. That means that the foreign legal office practitioner comes to Nigeria to establish a law firm or a branch office. That is mode 3, commercial presence. And mode 4 means the presence of natural persons. And that, as it's very, very clear, is that a counsel from Follyhogs, again, Ian, comes to Nigeria to deliver legal service. What kind of services should that person be allowed to, and how long? These are all spelled out in the schedule of commitment. And when imputing in the schedule of commitment, they don't repeat cross-border supply, consumption abroad, commercial presence, presence of natural person. They just put mode 1, what is the commitment of that country, mode 2, mode 3, mode 4. So it's important to understand this as we go on. Yes, so the non-discriminatory principle and the transparency principle is operationalized through market access and national treatment, as I said earlier. Next slide. And market access means the conditions of a member state guaranteeing market access to foreign suppliers of legal services to the domestic member country. Like, what conditions do we have to grant market access to European lawyers, to English lawyers to come and practice in Nigeria or offer legal services in any form? And it is subject to the conditions set out in the limitation column of a member state schedule. So we have the market access under the schedule of specific commitment. We have the limitation to national treatment, and we have additional commitments. And under the WTO and the AFCFTA, the conditions for granting an access to our markets must not be less favorable than conditions specified in the schedule of commitment, so that any foreign practitioner coming in or who wishes to come in will see what the limitations are. And when they do start to provide the legal services, they must not be met by surprises, which restrict what we had represented in our schedule. And on national treatment simply means that the foreign legal practitioners and Nigerian lawyers, and like Judge, I don't like to say local lawyers because we're international lawyers as well. So both the foreign legal practitioners and the Nigerian lawyers must have equal treatment. Equal protection, same favorable treatment to foreign lawyers as any Nigerian lawyer practicing. And if we do not wish to give them all the advantages, all the rights of a Nigerian lawyer, then we must disclose it under the limitation to national treatment, which means that when a country puts what the limitation is in the schedule, it means that that country, that member state, wants to maintain some restrictions on national treatment, wants to maintain some discriminatory measures against foreign legal practitioners, and this has to be indicated in the column. So even as we enter the agreement, and that is why we have to have savvy negotiators, they have to understand that the agreement allows member states to liberalize according to their own level and their own national interest, and indeed you can restrict some. You can have some restriction, but it has to be disclosed in the relevant column. So then you also have as the third column additional commitments. This is optional, but a member state is supposed to add, not reduce what they have already scheduled under market access and national treatment, to add further opportunities, positive undertakings, and especially on issues that were not covered under the schedule, like standards and issuing licenses. Next slide. Another terminology used in trade negotiation is non and unbound. Where a country enters non under the column for market access, for example, it means that there are no limitations on market access. Same with national treatment. If the entry in the schedule is none, it means a foreign legal practitioner can come in. You don't have any restrictions whatsoever. However, it applies only to the sector or the subsector. It's not generalized. And we have to note that the horizontal commitment applies. And in most cases, countries have restrictions in the horizontal commitments, which we will explain shortly with examples. Then another entry is unbound. All areas that have been listed in a schedule are considered to be bound, that is to be binding. They are binding, they are guarantees to your trading partner, except you have specified the limitation in the schedule. And a member is free in the specified sector and mode of supply to introduce or maintain measures that restrict, that are inconsistent with the market access obligation, the national treatment obligation. And again, we mention in greater detail, next slide, what we mean by specific commitments. Next slide. Next slide, specific commitments. As I said earlier, is a binding undertaking to provide market access to foreign legal practitioners on the terms and conditions that are specified in a country's schedule. And it covers market access, national treatment, and additional commitments. You have it in two sections. This one section on horizontal commitment, another section on sector-specific commitments. Next slide. The horizontal commitment is a list of undertakings, and it comes first in a schedule for a country, or like in the AFCFTA, where the RECs are the negotiating parties, that is the regional economic communities. It comes first, the horizontal commitments, before we have the specific commitments. The horizontal commitment is a list of undertakings or limitations that apply to all sectors of the economy that is included in a member's schedule. It generally applies to the modes of supply that are grouped as commercial presence and the presence of natural persons. But when you are evaluating the commitments of a country, we must take those horizontal entries into account. The limitations on commercial presence, that is establishing an office in the host country or physically being present in a host country to supply legal services. I have some examples here. And this was when I was part of the Nigerian Office for Trade Negotiation, and that is what was negotiated and inputted. Next slide. It is from the ECOWAS member states plus Mauritania consolidated horizontal commitments, and I've specifically brought out that of Nigeria. Nigeria has listed a limitation to market access, and this just explains how it is a requirement that applies to all sectors of the economy. For instance, there's a requirement that you must incorporate your business with the Corporate Affairs Commission, whether it is legal services or manufacturing or financial services. It applies to all service sectors. And also, if they need to have land, we know about our laws with respect to alienation of land. Every sector must comply with that rule. Because it applies to all sectors and because of our commitment, it operates on a non-discriminatory basis. Once you have been allowed access to the market in Nigeria and you want to construct an office to acquire land, you have to follow the process. You have to register at the CAC. Same thing with having to expatriate your earnings. Nigeria allows foreign companies to transfer their revenue abroad according to existing laws. That is an example. And the next example of horizontal commitment. Next slide. Next slide. That's the one I just talked about was with respect to commercial presence. And then the next one is with respect to natural persons. A slide before that, you've gone too fast. Yes. So Nigeria is unbound with respect to Mode 4. As I said, you won't see the meaning of Mode 4. It's just Mode 4, and you're expected to know that Mode 4 refers to the presence of natural persons in a member's territory to deliver legal services. So Nigeria is unbound, meaning that Nigeria is free to maintain restrictions and limitations that contradicts with our obligation to grant market access to everybody, so long as it has been transparently included in our schedule. So we are unbound, and it has mentioned that we have entry and temporary conditions for entry and temporary stay of personnel. And if you, I think it's NOTAP, they have specifications on the type of persons that we can grant business permit to and the number of months that such permits are granted. And then you have also on national treatment, the limitations, unbound except for measures concerning the categories of natural persons. We refer back to the other ones because we have said under market access that it will be granted to senior management and experts, jobs that require expertise, which means that cooks and cleaners should not come from China if we're to be strict in applying our laws. Next slide. So this one is an example of a specific commitment negotiated under ECOWAS. Legal services under CPC 861, which I had explained in previous slide what services are covered. Representation being litigation and advisory on transaction matters. So under Mode 1, what has the ECOWAS countries presented as their common position, negotiated position? Under Mode 1, remember, it is cross-border where the service itself crosses electronically. You don't travel. So all members of ECOWAS are unbound, meaning that it is not 100% free. We can impose restrictions and limitations. You're expected to state those limitations openly, but this puts everybody on alert, puts everybody on notice, so they would have to now engage local lawyers to advise them on what the law permits. So it is unbound, except Benin, Cape Verde, Cote d'Ivoire, the Gambia, which means they have some other rules. Some of them are, have none. And they also explain if there are any issues that they need to state the restrictions. Then under limitation on national treatment, all are unbound except those countries. And we go further down, they will also state the areas that they have been able, or they are ready to impose restrictions. For instance, in that legal services, let's look at the additional commitments. All decisions by the ECOWAS summits have direct effect in the ECOWAS member states. So you have to go and read those decisions. But the third one there for the UMA countries, UMA decisions and regulations are binding on only UMA countries. But because there is a high degree of harmonization, when you read this paper, you see areas of the legal profession where they say the freedom to come in and practice, to come in and set up office, to come in and have residence is restricted only to UMA, lawyers from the UMA countries. So you have another one on Mode 2. Next slide. Mode 2, which is on consumption abroad. All ECOWAS members, again, except those countries, are unbound. And Gambia says none. None means it has no restrictions, howsoever, but it says, except as required by the Legal Practitioners Act. It is important, when I was in the Northern team, some countries asked that they have to state what restriction is in the Legal Practitioners Act, so that on reading the country's schedule of commitments, you know, without having to go to another document to read about it. And still on Mode 2, consumption abroad and limitations on national treatment is unbound. What transpired, or what the sense I had was that the legal profession was playing it safe. Because in most of these countries, they had not interfaced with their national bars. So the representatives of the negotiators representing the countries did not want to make any commitment which has not been sanctioned or approved by their Ministry of Justice, their bar associations, and all the government agencies responsible for regulating the practice of law. So it's because the negotiation on AFCFTA are at the infant stage, it was safe, it was better to play safe. And for Nigerian Bar Association, we had actually written to Norton and to the Ministry of Trade that they should remove legal practice, legal services entirely from the group of service negotiations because of the peculiarity of legal practice. So I guess also some other countries followed that approach, and so it was mostly unbound. Even South Africa, their representative will state clearly, no, you cannot insist for them to open up on this because they have to refer to their Ministry of Justice. And that is what we should take home to discuss. The representative of the Attorney General of the Federation and Minister of Justice is here, that we don't get pushed into making commitments without talking to the people that it affects, which are lawyers. And then also have Mode 3 on commercial presence, still with respect to legal practice. Next slide. This one has more details. Still, several ECOWAS countries entered unbound, meaning they can have restrictions. And Benin went on to give more explanation, stating, yes, you can, it is unbound, it will maintain restrictions, it will have limitations, except for UMA countries. Even for that UMA countries, that is the Francophone Africa, is a very strong harmonized region. But even for that, those lawyers from UMA countries, they have to have prior authorization from the president of the Bar Association of that country. Mr. President, how would we be able to get the Ministry of Justice to recognize us the way a country like Benin has done? Because we know where it pinches, and we have to be able to be part of that negotiation. It was so during the time of, 2 ministers ago in the Ministry of Trade, because he was a lawyer. And also we had the people in Norton. We had representatives from the then president of the bar. We wrote to them, and we have to be part of their team. So we were not shortchanged in legal profession with respect to the ongoing negotiations. Same thing, you can see the favorable treatment given to human lawyers in Côte d'Ivoire. So these were just to give examples of what happens under what we enter under the sector-specific commitment. It is really, really sector-specific. It could also have subsectors. South Africa went on and had not just legal services, it had subsectors, international law, domestic law, arbitration for further clarity. But we did not go that far. And then on Mode 4, which is the presence of natural persons. Next slide. All ECOWAS member states were entered unbound, meaning that they can have limitations and restrictions. It's not free for all. And Benin Republic wrote there that they have obligation to report to the president of the bar and to be associated with the Benin lawyers, except for the UMA countries where Benin has reciprocal arrangements. All of them have reciprocal arrangements within the UMA, but if you're not, then you have to report your presence to the Bar Association of Benin. The same on limitation to national treatment with respect to Mode 4, which is entered there. Next slide. Next slide, okay. So you can see here, Côte d'Ivoire on Mode 4, limitation on market access, has even gone to detail of inputting that the length of stay for legal service providers is limited to a period of 6 months, having met all the other previous qualifications, and even if you're from UMA countries. Then Togo says free circulation for nationals of UMA, but they must elect a domestic colleague which is registered with the bar of that country. Mr. President, that's what you refer to in the bill. It has to be registered with the bar of that country. So it doesn't just stop at the bill. Our negotiators must make sure that they state this clearly, these limitations clearly, if that is what we agree to. So what is the task for bar associations? First of all, through conferences like this that is organized by BIC, ITILS. Next slide. We interact with lawyers in different countries to talk about what it means to trade in services under different agreements, whether it is multilateral, regional, or bilateral. So we gain knowledge on what it means, what are the issues involved. And then the next thing for BAS to do is to establish trade in legal services working groups. The Nigerian Bar Association has such a working group. Some other bar association also has, but those who don't have, we encourage them to establish and to engage with government agencies responsible for development of rules and trade negotiations. How will you engage if you do not understand trade law? It is in seminars and conferences like this that we talk about trade laws and how we can use that knowledge to influence what is being done to the profession at the trade negotiation level. BAS are encouraged to contribute to the formulation of policies and rulemaking, and we're encouraged to interface with the International Bar Issues Commission like this one, so that you can let us know the level of your involvement, the developments in each country. So yes, we task lawyers through the Nigerian Bar Association to be on the government's negotiating team for legal services. Sir, under Norton, they occasionally have stakeholders meetings and workshops. Right now, we do not have the NBA team that are working with Norton, Nigerian Office for Trade Negotiations. And it is not for Norton to pick and choose, because that is for the Nigerian bar to choose who represents them in Norton. Like President Paulo Soro did, a letter was written to Norton and to the minister that the NBA has to be part of it. And this is the name of the working group, AFCFTA working group in these negotiations. So each time they needed advice, they will write to the Nigerian Bar Association, and the Nigerian Bar Association will forward it to our working group, where myself and George and I think Aswe was there, and the former SBL chair as well. It was a small group of lawyers that are versed and experienced in trade law. So another thing is to engage in consultation with like-minded African countries for an African position if the negotiation is in a multilateral setting, multilateral organization, so that they don't split us like the European Partnership Agreement that have chosen to discuss, segment us and discuss with each country, where without your knowing, country A in West Africa may have said, yes, it's open, and all of you Europeans can come in to set up firm. Meanwhile, under ECOWAS, we have, and under AFCFTA, we have a free trade agreement with that country A in West Africa. So long as that country A has allowed foreign legal practitioners access to their country, the rule of most favored nation also requires that Nigeria permits whoever practices in that African country, West African country, to also have access to our market. So it's intricate. These are the things that we need to educate our government and our negotiators about, and it's one of the reasons that NBA is active in talking or participating in the BIC ITILS and in any discussion which will affect the legal practice in Nigeria. Like George said, we are not against, but we want to have a sizable size of the pie. Under our BIC ITILS, there's a resolution that we developed, and it was called the Resolution on Association, I think. Association, it was still on foreign practice, legal practitioners, but on association. It's a draft. I'm calling it a draft because IBA has not approved it. And it was stood down by our committees because there was a vocal, minority but vocal voice against it. That resolution simply said, if a foreign legal practitioner or firm wants to practice in a host country, it must be in association with local lawyers. Some minority voices in the committee said that that goes against freedom of the freedom that's guaranteed. You must not put a condition. If you want to open up your practice, you mustn't put any condition at all. You just allow the law firm to, foreign law firm to come in and establish. So it was stood down. And this is where we need to have a voice, a stronger voice, to encourage that draft come up again and be fine-tuned in a way that will provide for all the interests, both the importing and the exporting country interests. Thank you very much for your attention.
Thank you very much, Mrs. Mfon Osoro, Managing Partner Paul Osoro & Co., for that presentation. We'll go to our next presentation and panel discussion. This particular presentation and panel discussion focuses on the topic arbitration of international commercial disputes, how to keep international arbitration local. There'll be a panel session, but before we start the panel session, there'll be a panel session opening remarks by Stephen Richman, Chair of the IBA Bar Issues Commission. He'll be joining us virtually. Please, a round of applause for him as he joins us virtually. Thank you. IT, please project.
Thank you. And it's been a pleasure to be here. It's about 5 in the morning in the US. I've been on since about 4:15 and have greatly appreciated the speeches and presentations to date. I also want to thank Ian and Mikhail and our entire team for the ITILS committee. And on behalf of the Bar Issues Commission, of which I have the honor to chair, want to welcome you all to this session and also reemphasize the importance and priority of our efforts in Africa. Many of the speakers so far have talked about the importance of the local, and we feel that it is important to continue, whether virtually or in person as we're doing here, to continue to focus on issues of concern to the region. So very grateful to be here and look forward to the rest of the presentations.
Thank you very much, Steve Richman, for that opening remarks. Just wanted to confirm that you're done. Okay, I think it's done. Okay, thank you very much. So our panel session today, like I mentioned earlier, will be focusing on the topic arbitration of international commercial disputes, how to keep international arbitration local. To help us facilitate or to contribute to this discussion, we'll be having, the first person I'll be inviting up is Mrs. Chiazo Anishiri, Senior Advocate of Nigeria. She's a member of the ICC International Court of Arbitration, Paris, and member of the London Court of International Arbitration. Please, a round of applause as she comes up. Please keep clapping as she comes up. Our distinguished Senior Advocate. Thank you very much. The second person I'll be inviting to this panel discussion will be Mrs. Essien, Senior Advocate of Nigeria, Managing Partner, Principals Law Partnership. Please a round of applause as she comes up. I'll also be inviting Priscilla Ogwemo, I hope I got that correctly, Managing Partner, Kevin Martin Ogwemo Legal. She's here. I will also be inviting Yahya Isa Abdul Rashid, Associate Partner Diko and Mahmood, to come up to join us on this panel discussion. Steve Richman will be joining us virtually. And then to moderate this panel session will be Mr. Ladipo Shueton. A round of applause. Usher, please, I need this.
Good morning, distinguished colleagues. Welcome to this session on arbitration of international commercial disputes, how to keep international arbitration local. In many jurisdictions across, particularly across Africa, the tension between international best practices and local participation remains central. While parties often prefer international seats for perceived neutrality and efficiency, there's a growing recognition that sustainable arbitration ecosystems must be nurtured. Today's discussion will explore how we can strengthen local institutions, promote confidence in domestic arbitration laws, and ensure that international standards coexist with local ownership. The goal is to identify the challenges preventing international users from choosing local seats, highlight reforms and practices that make local arbitration credible and cost-effective, and encourage collaboration between local and international practitioners. Our panelists today bring diverse experience from practice, policy, and institutional perspectives, and I look forward to a rich exchange of ideas. Now, our MC has done a good job of introducing them, and we don't have a lot of time, so I hope we'll just go straight into the session. I would like to invite Mrs. Anishiri Essien to make her presentation. Respectfully, you have 10 minutes. Thank you.
Just 10 minutes.
Yes, 10, 10 minutes. I've seen her paper. It's very extensive, but Mrs. Rancho will speak to it. So that's.
Good morning, very distinguished ladies and gentlemen. I'd like to thank the organizers of this great event for inviting me. The topic, arbitration of international commercial disputes, keeping international arbitration local, I find very, very exciting. As we all know, the world has gone, the commercial disputes has gone global, and the normal question is that when international businesses clash, the first question that comes to mind is where to resolve their disputes. So where and how to resolve their disputes will be what will come to their minds. Now, the courts have been found to be not too efficient in resolving some of these disputes, and so international arbitration has been the go-to for dispute resolution in terms of commercial arbitration. So, commercial disputes. Now, where this happens, ordinarily you find that arbitrators or the council choose established traditional seats. And the reason is that because they are familiar with these traditional seats as opposed to regional centers or that we call local. I mean, being local doesn't mean that you're going to dispense with international best practices or the confidentiality and the issue of neutrality that is embedded in arbitration practices. No, it's, we're looking at practical strategy for businesses. That's what we mean by being local. Businesses look at what is strategic for it to succeed and to survive in terms of resolving international disputes that arise between these foreign parties. Okay, thank you. Right, so the challenge is the explosion of global commerce, which leads to more cross-border disputes. Fawn said earlier in her presentation the problem with the AFCTFA. We're happy to see that the WTO rules are adopted by the AFCTFA, and such, you all know, will obviously lead to cross-border disputes going forward. So how do we resolve this? Do we have to go to the established seats like London, Paris, or New York to resolving these disputes as opposed to looking locally, looking at the regional centers or home states for resolving the disputes that arise due to these cross-border clashes? So the limitation of courts are often slow and costly, and jurisdictional issues are limited. And the default solution is what has led to international arbitration becoming the go-to for solution, like I said. Now the question that arises is, will the bigger solution or the bigger venue be the answer to the bigger issues? Would it be the answer to bigger issues? Bigger venue be the answer to bigger issues? No. But I think you may want to differ after my presentation on this. And the problem is I don't get to see the PowerPoint presentation because it's right behind me, so I'm using the... It's not showing. Oh, sad. So I'm using what the moderator is giving to me. So there are strategic advantages of local seats. No, I think I'd rather use my paper, yeah. Hoping that they'll show the PowerPoint for the audience. Right, so there are also the concept of safe seats. we're talking about safe seats. So what do we mean by safe seats? That is seats that the parties find to be more trusted in terms of enforceability of awards, in terms of neutrality, and in terms of party autonomy. So another issue is the jurisprudence, what's the policy in those states. Now, he's happy to note that most of the countries, the practice that are pro-arbitration friendly have actually imbibed the UNCITRAL model law on international arbitration as amended in 2006. Now, I think about 120 countries have actually imbibed the UNCITRAL model law on international arbitration. Now, if we have over 120 countries adopting this UNCITRAL model law, so you can imagine that there is a harmonization of laws on international arbitration as it relates to business disputes, and that's very key. Coming back home to Nigeria, very recent, not recent really, but our current law on arbitration, which is Arbitration Mediation Act of 2024, is also pro-arbitration friendly. It's predominantly based on UNCITRAL model law on international arbitration. Most of the conventions, most of the sections or provisions in AMA 2024 are basically in tandem with the UNCITRAL model law. So now we want to consider the legal framework and why the location matters. There's always the question on whether the critical distinction between the seat and the venue, the seat of arbitration and the venue of the arbitration. Now, the seat of the arbitration is the legal framework. It actually depicts the legal framework of the arbitration. It talks about the laws that will be applicable to the arbitration process, whilst the venue is where the parties meet to conduct in the arbitration process. So these are, quite distinct. So it's important, therefore, that when you choose your seat of arbitration, you ensure that the laws of that seat, of that country, are actually pro-arbitration, and they're in tandem with the UNCITRAL model law on international arbitration. The venue, of course, is chosen for sake of convenience and to limit cost. You can imagine having an arbitration in London, and you have to move your team of lawyers, expert lawyers, to London. You choose a venue in central London, and the sessions are probably going to be more than a day. The cost of the hotel accommodation, the cost of the administrator, and other costs of the arbitration will be so humongous, and that makes arbitration very expensive. So the venue sometimes is considered to be such that will make it easier for the witnesses to easily assemble, and it's convenient for the parties to have the arbitration administered at lesser cost, as opposed to taking the whole team to established centers like Paris, London, or even New York. So what choosing a seat really means, when parties select an arbitral seat, they're essentially choosing which arbitration law will govern the proceedings, and they're choosing which courts can support or intervene in their arbitration. And some seats have a lot of interferences from their courts, and this is not really advisable. Some courts give injunctions, and this is totally not pro-arbitration. So choosing seats also involve what standard will apply if someone tries to challenge that award. So, enforceability of awards is also very critical to choosing your seat. Again, is how much judicial interference they'll face. That has been taken care of in Nigeria. Before the enactment of the AMA 2024, we had quite a number of judicial interferences in our arbitral processes. But thank goodness now that actually has ebbed drastically. So choosing seat, you need to consider these factors to ensuring that the seat is in compliance with the factors as I've earlier enumerated. And strategic advantages of local seat selection. Now, the local seat selection enables you to not only save cost, but also to ensure that you will improve domestic participation, where we improve lawyers, national lawyers, I'm trying to also avoid using local, lawyers who practice in their particular state to expound their knowledge in that particular subject. The courts also get to know more about that subject and increase their knowledge. We keep record of such proceedings. This actually helps to improve arbitral processes in that state. So these are some of the strategic advantages of local seat selection. It also helps with, I said that judicial familiarity and reduction of complexity in terms of time zones. We know that sometimes if you have to choose a seat in Singapore, you can imagine the time zone. So if you choose a seat locally, it helps to minimize the complexity of the time zones and the travel logistics, just as the example I gave earlier on. Now, cost management is also an advantage, and cultural alignment is another advantage to choosing local seats as opposed to the established venues. Cultural alignment, for example, there are some seats that have place special attendance to the cultural values of the parties. And where this is not known by foreign arbitrators or counsel, you can imagine it could be some distasteful to certain parties and may eventually affect the process of arbitration. So the development of arbitral capacity is another reason why local seat should be preferred. It helps to develop arbitral capacity. Now, we also have to consider the challenges to localizing international arbitration. Some schools of thought will say there's a conflict. How do you localize an international arbitration? How can an international subject be made local? Now, by localizing international arbitration, we do not mean that, you jettison international best practices or the international rules and laws that relate to arbitration, particularly as enshrined in the UNCITRAL model law. No. The fact is that the challenges to localize international arbitration, sometimes one of which is that the council, these agreements are majorly prepared by lawyers. And some lawyers are familiar with established laws, established centers. So when they prepare the clause on the arbitration, when they introduce the arbitration clause in the agreement or contract, it's obvious that these lawyers would put in a seat that they are familiar with because they've tried it and they find it to be good for their own practice. So this is one of the challenges we have, familiarity of counsel to the established seats. Another is the problem of the risk of bias of the local courts. Some of the parties may feel threatened or feel that there will be some bias if they don't choose a neutral seat. They feel that the court may favor the party that is from that particular country. And so that risk of bias is another challenge for choosing a local seat. So that's another very important challenge. Again is the, I have about a minute more. It's a very interesting topic. Again is the fact of the unfamiliar terrain. Some parties are not familiar with that particular seat. So the not being familiar with that terrain could also be a challenge to choosing a local seat to established seat. Now the fact of technology has come in as a game changer. We all know that since the COVID pandemic, we've had an improvement in technology. We now have hybrid sessions. We have virtual proceedings. And this actually has helped to improve arbitration processes. So ensuring that we have greater knowledge in AI or blockchain technology also play a very important role here. The introduction of the digital technology, the AI and blockchain should also be what everyone who's aspiring to be an arbitrator or counsel should endeavor to know, because technology has come in as a game changer. I think I'll just wrap it up by saying that I've talked about the cost of international arbitration, the practical cost reduction strategies, and the value of optimization rather than cost minimization. So I'll just quickly go to my conclusion, which will actually talk more about the future of localized international arbitration. The future, indeed, is technological opportunities, and the sustainability and environmental considerations should also come into play in deciding the future of localizing international arbitration. Also, the regulatory evolution, I said that it's also very important to have harmonized laws in all these states. And so by way of conclusion, because I see my moderator is prompting me that 1 minute is over, I'll just quickly read what I have here, which says it all, and summarizes the paper, that the international arbitration world is changing rapidly, and smart businesses are adapting their approaches to take advantage of new opportunities, indeed. So keeping international arbitration local isn't about abandoning international standards or accepting lower quality dispute resolution, not at all. It's about recognizing that the best solution for any particular dispute might not be the most obvious or traditional one. When I say traditional one, I mean the established London, Paris, established centers. So the role of regional arbitration centers, combined with technology advances that reduce the importance of physical location, has created genuine alternatives to traditional international arbitration centers. And let me pause here to quickly say that it's gratifying to note that in Nigeria, our current marine and blue economy policy, which is akin to shipping policy, actually makes provision for resolving disputes by arbitration. And it made reference to the creation of arbitration regional centers. Of course, the Maritime Arbitration Association of Nigeria is considering collaborating with the Nigerian Maritime Law Association towards ensuring that a regional center is established very soon here in Lagos. The policy talks about it going through the auspices of the Federal Ministry of Justice, and I think the Honorable Attorney General's office is also involved in this. So we'll be paying him a courtesy visit to ensuring that this regional center is established fast enough for the purpose of localizing international arbitration, which is the topic for today. And I'll say that this shift towards localization reflects broader changes in international commerce. As businesses become truly global, the old assumption that international necessarily means London, Paris, or New York no longer holds. Now, companies are discovering that the best international arbitration might actually be closer to home. Thank you.
Thank you very much. I'm really sorry that I made you speed through your session. Now I'm going to do something that moderators are not supposed to do. Moderators are supposed to be impartial and give a balanced, but Mrs. Essien has to leave. She has a flight to catch, so I'm just going to start with her and ask her a couple of questions, allow her to leave, and then we'll have well, not all the time in the world, but a little more time. Mrs. Essien, are you ready? You've listened to Silk. So your first question, you have 2 minutes. I know you won't go past 2 minutes. Looking at Nigerian jurisprudence and the passing of the Arbitration and Mediation Act 2023, would you say that local courts in our jurisdiction, or not local, Nigerian courts, are now sufficiently arbitration friendly? And where do you see the gaps? 2 minutes.
Okay, thank you very much. I'd like to thank the organizers. I'd like to thank Mr. President Afamosigwe SAN, my Uncle George, my sister Mfon, and Madam Chair for inviting me. I must preface this with an apology. I have a 2 o'clock flight. If George gave me his PJ or the president gave me his president private jet, I would not be rushing to catch a commercial flight. So please pardon me. I'm actually supposed to be speaking at the NBA in Port Harcourt at 3 p.m. So if they delay theirs like we delayed ours, hopefully I'll catch up with it. So please, my apologies. So without further ado, yes, I think that with the passing of the AMA, there's been a significant difference. But I must issue a word of caution. If you go to UBA and Trident, and we all know that case because we've all been bothered by the Supreme Court decision in UBA and Trident, I'm not so sure anything has significantly changed. Because one of the things that was interpreted, one of the expressions that were interpreted, was the expression, before the submission of your first statement in the dispute. That was what was interpreted pursuant to Section 4 of the former ACA. That sentence, that expression, still exists in Section 5. It's important for us to bear that in mind because at the end of the day, while interpreting Sections 4 and 5, and then in 5 you had pleadings, and so the Supreme Court said, well, so in Section 5 you have pleadings, in Section 4 you have first statement on the dispute. And under Nigerian law, there is nothing like first statement on the dispute. We have first statement on the dispute in Section 5. So it seems to me as if we may still have some landmines to look out for in terms of whether the Supreme Court has interpreted that. But coming back to the key things, yes, courts are sufficiently more arbitration friendly. And you can see that there's been an attempt to, of course, to merge Sections 4 and 5, which had presented a challenge in the past, which is part of what was interpreted in UBA and Trident, to say that now it's mandatory. so long as the agreement is not void, inoperative, or incapable of being performed. Also, there is more support for interim measures, as the Act explicitly grants courts the power to issue interim measures of protection. And most significantly, we have specialized court rules in the AMA, the third schedule, which introduces those rules which are designed to modify ordinary litigation procedures and eliminate bureaucratic hurdles, thereby speeding up arbitration-related court applications and appeals. And of course, a very important change is the fact that the enforcement, now you have less interference, because now it's strictly limited to specific issues. So error of the face of law, which caused so much problems from the interpretation in Taylor Woodrow, is now out. So clearly it's made a huge difference to our jurisprudence, to our jurisprudence. But then, do we still have gaps? Absolutely. And I think one of them is, when you come to case law or interpretation of current laws, you can always go back to what's been interpreted before. And so that's why I flagged the issue of UBA and tried. It may still be a problem for us. And if we find ourselves in the situation, and I am in that situation in a particular case, I've asked the Supreme Court to depart from that decision. And so I'm ready to get all the bullets that will be thrown at me when I'm going to be putting forward those arguments, but I think it's worth it. So one of the gaps that judicial consistency in practice, not just consistency, awareness, because you still have some judges who still feel that arbitration encroaches on their turf. So we still have those issues. So while the law provides a clear framework, proactive and consistent application of the AMA, we will still have different judges interpreting them at the trial court levels. And so, yes. Sorry, I hadn't even started, but go ahead.
Okay. You've taken 4 minutes. And because you have a flight.
I'm sorry.
So many other panelists. I'll ask you one last question.
Yes.
So despite the New York Convention, and you've touched on it just momentarily now, providing a uniform enforcement regime, parties still express anxiety over enforcing awards from non-traditional seats. Is this concern justified in practice?
I think in practice...
2 minutes.
No, I don't worry. I won't even take 2 minutes, because it actually straddles what I'd said earlier on, which is the issue of judicial interpretations, right? So this may vary from jurisdiction to jurisdiction. And the convention's grounds for refusing enforcement are actually discretionary, leaving room for interpretation. What is public policy here may be different from public policy somewhere else. And so you may find that the interpretation of some of these exceptions may lead to, broader issues. And of course, there's also the risk of annulment at the seat. An award or seat can be set aside or suspended by a court on the ground for refusal of enforcement, which we know is, it's always one or the other. And of course, you still have procedural hurdles and inefficiencies, sovereign immunity, and indeed the issue of forum shopping, because ultimately when you're trying to enforce, in a convention state, it's because you think that person has assets there. So you are actually forum shopping. And so I think that may be one of the issues that we may be faced with. I took 45 seconds.
Fantastic. Can we put a round of, can we give Mrs. SNSN a round of applause? Thank you very much.
Thank you very much, and please, may I file a formal application for leave to disappear?
Thank you so much. Now, it's not as if we have unlimited time, but I'd just like to quickly say that Mrs. Chiazo Anishere SCN was only just recently elected as chairperson of the ICC Africa Arbitration and AGR 10th Anniversary Conference Planning Committee. So next year we're having a conference here. Please put your hands together for her. And she's also now, again, very recently, the president of the Maritime Arbitrators Association of Nigeria. Congratulations to her. Can you have a round of applause? Yes, that was just a few days ago. Yes? Okay. So, I'll start No, I've already come this way. You moved over here. So let me start with Mrs. Ogwemo. Now, I'll continue with you. Beyond legislative reform, what are the top 3 low-cost, high-impact operational changes a regional center can implement today to immediately enhance its appeal to foreign users? You have 2 minutes.
Okay, thank you very much. If you say 3, I'll bullet point them. I would say we need to look at the area of building capacity. And when I say building capacity, I'm looking at training, I'm looking at the quality of, say, the administrative personnel in regional centers. We need to have them like, top-notch administrators because they provide quite a lot and they play a key role in just getting us there, in changing perception. I read a part of Auntie Jean's presentation, and she talked a lot about perception. If we want to make Nigeria a center, a center of reckon, we need to begin to work towards changing perceptions. Everything is about perception. Having talked about capacity, then I'll talk about strategic relationship, building strategic partnerships with similar regional centers all over the world. I know the institute I belong to, which is the NICAB, that is the Nigerian Chartered Institute of Arbitrators. Recently, we're in partnership with CITAC. That's the China International Economic and Arbitration Commission. We have entered into an MOU with them. And I know that we are also, building similar relationships with other centers all over the world. What does that do? Immediately it begins to shift. It begins to shift the perception we have about Nigeria. That, okay, if there's this, relationship, then we know it's a safe place to come to. The third point I'd like to make will be advocacy. Someone mentioned, about a center now deliberately imputing arbitration clauses that says, in the event of a dispute, you go to XYZ center. So if you don't, because arbitration is primarily party-driven. So the parties craft their agreement, they design, when we talk about party autonomy. So it means at that point of even crafting or drafting your arbitration clauses, you have to be intentional. And the role the regional centers can play is to strategically engage these institutions. And I will say we generally will start with the SOEs, the state-owned enterprises. Because at the point of entering into a contract, you have the agency. They have the power to insist at that point that in the event of a dispute, come to Nigeria, go to the regional center where, arbitration will be conducted, proceedings will be conducted. You said 2 minutes, I agree. And that's why I quickly did the bullet point. Hopefully I'll have a chance to talk more about, the advantages of what the key roles that these centers can play.
Okay.
Yeah,
so you had those 3 points. One, training.
Training.
Second one, partnerships.
Yes.
And then the third one,
advocacy.
Thank you. Okay, so Mr. Richard, we haven't forgotten you. We'll go over to New York now. I hope our technical people, we haven't lost Mr. Richard. So I have a question for you. Following from what Mrs. Ogwemo has said, and given your expertise with AI, hybrid and virtual hearings have reduced the need for physical proximity. Now, does technology fundamentally level the playing field between traditional arbitration hubs? Can you hear me? Okay. Can you hear me? Yes, okay.
Yes.
So I said hybrid and virtual hearings have reduced the need for physical proximity. Does technology fundamentally level the playing field between traditional arbitration hubs and regional centers? Or are there still inherent advantages that global centers retain despite technological parity? You also have 2 minutes.
Thank you. Virtual has become in arbitrations, certainly in the United States, and artificial intelligence is a part of that. It's important that in developing the credibility and competence of a regional arbitration center or the regime that governs the arbitration, that the staff is also competently trained in technology and also AI. AI is used in a multiple variety of ways, obviously, in terms of dealing with discovery, in terms of running the actual proceeding, taking notes and so forth. And it's also important from the ethical standpoint that the practitioners in dealing with AI and arbitration in particular understand the ethics rules. There have been several movements to make sure that ethics rules dealing with AI have kept pace with the actual nature of the technology. The International Bar Association has focused on that, and I'm happy to share the report with everyone here. But I also want to make clear that there are other aspects of how a regional center will maintain and develop its credibility. One is to have certain robust standards for arbitrators. And again, that would include a knowledge of the technology and its limitations. Another is continuing CLE, which would include technological competence for arbitrators and, frankly, for advocates who arbitrate as well. I think it's important to emphasize what's already been said about competence and credibility. Local does have very many advantages, but the idea of artificial intelligence in arbitration not only helps the advocates in terms of level the playing field and let them leverage their resources against larger firms, but also helps the arbitrator keep pace with the case and avoid excess costs with regard to, and I've seen some arbitrators do this, engage other assistants or arbitrators. So AI can definitely, in my view, and will become more part of a more efficient and expeditious arbitration proceeding, which does play to the benefit of using more local sources instead of going to the much more expensive and traditional centers of arbitration. 2 minutes and 30 seconds, I think.
Very good. Thank you. Okay, Mr. Yaya, we come to you now. Also about capacity building, learning from what Mrs. Okwemo said. Now, how can local practitioners, arbitrators, and institutions build the skills and reputation needed to, and we've been talking about this all day. You listen to Mrs. Ufon's presentation, and in fact what the MBA president also said. How can we build the skills and reputation needed to compete internationally?
Thank you very much. I want to start by thanking the organizers for inviting me. So I'll go straight to respond to the question. I think local practitioners could build capacity by this type of engagements. We've seen that this is an engagement to attempt to ensure collaboration and also to ensure that there is internationalization of local competences. So again, there are a lot of trainings, capacity building trainings as well is key to improving capacity for local practitioners, as well as partnering with international law firms, because we know that these law firms have been there, they have been into arbitration, and they are the big laws. So there are certain types of disputes that you cannot risk appointing a local counsel, not because they don't have the capacity, but because there are some nuances which most of these big laws are the ones that are familiar with the terrain, But partnering with them, working together with them, will be able to help you upskill and have the capacity as well. And as well as there are also initiatives ongoing which help local practitioners to build to upskill capacity, not only to the practitioners, but as well as the users and the centers themselves. Because some of these things you won't be able to improve unless there is constant use, unless you're being put into use. Thank you very much.
Please clap for it. It was 2 minutes exactly. 2 minutes exactly. Thank you so much. I'm going to come back to you. But now, because we didn't get a chance for you to explore all the nuances in your paper, I want to ask you this question, Mrs. Anishere SAN. You mentioned, because I've read it, the cultural imperative. Now, in your experience, what are the most decisive... I'm sorry, could we have another microphone instead of just passing this one? This one is not... Aha, okay. What are the most decisive practical or psychological factors that keep parties tied to traditional seats? And how can regional centers overcome this inertia? Now, you know you have talked about the cultural imperative. So I want you to relate those two.
If you could take the question again, the keep...
Right. Okay, let's forget the cultural part. Just let's focus on this. So, in your experience, what are the most decisive practical or psychological factors that keep parties tied to safe seats? What can regional centers do to overcome this inertia?
Safe seats, traditional seats. I think it's familiarity. You know, the users, counsel or arbitrators are familiar with the traditional seats, and so they tend to keep it. Like I said earlier, lawyers are those who actually draft these agreements, who introduce the clauses into the agreements of international arbitration on other subjects, and also for the lawyers. For example, lawyers counsel based in Nigeria to have the opportunity of being versed on those subjects as relate to the international disputes. So I think the first and foremost is to ensure that lawyers introduce clauses that will enable parties refer to regional centers when there's a dispute.
Thank you very much. Thank you very much. And you were well within time. Okay, Mr. Gwen, we're going to delve a little more deeply into what you had talked about before. So, you talked about training, you talked about... I want you to go into a little more detail, but you still have 2 minutes, you understand? When you have complex arbitrations that require, really effective case management, scheduling, people are all over the place and stuff. What are the things that the local institutions, what can they do? I want you to talk a little bit more about that. We're focusing now on a little bit of what you had said before. What can they do to demonstrate reliability? So you have an international arbitration. It's hundreds of millions of dollars. There are several witnesses from all over the world and everything. And you are suggesting that the arbitration be held locally. What are these regional centers going to do to persuade the parties that, yes, it can be done effectively? Yeah.
So the first thing I'll say will be facilities. I'll first of all be concerned about the kind of facility that is available at these regional centers. The second thing will be the demonstration of skills. And that's why I had talked about training of administrative staff, training of arbitrators themselves. Because at the end of the day, yes, Uncle George talked about having a leg in. If you are not in, you can't even begin to talk about having a competitive edge or having a good share, of what is at stake. However, ultimately, the skills will be tested. So I've talked about skills, I've talked about facilities, and then I will also be concerned about the capacity, the ability of the staff to provide the support that will be needed. And that's when you talk about case management And this case management is acquired over time. And by seriously investing, in that capital. Because if you're not able to manage cases, you talk about complex arbitration cases, and a lot of these international disputes are quite complex. So you don't just come and you think it's business as usual. We have to demonstrate. But I also like to address, the point at which, because this is when you have the job in. In other words, there's an arbitration, and then we have an opportunity to demonstrate these skills. But how about even getting them convinced that indeed we are positioned, we are able and capable of providing these facilities and this support? And that's where I talk about strategic networking. We've got to sell our skills. We've got to make the international community know that, look, we are ready. We have the facilities. How do we do that? We can begin to deliberately attract conferences, for instance, where you invite these international players. I've talked about strategic partnership, MOUs, and all of that. But yes, importantly, it is when they come, are we able? I think we are. In all the centers that I'm aware of, particularly the regional center, the CAB, the NICAB, LCA, they all have the skills. Do we need to invest more in facilities? Yes, because now we've talked about AI, virtual hearing is a big issue, and we have to show that, yes, we are ready, we have the facilities, we have the gadgets, we have the tools, we have the equipment. Thank you.
Thank you very much. We're going to coming back to you, Mr. Richman. I hope you can hear me.
Yes.
Okay. So looking ahead, a decade, 15 years, do you foresee regional arbitration centers meaningfully competing or even overtaking traditional hubs? And what factors specifically do you think will most influence this trajectory? Would it be technology, sustainability pressures, or regulatory innovation?
The answer to yeah, and that was just 3 seconds. So I'll expand to the rest of it now. I'd really just make a few points. A lot of what's been said is overlapping to what others are saying. In the US, though, I would point out it's not just one arbitration regime. You've got several. You've got AAA, American Arbitration Association, where I'm actually on the commercial panel as well as consumer artificial intelligence with technology, with the ability of the entity, the regime to handle technology. Then it's less of a global, or rather, it's less of a local issue. Do I go here or there? And I understand the issue of situs of the arbitration, but it's also a question of convenience. And as someone else mentioned, the choice of arbitration and the choice of location in many cases is client driven. So I'm optimistic that the regional centers will stop being called regional centers and they will be seen as on a parity with other centers. The local issues, as we've discussed, have importance, but it's really going to be the embracing of technology and the ability to handle on a broader level cross-border arbitrations that take advantage of virtual as well as in person.
For you, then I'll take a couple of questions if we have any from the audience, and then we'll end the session. And this is, I think, a little bit important. So some jurisdictions require state-related disputes to be arbitrated locally as a way of building arbitral capacity. Do you see this as an efficient strategy, or does it risk undermining confidence by appearing protectionist and limiting party autonomy?
Thank you. So I'd like to start by saying that, well, states have legitimate right to promote use of arbitrating disputes locally. However, it doesn't extend to imposing those seats because, like the lead presenter said, the point has been underscored that arbitration is anchored on the basis of neutrality and party autonomy. So parties have the right to decide which seat they want. So it is important for states to understand that there are measures states can take, not necessarily by imposing that this dispute should be. Others argued that no, you cannot do that because of party neutrality. So it is for you to encourage, and there are a lot of policies and a lot of provision in the policy that encourages and that supports is choosing Nigeria as a local seat. Thank you very much.
Thank you very much. Okay, so that it doesn't just appear that we're just talking at the audience, if we have any questions, we only have time for.
Most of the time, it's not the agreement or the award that is faulty, but if the lawyers advise the party that this is something that you could challenge based on whatever law that he thinks so, then the party will go along with that. And the court are there. If the matter does not get to court, the court will not interfere. And the other strategy that is being used, why court is preferred in some instances, is the issue of delay. If a party knows that it's going to be slammed with 10 minutes.
About localization and having that preference for a seat where we reside locally. But what do we do when we're confronted with African parties who maybe have a distrust for each other's seats? I'm actually facing such a situation here where I'm recommending...
I must also say here that presently ICC is being, training, having conferences on how we can encourage seats in Africa. And then that's why ICC has established an academy for arbitration, international arbitration in Africa, in Kenya, and some courses are taken in Ghana, in Cote d'Ivoire, in about 3 or 4 African countries. So there's that spread. That's ICC's wisdom in ensuring that we encourage seats in Africa. And even the courts, ICC courts, however, what we do at the courts is that we scrutinize awards that are being drafted by arbitrators. The scrutiny we do in some African states. So we do not just sit in Paris to scrutinize, and of course, we also do the scrutiny virtually. So ICC is on top of its game in that regard.
Okay, thank you very much, Leonard Silk. And I think with that, we're going to bring the session to an end. I would like to thank my panelists, Mrs. Ogwemo, Mr. Yaya, and Mrs. Anisheri SAN. Thank you very much. I would also like to thank Mrs. Mrs. SAN. I wish her safe travels. I'd like to thank the chairperson of the SPL for the opportunity to moderate this. Also like to thank all of you for participating. The session. Oh yes, of course. I'm so sorry, Mr. Richman. Thank you so much. He's been awake since 4 a.m. Perhaps earlier than 4 a.m. for him to participate. Thank you so much for staying with us, for waking up so early and staying with us until the end of this session. Your insights have been invaluable. So to recap, essentially we have to build capacity, we have to invest in infrastructure, in training, and also the training of our local arbitrators to overcome the fear about using local seats. It's going to take some time, but we have very, very many capable people here who will take the advice that you've given back, and hopefully next time we're talking about this, we'll be talking about competition between regional seats and so-called safe seats. Thank you very much and have a lovely afternoon.
The panelists, please hold on for a group photograph.
Okay, so he can share. Okay. So that he can show.
just to formally announce that tea break is over, so we expect everyone to please come back into the hall. You can come in with your tea and your food. Also, we would like to apologize for the inconvenience you're all experiencing due to the air conditioning issue. The facility management is working on it to restore coolness very shortly. Please accept our sincerest apologies. For those who are just joining us now, you're welcome to the International Bar Association Bar Issues Commission on International Trade in Legal Services Cross-Border Conference. We've had a couple of presentations, panel sessions, and a keynote speech given earlier today. We're just coming back for our tea break. I'm about to proceed with the event. Ushers, please can you take position and ensure everyone comes back into the hall. Okay, without any further ado, I would like to announce the next session we're having. It's a presentation on the topic Legal Gatekeepers of Global Finance, How Jurisdictional Counsel Shape Cross-Border Capital Raising. We would first have a presentation by Mrs. Yinka Edu, a partner to Do Udoma and Bella Osage, and past chair of the Capital Market Solicitors Association. When she finishes our presentation, we'll then have a fireside chat with her and Mr. Abimbola Babalola, Head Trading and Products at NGX. So I'd like to call forward Mrs. Yinka Edu for a presentation on Legal Gatekeepers of Global Finance, How Jurisdictional Counsel Shape Cross-Border Capital Raising. Please a round of applause as she comes up to give her presentation. Please keep clapping as she comes up. Let's encourage her. Let's encourage her. Please keep clapping.
Good afternoon, everyone. Oh, I thought there'd be more energy. Good afternoon, everyone. Okay. So I know that this is going to be one of the best sessions today. And I say that partly because you're not going to be just listening to lawyers. There's going to be, Mr. Babalola is here from the stock exchange, and we're going to have a fireside chat. But before that, you are going to have to listen to a lawyer. So I'm going to give just a little bit of background on the topic. I have some slides. I'm hoping they will come up. No slides? Oh, that's a shame. Because then I need my glasses because I can't read my notes here. No slides? Okay, anyway, I'll get started. So essentially, we're looking at, I sent them to you. Sorry, 1 second. Let me see if I can get the slides. Was when I heard this topic, I thought legal gatekeepers for global finance, shaping cross-border capital raising. What I thought would be actually quite useful was just to look a little bit at the history of cross-border capital raising, what we've seen in the past, how it has developed, if you like. So the very first thing I could see was the UBA GDR. A GDR is a program. I realized when I sat at the back earlier, when a few technical things were being said, one of my colleagues there said, only the litigators can understand this. So I also have to make sure that you understand what I say. So the GDR, UBA is the bank, they set up a GDR program. A GDR program is a program whereby on a cross-border basis, they're able to sell their equity, but they're not selling their shares directly, so they're not listed on another exchange. It's an instrument, like a certificate, that represents shares. And that was one of the very first ways in which we had a cross-border transaction, and that was back in 1998. And it was on the New York Stock Exchange. After that, since then, we saw ETI. Now, I think the ETI example is a really good one because it is West African. So ETI is listed on the Nigerian Stock Exchange, the Ghanaian Stock Exchange, and the Stock Exchange in Côte d'Ivoire. We have very few cross-border transactions across West Africa, so it's a really good example. Shortly after that, we had some other GDRs. A lot of banks have issued GDRs now. It was quite a popular way to create, I guess, international visibility, also to increase the pool of funds and investors and so on. Then we went to the Eurobond. Now, the Eurobond system, so GDRs, as I've mentioned, is equity. ETI is also equities. They're shares that can be bought on those exchanges. We then moved on to Eurobonds. Apparently, way back before my time, the Eurobonds we'd had a Eurobond market, but it had failed. And so there was a concerted effort by government to build up a new Eurobond market. There was a big study, institutions had to be put in place, etc. But then we had a Eurobond market. Eurobonds are debt instruments. So they're basically debt instruments, certificates that represent a debt obligation. We have now had quite a few Eurobond issuances. Federal government issues on a regular basis. Federal government has to issue actually on a regular basis as well because the way that those bonds work is that people are priced off the sovereign. So if you're a Nigerian issuer, your price is taken with reference to the sovereign's price. So if the sovereign is not issuing, it's very difficult for a corporate issuer to issue. But we have EcoBank, First Bank, so many different banks have also issued Eurobonds and do so on a regular basis. Then we have the dual listings. So we have Seplat, who is listed on the Nigerian Stock Exchange and listed on the London Stock Exchange. We have Oando, which is dual listed on the Nigerian Stock Exchange and the South African Stock Exchange. We have Airtel, which is also London and Nigeria, and we have GTB, which is very recent in 2025, which also had their dual listing on the London Stock Exchange. I think that has also sort of increased excitement around that area. The one example, sort of the other way that I have of a foreign issuer listing in Nigeria is the ABSA New Gold ETI. An ETI is an exchange-traded fund. It's an instrument that represents underlying assets. So the ETI instrument represents gold. So it represents gold, and it's listed on the Nigerian Stock Exchange. I think that the other thing I see also is on a private placement type of basis, you see funds that want to sell into Nigeria and want to know what they can do outside, are they allowed to do it on a private placement basis? Can they only respond to reverse solicitation, that kind of thing. So I would say in relation to cross-border capital raising, that's kind of the big outline. The reasons why I think I want to make a slight, I want to talk about the fact that the bond instruments, the debt instruments are slightly different from equity. And I say that because a bond instrument is a debt. It can be that I will pay you, I don't know, I'll pay you back in 5 years at an interest rate of X amount. versus I'll pay somebody else back in 20 years, a different interest rate. What all of that essentially means is that each Eurobond is different. It's not the same as any other one. Those instruments are all different. That's very different from equity. Equity, everybody owns equity in the same institution. What applies to you, whether you're a Nigerian investor, or you, whether you're a UK investor, is the same thing. It's equity in that entity. Whereas a Eurobond, for example, that's targeted at UK, foreign investors, can be very specific to those foreign investors. It can be in foreign exchange. The interest rates can be, is set up in a particular way. And so when looking at those types of transactions and putting them together, it's a little bit different. The involvement of the local regulator, if you like, is slightly different. They're involved anyway because the issuer is a Nigerian issuer. But the level of scrutiny is different whether it's an equity instrument, because it has to apply also to Nigerian investors as it does to the foreign investors. Slightly different from the way they look at a Eurobond issuance, for example, where you still need their approval, but they will defer to some extent to the rules of that foreign jurisdiction, because that's where you're issuing, and those are the most likely investors. We also have I have a couple of slides. Hopefully the slides will come up in a few minutes. But as you probably know, the US is very extraterritorial in relation to their regulation of securities. So if anybody issues securities anywhere in the world, and a US investor can get to see it, then you have to comply with US rules. So it's very restrictive. So when we're usually issuing, particularly when you're issuing outside of Nigeria, Eurobonds, etc., there are certain rules that apply. Either Rule 144A or Reg S. Reg S basically says that this is a okay, so these are my examples. Just a minute, so people can have a quick look before we move on to the next slide. I think we're on the next slide now. But these are some of the examples that I gave. Next slide, please. I also mentioned why cross-border capital. To scale and for liquidity, you're looking at a market that may have more, you're looking at more money, basically. If you're looking at your market and another. Economic resilience, obviously, single market, you can be prone to shocks that may be in a particular market. If you are looking at always raising debt in Nigeria, for example, if there's certain things that are affecting people's ability to invest, then obviously that can impact you. Also, global validation. We've seen how much people sort of recognize. I saw all the fuss around the GT listing. So people recognizing that this institution has met a standard that is an international standard, international governance standard. That's why they're able to issue there. Next slide, please. So in terms of the Nigerian regulations, the key regulations that we would look at. So in working on this type of transaction, clearly, as I've mentioned, you're looking at a Nigerian issuer, for example, and a foreign jurisdiction. And so you definitely need a lot of collaboration between Nigerian lawyers and foreign lawyers. In relation to this, you need to make sure that you're complying with both sets of rules. So we are looking at the Investment and Securities Act in Nigeria, the CAMA, which is our Companies Act. Foreign exchange regulations are, as we know, part and parcel of our laws. In a lot of jurisdictions, you don't have those restrictions. So those are something that are very important as a Nigerian lawyer looking at this type of transaction. NGX and SEC rules also. Next slide. Okay, I mentioned the Reg S. So that's the safe harbor rule. So basically, it allows an issuer to get an exemption. It's effectively an exemption from the US. So essentially, you're saying that you are not looking at US investors. US investors are not allowed to invest. Rule 144A allows qualified institutional investors to invest. And so that's a slightly higher set of requirements in relation to that. Often we're looking at the UK listing rules, for example, the CEPLAT and GT. And then also we're looking at anti-bribery, so global compliance. We're looking at general compliance, governance. Next slide, please. Okay. So these are some of the key, like, big issues that you would be looking at in relation to that. Governance and controls. Obviously, there's governance requirements. Nigerian governance code is actually pretty good and has really moved. The FRC rules have really moved along with international standards, so lots of the issues are now being taken care of. Maybe not so much when some of the earlier dual listings, but now, you know, you need to have your independence, you need to have more independent directors than non-independents and so on. The financial reporting also, if you're going to be in another market, it needs to be sure that it is reported in a way that will be understood. Documentation. Prospectus, drafting, DD, all of that is also very important, and the lawyers play a big part in that. Coordination between regulators. So you will need an approval, for example, with the dual listing, you will need an approval from the UK regulator as well as the Nigerian regulator. And sometimes that is you have to look at timing, you know, who's going to go first. You know how it can be. The regulator can be, yes, I'll come back. Have you got their approval before you get mine? And vice versa. So it's quite it's something that you have to negotiate quite carefully. Also about timing. Do you put one in whilst the other one is still reviewing and so on? So that's a whole process. But it's certainly very much something that the lawyers are very much involved in. Stakeholder management. Again, there are quite a lot of parties that are involved. I'm loving that now we're seeing a lot of Nigerian financial advisors also involved, even with the Eurobond and the international listings. Earlier on, it was very much, you know, if you saw Nigerian advisors, it's because they were subsidiaries of foreign financial institutions, so you may see a Stanbic or a Standard Chartered or a Citi. But now we're also seeing some of our local investment banks having a really important role, actually, in relation to that, and really leading the charge there. Operational infrastructure, I won't talk too much about that, but that's just basically, because that is what our speaker is going to be talking about, the infrastructure of the exchange and so on, how we're making these things happen. We talk about the fact that these shares are fungible. So you can buy shares on the London Stock Exchange and sell it in Nigeria. You can be paid, you know, dividends are paid in Naira. You can collect in dollars or whatever. So that whole process is something else that is very interesting. And I worked on the SEPLAT deal, which is 10 years old now. And on that deal, because of the operational infrastructure, it probably took us about 4 years to actually put that deal together, because the two exchanges needed to be able to speak to each other, etc. So it's more than just the documentation. Next slide, please. Okay, I've got here the traditional roles of the lawyers, some of the things that you're looking at: transaction structuring, risk assessment. You're also a local bridge, obviously, in relation to the regulators, regulatory compliance. I'm going to skip on because we don't have a lot of time. Next slide. Yeah, I think I can skip this, but these are very specific things that the lawyers do. Next slide, please. Okay, so this talks about sort of how we strengthen the market, what we need to do, digital innovation, you know, how governance is, what needs to be done in relation to governance, etc., in order to make sure that these markets can speak to each other, that you can comfortably invest in an instrument that is issued by an issuer in a particular jurisdiction in another jurisdiction. Again, a lot of this is going to be discussed by our speaker, Mr. Babalola. Next slide, that might be the last. Okay, importance, early engagement, obviously digital efficiency. Even in the arbitration, this panel, there was quite a lot of talk about sort of digital. We can't ignore it, it's first and foremost. So that's going to also drive things like due diligence and so on. The holistic structure tax is also a very important factor. For lawyers, we have to ensure that we are making disclosures. There's a lot of liability around if somebody invests in an instrument and they did not understand the risk. So risk factors are very, very important. That's something else that was actually quite interesting, because working, again, on the SEPLAT deal, before CEPLAT actually, I think the very first prospectus that I saw, that I looked at, that had risk factors about Nigeria. I mean, I could not believe it. There was nothing it didn't say. The country might fall apart tomorrow, this was bad, the structure was terrible, there was nothing. And I was shocked. But essentially, that is the way capital market lawyers kind of structure those things. They make sure that there's no risk they haven't highlighted. But in Nigeria, we had a very different approach. So we would talk about the risks, then we'll talk about the mitigants. We'll say, yes, the infrastructure is bad, but government is doing a lot to build new roads and blah, blah, blah. Yes, the electricity situation is this, but we would have mitigants. When we were in the international market, the English lawyers were not comfortable with any of these mitigants. And we need to state what the risk is, and the person needs to do their own due diligence and decide that notwithstanding this risk, they're ready to invest. So they don't want to say, well, I invested because you said government was building a new road, or the fourth mainland bridge, or whatever it is. And so it was interesting. We then went to SEC and said to SEC, and SEC wouldn't accept. They said, no, once you put out risk factor, we need to see a mitigant. So we had to go, that was something that we had to negotiate along with the English Council about the fact that we wouldn't be putting in mitigants. And it took a while to persuade SEC. I told you, the whole thing, 4 years. It took a while to persuade SEC. But when they were eventually persuaded, they then put in their rules. When you put in risk factors, you cannot put in mitigants. So SEC went to the other extreme. But that's where we are. So there's quite a lot to learn. I think it grows every day. I think that in terms of, one thing I just wanted to mention, I think in terms of sort of the next wave, when I talked about the history, you can kind of see the trends. I think the next wave, I think, is likely to be a lot of maybe our fintechs. A lot of them are looking at liquidity, and a lot of them have offshore holdcos. So I think that's the structure, the most likely structure we're going to see. There's been a lot of talk about a lot of fintechs in and out over the years coming to the market, and then they haven't come. Some of what I've seen, sometimes it's actually around some of the FX concerns, but also just structuring it. But I think that is where we will probably see the next wave. So with that, I think I will invite Mr. Babalola up. Thank you very much. Okay, I'm just going to introduce Mr. Babalola. Mr. Babalola is a fellow of the Chartered Institute of Chartered Accountants, Institute of Chartered Accountants, Institute of Stockbrokers, Institute of Bankers, Institute of Taxation, and he joined the stock exchange in 1997. He serves currently as the, let me just check, head of trading and products at the NGX. He's a respected market strategist with extensive expertise in capital markets, securities trading, and investor education. So So Mr. Babalola is going to tell us a little bit about what they have been seeing, and also maybe the trends, what to expect. Okay, we'll see. I'm actually not sure I heard what he said. But don't worry, I won't be too long. All right. So, Mr. Babalola, thank you so much for joining us.
Yes, thank you for having me.
I saw all your different qualifications and all your different associations. I didn't see MBA, sure. I didn't see the Nigerian Bar Association. So thank you for joining us and facing all these lawyers.
Thank you for inviting me.
All right. Okay, from the NGX's perspective, what are the most promising opportunities for Nigerian and West African issuers seeking to raise capital internationally?
Thank you very much. I think in terms of opportunity, like I saw in your presentation, we've seen instances where people had used direct, foreign listing. We've seen where people had done what we call cross-border listing. We've seen people use the fixed income side, which is the Eurobond, to raise capital. We are doing a lot of things in the West Africa integration so that the West African market itself can be developed. There are other opportunities that we're seeing, which is in the private capital. You know, some people are leveraging on the private equity, venture capital, you understand? And again, we've seen growth in labeled bonds, you know, things that speaks to sustainability, social bond, green bond, blue bonds, where people are using this to raise capital because there are fund managers out there that their focus is actually looking at companies that are focusing on these major areas.
Thank you. Can I just ask, just for the benefit of everyone, can you explain like the green bond, blue bond?
So I think in the sustainability space, or what we call ESG, you know, a lot of funds are now focusing deliberately on environmental friendly initiatives. So when I raise bond and I said I'm focusing on green bond, there are standards that I must follow. I must apply the funds directly to things that have those requirements. And those standards are regulated internationally. So you cannot greenwash. You know, people want to see that what you are saying apply to green instrument. If you talk about blue bond, you are really talking about something that has got to do with marine, you know, water and everything. Then we have social bonds, where the investment is focused on social impact. We could also have something that speaks to, that is related to women, especially when you want to achieve things and it's going to achieve. So most of these things, while they are environmental friendly, you're also looking at the these development growth goals, you know, to ensure that you are doing something and you're able to measure the impact. So it's not only finance, but you're only touching on environmental and you're also touching on sustainability.
Okay, so I was going to ask this question, but I'm glad it's on my list. What are the top concerns for international investors typically expressed when assessing Nigerian issuers for cross-border listings and debt issuances?
I think I would take it from every investor, whether it's local or foreign, are looking for certain things. So the question is, the man who wants to raise money, which is the issuer, are you really ready? You know, do you have what it takes? What is your governance structures like? What is the internal control that you have? You understand? How much of the financial reporting and disclosure are you doing? Because it is by doing this that they will be able to assess you. And if they cannot assess your company, then it means that no matter what you put together, you know, nobody is ready to buy. But if they can assess you, your local market is well developed, they can get information, they can leverage on legal advice to do due diligence about your company. What exactly are you doing? These are things that if you are not ready, no matter how much you want to do all this, nobody will be ready to part with their money. But if they can see that there is corporate governance in your system, you are doing the necessary disclosure, your financial reporting is meeting international standards, you know, they can easily assess you or easily get somebody to verify and do due diligence for them. They will definitely start seeing you in a positive light as somebody that they can invest money in. Even they also do what we call country-wise assessment. You understand? That is why, you know, most of the things you've said is because Nigeria has taken a deliberate steps, even at the federal government level, to issue sovereign bonds so that we can have sovereign ratings. Then they can start, you know, cascading that to companies within the country in terms of how to dimension the risk and also to do the pricing. So for issuers, you know, you must understand that you are going into a terrain that they want you to open up, give all the necessary information, prepare your standards, run your business in line with global best practices. If you're not ready, nobody will be ready to invest in that particular company.
Thank you. And so to what extent do you think the regulatory environment actually supports this?
I think, I mean, you will observe that in Nigeria, I would say we have good regulator in terms of Security and Exchange Commission and Central Bank of Nigeria. They are very dynamic, they are up to speed. They make sure that all the rules that we use in Nigeria are up to date, taking into cognizance some of the challenges, observation that they've observed all over the year. You will notice that we changed our CAMA recently. We changed our ISA just to accommodate those gaps. So in terms of the environment being supportive, at the regulatory side, we have business-focused regulators. At the exchange side, we're also willing to support anybody that wants to do anything. You know, just come to us, you know, give us early information, we'll support you, we'll handhold you. Some of these things you see us do again. We have a lot of MOUs with some of the market destination, talk about Johannesburg Stock Exchange, London Stock Exchange, Luxembourg Stock Exchange, Dubai centers. It's deliberate because we see that a time will come, one or two issuers in the country might see an opportunity in those markets. Because we have an MOU with them, we understand them, we try as much as possible to bring our regulation up to speed and to meet up with international standard. Today, it's not by mistake that we happen to be the first country in Africa to issue a green bond. You understand? We're planning to issue a blue bond. All these things is aimed at telling the issuers, apart from the government, that look, these opportunities are there if you're really and you're ready. And we also have a lot of MOUs with IFC, you understand, an arm of World Bank that trains corporates who wants to issue some of these instruments. So talking about whether the environment or regulation, whether we are supportive, in fact, some of us, that is our KPI. You understand? It's deliberate. They even tell you the number of instruments you must bring. So I'm waiting for somebody, or I'm even searching, for whoever wants to access that market so that we can provide the necessary guidance and hold them to achieving that objective.
So you mentioned MOUs with Dubai, the UK, South Africa. So what about West Africa?
Oh, we play a leading role in West Africa, you understand? Whether it is WACMIC, I'm sure maybe you've heard about.
Nigerians.
No, we play a leading, is it in WACMIC, that is the West African Market Integration. We're literally driving that initiative, supporting some of them to come up with the new rules and regulations to meet up with us. We are, miles ahead of some of these countries. It's also on record that we supported, in the establishment of stock exchange in Sierra Leone, in Liberia, in Gambia, and also, recently, we were the brain behind Ethiopia Stock Exchange being established, and we didn't stop at that. We also took a stake in the Ethiopian Stock Exchange to say, we believe in you, we're also going to invest our money. So the NGX Group, PLC, owns shares in Ethiopia Stock Exchange. So we're doing a lot of things in that. Some of the Asia, whether it is at the Asia, African Stock Exchanges, whether it's at WAP, we're the big brother, and we're actually leading those integrations.
This is an aside. Last week I met with somebody from in the office from Ghana, and of course the whole conversation of Ghanaian jollof rice came up. and so there was an argument. Obviously, there were more Nigerians in the room than him. So this argument was going on. He just finished it. He said, "You know what? At least we'll be eating our jollof rice, watching our footballers play at the World Cup."
No, but I think our leadership role in Africa, it's deliberate. Other African nations need to have a stock market before we could bring about that required growth. Because, you see, it's not government. It is private that is going to drive a link between Accra and Ghana for business. And you will see that most of the things that we're talking about, having common currency and the rest, the strategy first is, look, integrate the private sector. Once the private sector start doing business among themselves, government will come and that currency will come.
This next question is about lawyers, actually. So, yeah, remember you. What does it say? What role do local council play in building investor confidence and enhancing transparency?
I think, most of these things will not take place if you don't have a strong lawyer behind it. I must recognize that. And, one, you validate. So if I say I want to raise money, probably nobody knows my company. The first thing a lawyer does is you provide interpretation of the local regulation to the foreign investors. You are a gatekeeper. You do due diligence. You ensure that all the necessary disclosures are identified and the company is keeping to those disclosures. You also do due diligence. You sign concept. You also provide compliance, which boosts and ensures all the necessary documentation are provided, and you also ensure that people comply with that. And that, in a way, boosts investors' confidence. Because whether I'm investing locally or internationally, I'm picking their prospectus, which you contribute majorly into. I'm looking at a lot of things. And even without visiting that country, based on your work, I'm able to get information. And some other people will approach you and say, I need more information. And you're also doing that. So, I can say, can we really appreciate ourselves because we're playing a major role in contributing towards the development of attracting capital into the Nigeria and the continent.
And just to say, I mean, there's a lot that goes into those prospectuses in terms of, as you said, it really is giving people an insight into the country. So more than just about the company that is issuing, a lot about the country, our reliance on oil, whether we're diversifying, what's likely to happen. I mentioned the fact that, particularly with bonds, people price off the sovereign. And so if Nigeria is able to price at a particular price, because you operate in Nigeria, the expectation is that you cannot be as risk-free as the sovereign. And so so the impact of the country actually also affects your ability to raise. I will ask you this. What policy or market reform would you like to see that you think would have an impact on increasing?
I think, without being political, for the first time we're seeing a government that is pro-market in terms of their policy. So one policy we would like to see is to make sure that the foreign exchange is stable, because with that stability, it assists investors in pricing you correctly, knowing that if they take their money in, also repatriation, how can they take back their money? Because if I bring my money or I invest, definitely whether directly or indirectly, you're still going to pay me dividend. How I'm able to receive that dividend. Also, we want tax reforms that will definitely not punish people, double taxation, you understand? You want clarity around that. We want a scenario where government, again, could, like what they did with banking, you understand? It was because government says, I need banks to recapitalize. That is why you probably see the GTB, LSC transaction. We believe if we go into energy, we believe if we go into infrastructure, you understand? Then again, on policy side, deepen your market, come up with reforms, constantly look at your market and remove inefficiency so that we can benchmark. And that is why you see today at the NGX, we started with T+14.
Oh, congrats, yeah.
Then we moved to T+5, T+5 to T+3, and we're doing T+2. So all these things has implication because it tells you that, look, if you buy securities in our market, it takes 14 days.
That was before.
Before. In the days of manual or call over. But today we're saying if you buy on a Monday, you can get your money on a Tuesday. On a Wednesday. That is the meaning. And that is not the end. We keep assessing the infrastructure. So all these things they come together and showcase your market too, because you need a well-developed secondary market so that pricing and valuation, those people can also see it. So all these reforms, and you will see us engage more of government so that the more government patronize, the more you have issuers in your market. Because today, when if I'm a fund manager in US, and I'm thinking of allocating funds to Africa, the first thing I will look is your market capitalization. And that already puts us at a disadvantage because I will go to South Africa before coming to Nigeria. But if government will allow some of these things to happen, some of the things we envisage will happen in 2026. Dangote refinery is coming, Dangote petrochemical is coming, Dangote NNPC is coming. Federal government is trying to unbundle and really reveal what is happening in the energy sector. All these things, then we're doing something on the solid mineral sector. By the time you bring all these things together and we encourage most of them to be listed, you will see that today our market cap is about 95 trillion. We're projecting that by next year we should get to 300 trillion. You understand? And that is going to be all of us working together to achieve that. And once we achieve that, it means more funds will be available for businesses in Nigeria, and we can actually record that desired economic growth that we're actually looking for.
Thank you. I noticed that the timer never started, so I assume I still have 10 minutes, but I don't know if there are any questions that we want to take. Any questions? Please, if he said anything technical, ask him. If you don't know what market cap is or whatever it is, please ask. Madam. Yeah, I'm hoping somebody is going to help us with the mic.
They've changed it to 1 minute.
You changed it to 1 minute.
Thank you. I'm very delighted to learn that you have issued green bonds. It will be interesting for you to direct us to where we can get information on green bonds and blue bonds, because really, I don't think the financial market has interfaced very much with operators on blue bond and green bond. I don't know whether the regulators have really come out with the characteristics of peculiarities of blue projects or green projects, so that investors will know that they fit into and are qualified to access those bonds. Please, let's have more information and direct us to where we can find.
I think the first,
thank
you very much. If my memory serves me well, you know this woman, when she was Minister for Environment, Amina, that later went to United Nations, that was when we issued the first green bond. Yes, federal government, at federal government level, Access Bank had issued one, South North Power have issued one too. So I think it's on our website. You know, if anybody visits our website and you are looking for green bond, and to what Madam said, maybe what we can do is, if we have people that are interested in even understanding this more, we have an MOU with IFC for capacity building. We can actually bring together people and let them integrate them so that they can know what exactly makes something to be green. But on blue bond at the federal level, it's still something that we'll probably see next year. I think at the federal level, federal government have done the first green bond. They issued the second one this year, you know, about 3 months ago, and it was also full oversubscribed. So in terms of capacity building and information, Lagos State will follow federal anytime federal is doing anything. Lagos State has also issued a green bond. So in terms of capacity building, I will liaise with her, give her information, then we can work together and provide that capacity building with international body. IFC is a subsidiary of the World Bank. They can provide that capacity training.
I'm hoping that Lagos State will issue a blue bond.
No, definitely.
I think the waterways need work.
Exactly.
But what I will say is, I think that's a very important point, actually, that a lot of, I think the capital market community speaks to itself quite a bit, yes. Rather than speaking out. I know that we're all very excited about T+2.
True, exactly.
But I don't know how much the market, everybody outside of that small community is aware.
When they start receiving their money, when they start receiving their money earlier than, exactly, then they will see that, so this is the implication or the benefit of this.
Fair enough. One more question? Anyone? Beverly?
I think if there's anything that we should be prepared for, we talk about GDR. We're also working on reverse GDR. Reverse GDR is when you bring, a Nigerian company going out, we want to start bringing companies in. Municipal bond is also something you should focus on, because it's going to happen next year, is when you allow local government, local government to come and raise money in the financial market. And it's not new. The first one we experienced happened in 1992 during the no-party Babangida transition, when Prince Adeniji Adele was the local government chairman of Lagos Island. He came to the market to raise 100 million. Part of what we applied that money for was the popular Shura market. So today, we have over 700 local government. That is what you call municipal bonds. You will start seeing things happening in that space. Thank you.
Thank you very much, Mr. Babalola. I really appreciate you coming. You even look like a lawyer with your pinstripes. Thank you so much. Thank you.
Thank you so much, Mr. Babalola and Mrs. Inka Edu. Please, a round of applause to this fantastic session. Please, group photographs first. panelists. Okay, so we have another very important panel session coming up. The panel session will have a presentation followed by a discussion session. The presentation will be, the topic of this panel session is creation of joint ventures, different forms of international alliances and their benefits. There will be a presentation by Mr. Michael Laurence. I hope I got it correctly. And after that, we'll have a discussion session. But Mr. Michael, please, you can come and make your presentation. Please, a round of applause as he comes up to give his presentation on creation of joint ventures. Thank you.
Thank you. All right, I've got about 7 minutes to set the scene on this issue of international alliances, joint ventures, any forms of structured cooperation between foreign lawyers and, sorry, I've got to say it, local lawyers. I try to think of an alternative. What I mean by that, I don't mean Nigerian lawyers. I mean a lawyer in a jurisdiction and foreign lawyers. UK qualified lawyers are local too. But anyway, so trying to think of these forms of structured cooperation. And I want to cover 3 points. What forms of structured cooperation are available? Why cooperate? And then any regulatory issues which may arise in these cooperation. I will conclude by quoting some guidance that the IBA BIC ITILS committee has created on that purpose. So first of all, what forms of corporations are available? And I think it's useful to think about law firms and individual lawyers. Talking about law firms, you can start with marketing type cooperation. You have referral networks. Lex Mundi is one of them, but there are several hundreds of them. And they can either have one law firm per jurisdiction, or several firms being listed. You can then look at slightly, it's a spectrum, so slightly more advanced cooperation, strategic alliance or cooperation agreement. It's all the good friends, best friends in association with. And here the key issue is how exclusive you want to be. You probably cannot be 100% exclusive because you may have conflict rules getting in the way, or you may, depending on the practice area, you may not cover all the practice areas required. But I think it's a key issue, how exclusive is that relationship. Then, alongside the spectrum, you go in partial integration models. And by that, there's mainly 2 examples. Swiss Verein is one of them. Now, Swiss Verein is a Swiss corporate structure that actually some international law firms have been using to work with, again, apologies, local firms with local lawyers doing local work, but under a global brand. And you may share back office, you may share some systems, but it's very much, it's a way to be in as many jurisdictions as you can while keeping local profit pools as well. Regular examples of Swiss Verein's model, DLA, Denton's, Baker McKenzie are regular examples. Joint ventures, it would be 2 firms, so one foreign firm or local firm creating another entity. And I think it's often driven by regulatory rules in that particular jurisdiction. For example, in Korea, they have a rule that a Korean law firm and a foreign law firms can create a joint venture, but 51% of the equity must be with the Korean firm. So it's often driven by the regulations there. And then you have the full merger and the fully integrated law firms at one end of the spectrum. In the UK, a lot of large UK law firms are looking for that transatlantic merger, which US law firms to merge with. So that's the law firms. Individual lawyers, obviously it's also worth mentioning, you can employ a foreign lawyer. Sometimes partnerships are not possible, but employing a foreign lawyer is possible. Or you can be employed by a foreign lawyer, and then you can have partnership between local and foreign lawyers. So these are very, very briefly different forms of corporations available to you. We have great examples on the panel of Nigerian law firms using different models, and we'll explore that. So why cooperate? My second point. First of all, for marketing and business development purposes. You want to secure these referrals. You want brand recognition. You may have like a joint marketing drive. I think that's the first objective. Second objective, if you want to widen your offer to client, you want to be able to say you provide services to new countries and new region, and you can develop low capabilities in other jurisdictions and a seamless service to clients. But cooperation can go beyond that as well. You can have economies of scale. You can share back office. You can share experience and technology transfer. And again, that's the most advanced forms of cooperation. Under some of these models, you may develop a common AML platform. So you share best practice on anti-money laundering processes. Cybersecurity is another one. AI. All the conference I go to this year, talk about AI. Well, you can share AI best practice as well with the firms you cooperate with. And ultimately, you grow core competence and transfer legal skills. It may also facilitate secondment, actually, when you send your young lawyers for a period of time in another jurisdiction so that they can learn from that experience. And ultimately, you want to cooperate because you want to grow your market share and your market power. So third issue I want to discuss is what regulatory issue may arise because of this cooperation. First of all, you want to know what is permitted in your jurisdiction. Is it restricted? Is it highly regulated? They don't always go together. Singapore is very open as a jurisdiction, but it's also highly regulated. You have 4 licenses of possible cooperation, and all of them, you need to fit into one of these boxes. The different models have got to go through these licenses. But just a list of questions, can foreign lawyers be established in your jurisdictions or not? Are there restrictions on profit sharing with lawyers of different jurisdictions? Are there equity caps? Are there restrictions on name of firms? Sometimes jurisdictions would impose using the name of a local lawyer, or even a living lawyer, a lawyer which is who's still living. So that's all restrictions. Also, which foreign lawyers can you partner with? Is your jurisdiction going for the full list of WTO member states, or do you go through a process of approval, recognizing which jurisdictions you recognize lawyers from, and under what criteria? Also, to do what? Full license or limited license in terms of practice areas, in terms of the law and the advice you can give. What kind of structures are possible? What approval process? And what's the level of regulatory oversight from the bar in that jurisdiction, and what cooperation they may have with bars from the other jurisdictions, not to mention a wide range of issues I won't be able to develop, but insurance. In some jurisdictions, there are social security or pension contributions, which are attached to the bar, compensation fund for clients, and all this. So I think lots of issues to discuss. We'll explore this with the panel. I just want to mention, to conclude, 2 guidance that the IBA BIC ITILS committee has produced. And I would ask, is possible, the NBA and the SBL to circulate that to the link to all delegates. But we published in 23 an IBA guide to international trade agreements for IBA member bars, which covers not only this issue, but many other issues. And also in 2017, an IBA guide on models for cross-border joint practice, which directly deals with the topic of the panel. Thank you.
Thank you very much. Please, you can have your seats. That applause wasn't loud enough. Please, let's... This panel session, like I earlier mentioned, is dealing with creation of joint ventures, different forms of international alliances and their benefits. Mr. Michael Lawrence just gave us a presentation. Now we'll go into the discussion session. We have a couple of panelists to come and join us here to discuss this. The first person I'd like to invite is Mrs. Joke Aliu, co-managing partner at Aluko & Oyebode. Please, a round of applause for her as she comes up. Please keep clapping. She's coming up. She's coming up. I also like to invite up here Ms. Taiwo Afonja, Managing Partner, Denton's Acres. Mr. Wolemie Son, Senior Advocate of Nigeria, ably represented by Mr. Abi. Miss Abi, sorry, I wasn't sure if it was male or female, please. We also have Ms. Sadatu Hamo Aliyu, Partner, Hamo Legal. And of course, we have Rush beside me here, Mr. Michael Lawrence, to have this panel session. Thank you very much. Do you guys have mics? Okay, yes. And then finally, you guys have mics? Do they have mics? Wait. We have Mrs. Fumi Yai, Partner at Templars, to come and moderate this session. She's.
And he was going to forget me. Okay. Hello, everyone. Thank you to the organizers for having me here. All the introductions have been done. So this is a very interesting session because we've been talking about globalization of the legal services industry, so to speak. And then on this here today, what we'll be talking about is how, as law or legal service providers, how all of us on the panel, the different routes that have been taken, right, along that globalization journey. So when Michael spoke, he talked about the different tie-up options, and the firms represented here have different stories to tell. So we'll essentially be listening to their stories, and then we'll discuss, I suppose, what lessons learned. Background for us here in Nigeria, and then for the firms represented here is, and we all know this. These are the largest law firms in terms of partnerships in the country. And one would say, if I said this thing, I would say that for us, I work at Templars, so I'm one of them. The background is the firms, Templars, Alukanebade, ACAS, Olaniwa Ajayi LP, right? We all sort of grew to a point where there was definitely a need to globalize, to grow outside of the jurisdiction. And not just these firms, many other firms. We have Mrs. Umfonusoro here of Polusoro & Co., a lot of law firms here. But the need to sort of figure out what the next step was, right, sort of came upon us. Now, that journey ties into the other conversation about, global transactions and getting into the global space. So for all these firms, we pretty much, the management, I would say, got to a point where one had to decide if you had to make a decision as to how do you then expand. You've set up in Abuja, Port Harcourt, Lagos, you've even, how do you then expand? What else is left to do? And, like I said, we'll then discuss all the different expansion journeys. So I will start with Joke, right? Alukanebade. And it's really, so the first question is, share what your expansion journey has been for Alukanebade and where you guys are now. And then the follow-up is, how has that impacted the firm's practice, right? How has it changed since you did what you would tell us that you have done? How has that changed how you service your clients? What's the background? When Mika was speaking, he talked about the benefits of some of these tie-ups. He talked about back-end collaborations. How has that changed for you in your practice? And then I'll go along to everybody else.
All right, thank you very much for me. You know, I can't help but notice that this is a female-packed panel, and that's good.
Yes, so.
But one. All right, so, I mean, let me tell you a bit about our journey and perhaps what inspired an international strategy.
Mm-hmm.
And I think a lot of it was shaped by market trends
Mm-hmm.
and what we saw going on in the markets.
Mm-hmm.
I mean, so clearly, I think all of us would agree that Africa is fast becoming, you know, that major destination for foreign direct investments, right? So that's it on the one hand. Secondly, more recently, we've had the AFC FTA and the commitment to further interconnect the continent. I think in addition to that was also looking at some of our key clients and their business model, and just saying that for many of them, expansion into key jurisdictions in Africa was an important element of their business model. You know, that's for our key clients and for aspirational clients. And we wanted to remain relevant to these clients. You know, we wanted to remain their trusted advisors, and we wanted to, you know, maintain our market share and increase it. Mm-hmm. And clearly, I think it was almost a no-brainer that an international strategy was key. So the next question was then what that strategy would be. Yeah. In what jurisdictions do we think we want to have some form of presence? And what kind of presence do we want to have in those jurisdictions? And where do we want to continue to maintain maybe our best friends relationship? I think key for us was the continent, Africa. And Mikel mentioned a number of options, you know, from referrals. And we wanted to go beyond occasional referrals. We thought that we needed to do much more in terms of our presence in those jurisdictions. We also wanted a platform that would allow us to be agile, you know, in terms of meeting market needs. And I guess several other factors. You know, when you ask me about strategy, I ask myself, how much should I really be telling the crowd?
Tell what you can.
You know, or what my strategy is. But I'll leave it at that. And I would say those things really inspired us, you know, to join ALN, you know, which is a network that Alukwano Ibode is a part of. It's a network of independent law firms who are top-tier firms in their respective jurisdictions, and they're present in about 15 jurisdictions on the continent. Thank you.
Thanks, Joke. Don't drop the mic yet. Then I just want to ask her, but how has that impacted your
Thank you. Yeah, that was your second question.
Yes.
So I think one of the major impacts is really in our value proposition. And I think that it has strengthened our value proposition. So we can say to our clients, we can say to aspirational clients that they can expect from us seamless execution on the continent. In other words, they don't need to project manage different firms where they have, you know, multi-jurisdictional transactions or cross-border transactions. So they can trust that coming to one member of the ALN network, you know, will deliver to them seamless execution on the continent in respect of cross-border or multi-jurisdictional transactions. The other thing also relates to value proposition, and it was our ability to be able to say to clients that you can expect deep local know-how and continental reach. So, and you know that for most jurisdictions, I would say local firms or national firms understand local nuances that I would say, you know, firms outside of that jurisdiction take a while to understand. So what we're promising to clients really is that you should expect the same standard of expertise, of delivery, you know, deep local know-how and continental reach. I guess that's the other. Do you want me to go on?
No, it's fine. I don't know if anybody noticed that Joke has found another word for local. National.
Well, I picked it up from the previous sessions, I must say.
Okay, so Taiwo, please. You've got a mic. Okay, so you share your story, right? What expansion route did you guys take at ACAS, and then just share how that has changed your service delivery.
There it is. Okay, I got it. Thank you so much. Good afternoon, everyone. I'm very happy to be here and glad to be sharing the story of Denton's ACAS law. So, prior to our combination with Denton's on the 1st of April 2021,
we already had a very good working relationship with Dentons, and we did, I would like to say, majority of their work here in Nigeria. We also had relationships with other notable law firms, both in the UK and also in the USA. But then we had this futuristic look at where the practice in Nigeria, in fact, the world as a whole, was actually heading to. Globalization was clearly the buzzword, and it was something that we realized that you cannot afford to miss out on the train, right? So it was important for us to jump on the train and ensure that whilst we did appreciate the relationships we had with other law firms before the combination, it was important for us to formalize one and then be ahead of the pack in terms of Nigeria, moving out there, not just on a best friends, really nice informal basis, but a formal basis that would solidify our position right there and also tell the world that we were no longer playing nationally, but we were now playing on a global field. And for us, it was also going beyond Africa. And the reason was because we certainly had a lot of multi-jurisdictional and cross-border transactions beyond Africa. And it was important for us to be able to provide our expertise locally and what we knew, combined with the strength that comes from being a member of a Swiss Verein, to our clients to deliver seamless, efficient, technologically backed services to our clients. And so we took that decision and we looked at all the other relationships that could exist in terms of partnering, and I use that word loosely, with foreign law firms or global law firms. And we took the view that it was important for us to pick Dentons, and do the alliance, or rather, not the alliance, they enter into a Swiss Verein, which is the structure under which we operate with Dentons.
What has, like, how has that impacted or affected your service delivery? What changed?
Do you say Africa or globally?
No, your firm.
Oh, my firm. Oh, a lot changed in the sense that we now have reach across the world, right? Dentons has about 176 offices all over the world in about 86 countries. And in Africa itself, we have 17 countries and about 25 offices. So what that did was it opened a seamless gateway for us to the world. We didn't have to start going through, in every country where we may have, where we did do business, or a prospective client or a client did business, have to sort of start re-engaging with local firms in those jurisdictions. Now we had what I would like to call a global market, singular global market, if I could use that word loosely, to play with, and that allowed us to sell ourselves. And of course, there's the branding thing. I'm sure a couple of you would know what a Swiss Verein is. It's law professional services, and in this instance, law firms coming together under a singular brand to provide services to our clients, share costs, take advantage of the economies of scale, and take advantage of all that the entire network has to offer. So that's the way it impacted us in terms of our reach to be able to tell our clients we're everywhere in the world, and then technology also, and then the economies of scale, because now we were sharing costs with, imagine, 76 or so countries. So that was that's how it has impacted us. It also impacts our people, and I use the word impacts because it's a continuous thing. We are able to take advantage of human resource development in a different way. Not that we didn't have any of these things before, but then you now have this different. Again, loosely speaking, best practices. We were practicing, we do have best practice, but then there is that flavor, the expertise and the different nuances that coming together brings into the whole mix that allows us to provide excellent services from a local perspective and also trans-jurisdictional point of view. Thank you.
Thank you. All right, so Mr. Passing the mic to you. So your route is completely different, right? And you just share your story, because you guys went a completely different route. So let's hear from you. Thank you. Good afternoon, ladies and gentlemen. So at Olaniwa Ajayi, we decided to set up our own firm in the City of London, a fully SRA registered and regulated law practice. And so it's an organic growth model using our own resources. And that's what we decided to do.
And of course, a lot of people asked us why we would want to go that route, given the significant challenges that we would and did face in doing so. But I think for us, as a matter of strategy, we realized that over the years and even over decades, a disproportionate amount of international work, clients' work, was coming from London. And even on cross-border disputes, the arbitral forums were seated in London. And we saw it as an opportunity to provide clients with an integrated, sort of seamless, end-to-end legal services and unlock value in cross-border deals. We thought it would be good to, it would enhance our talent pool, which it has done, and extend our global reach. We, however, did take a very different approach in Cameroon, because there we entered into a joint venture with a local firm.
Okay.
It wasn't actually going to be our initial approach, but we had to pivot. And I can talk about that as well.
Yeah, no, I mean, so from Templars, I'm very familiar with the starting, ground up approach, right? So that's pretty much what we did going into Ghana. But then, when people say, oh, Templars, you set it in Ghana, really, what Templars Ghana is, interestingly, some individuals had actually walked up to me to ask me about the setup because they are also from Ghana. I was like, the firm it's pretty much an amalgamation of 3 practices, what we have today as Templars Ghana, right? The firm that we merged with, and then in the course of time, you went on to pair up with another firm. But then, Mr. if I'll then just get to you, right? Just because you guys, at least, for your UK office, you're starting from ground up, what cultural, so I mean, Mikhail has spoken about regulatory, provisions, but then sometimes some things are not actually law, but you need to understand the culture to thrive, yeah? Because you could set up an office, but then you won't be thriving. So can you share, before I get to Sada, to just, as a follow-up, what cultural nuances did you have to walk around, in setting up a new office?
Okay, so there are quite a lot of things that you do need to have in place to thrive.
Yeah.
In terms of even culture, I think one of the things we realized was that, just as a matter of strategy, we didn't want a too-firm problem. We didn't want London to evolve away from the rest of the firm. So we were very intentional about integration, and the way we did this was in a couple of ways. London partners are very involved in our pitches, in pricing, in all matters. They also provide, input in terms of strategy to Lagos. Mm-hmm. And Lagos partners also go to their retreats and they put their inputs or give their inputs in relation to their strategy management decisions, governance, etc. We also have secondments, two-way secondments. So, Lagos lawyers are going to London and vice versa. That was one of the ways that we felt we could have that integrated approach, which is something that we really wanted to have.
Okay.
So, yeah, that's one of the things that we felt we needed to put in to have that cultural coherence.
Yeah. Okay, thank you. Sadatu. So Sadatu is one of the younger ones, not by age, but at least by practice, in terms of her firm, right? So she's the managing partner of her firm. It's called Aliyu and Partners.
No, Hamo Legal.
Hamo Legal. Now, Sadatu, my question to you is, what does expansion look like, right, from your perspective?
Thank you very much for that question. And yes, we may be the youngest in terms of age as a firm, but I do not believe in terms of impact. So for those who may not know the firm, I'm the managing partner of Hamo Legal. We are 7 years in existence, and we work across the intersection of business, technology, and regulation. And when we started, we had a bias for emerging companies operating in the technology ecosystem, but we've evolved into a more full practice as at today. So when we look at expansion for us as a firm, we view it not just from a market basis, but also in terms of the way our clients are also evolving. And we do strongly believe that the future of law practice, starting from Africa, would be that of the networked lawyer. So we really focus on individual collaborations with partners across Ghana, Tanzania. We move as our clients are also evolving, because the reality is, if a company started in Lagos, got funding from the US, the next point is, because you're pitching as an African company, expanding through the African ecosystem. So the next point line is when you're going to Accra, when you're going to Dar, you want to engage with your councils in Nigeria. Who do we engage with at that level? So for us, our priority is ensuring that as a firm, we're building the right individual networks and collaborations that would allow us to scale not only as a firm, but also collaborate in a way that our clients are able to deliver their business objectives. So for us, we see collaboration in two ways for the firm, or rather expansion, as you've asked. One, on an individual basis, because at the end of the day, the firm is one entity, but who you're working with as a baseline is what matters most. And then the second layer is on a firm basis. Who is the firm that we trust at the end of the day? This model, we believe, allows us to continue to remain agile, to help our clients continue to grow, and it has helped us for our clients to see us as these continuous trusted partners in their growth journey.
Okay, so practically so your client is, maybe setting up in Senegal or something, and then you then engage that foreign lawyer in Senegal to do work for you.
Absolutely, and more often than not, you would find we will be the ones collaborating with the council across the other end, because our system is more integrated and more embedded into the client system as well.
So the client is speaking to you, and then the Senegalese lawyer, in this example, will be reporting to you.
Absolutely. They could be reporting to the client, but we collaborate in the project together. And in that process, we share knowledge, we share experiences for the client as well that will help the Senegalese law firm serve the client better.
How do you bill?
How do we bill?
Yes.
So we already bill the client here locally. So we're not billing for the work in Senegal. So it's part of the strategic support we provide to the local client here.
Okay.
Or as Joke will say, the national client.
The national client, yes. Okay, so I'll just have, Mika, you've listened to, these different examples, and really, this is everything you've spoken about, right? It's all represented here. So I just want you to take a few minutes and just sort of react in terms of what you would say are kind of like the naughty issues or things that, firms should be aware of depending on the style. So there is the alliance, there's the Swiss verein, there's the organic growth, right? And then there's Humble Legal, who, is engaging individual lawyers in foreign countries.
Thank you. Well, first of all, I'd like to say I feel very privileged to be part of the panel, not just because it's a panel of predominantly women, great women lawyers and so on, but also because it's wonderful to have all these examples of different type of structured cooperation with, with foreign law firms. And I think what I'd like to say, you have different models available to you, and all options are valid in themselves. All have strength and obviously pros and cons that you may want to work on, but all are very valid models. I suppose another aspect is that depending on the jurisdictions you want to work with, you may actually have to pick some of these different options. And even if you look at the largest firms internationally, they may approach different jurisdictions in a different way because of the regulatory framework available in that jurisdiction. So can you, for example, open an office? Can you partner with national lawyers or not? But also other drivers like the tax situation in that jurisdiction may be an important driver. And also, organic growth. So opening an office in another jurisdiction is a massive investment. You're probably going to lose money the first 5 to maybe 10 years of operation in that market. So you want to approach jurisdiction in a different way as well. And you see some of the largest law firms may have offices in some jurisdictions, may be part of a networks, may go into best friends type of relationship, more or less exclusive in another market, and they may have a panel a lot of London-based law firms actually have a so-called Africa desk, and essentially they have a panel, either one or several law firms in each of the African jurisdictions. That's the topic for the next panel, actually. So I won't talk too much about it. But I think it's wonderful to see all these different examples, and we all have a lot to learn about the Nigerian experience.
Okay, thank you, Mikhail. We're going to go into lessons learned, right? And then before we go into that, I'll tell a story which my colleagues from Ghana know very well of. So, a foreign law firm, moved to set up shop in Ghana. Foreign, not off the continent, an African law firm out of South Africa, actually, set up in Ghana. Now, the law firm, so in coming in, they, I would say, acquired, right, a Ghanaian practice. And the founding partner of that practice, after 2 years, was asked to resign, right? That's a huge story, right? So everybody, it's a really terrible story. So lessons learned, okay? So I'll start from you, Bisola. Obviously, if he had to do it again, he wouldn't do it that same way. There was obviously something, in retrospect, he would do differently so he doesn't, he wouldn't get kicked out, okay? So do you guys already have just what you can share anyway, right? So any lessons learned?
Lots of lessons learned. As Mikhail said, it's a huge investment, and I think at first we underestimated just how much investment it would actually be. But not just in terms of, resources or expenses, in terms of even time. The regulatory requirements in a jurisdiction like England is very robust. It's a highly regulated environment. So even ensuring that with respect to our processes, data protection, AML, DD, we actually underestimated just how much time putting together proper protocols would take. Something else we underestimated was professional indemnity cover. So it was very expensive, of course, but what about even trying to find an insurance company that's willing to take a risk on us, on a startup firm, from Africa in London? That was very, very difficult. Then, I talked about costs, and I would say lessons learned is, one of the lessons learned is whatever your cost projections are, just double it.
Yeah.
Just double it at the start. And then even finding talent. So, you're trying to get talent that they already have their well-paid jobs, and you're trying to get them to buy into the vision. That was difficult. And you're not just trying to get them to buy into the vision, but even in terms of, the benefits, the salary benefits, and, for law firm, for lawyers, talented lawyers, that was very prohibitive. Let's put it that way. So those are some of the lessons that we learned, at least in London. In Cameroon, I mentioned that we ended up setting a joint venture, but we tried to do a market entry approach, but there were so many barriers, cultural, yes, language barrier, and even getting them to trust us. So we had to pivot pretty quickly, and we then, ended up going the joint venture approach. So those are some of the lessons. There are a few more, but I don't want to take up too much time.
Yeah, I'm very familiar with the cultural one. And then because, with Nigeria and Ghana, it's everything from jollof rice to soccer. There's always war. Yeah. So, when you go to set up an office in Ghana, you'd better respect the Ghanaians and, but it just worked out really well for us because we were able to find a firm that was just everything we wanted, but even including the level of expertise, right? So in partnering with them, we landed really well. Yeah. So when you say Templars Ghana, it's really a Ghana practice, right? There are about 30 people in the office, and there's only one Nigerian. It's a Ghana practice in Ghana, and as far as we're concerned, that's perfection. Okay, so Taiwo.
Thank you very much.
Lessons learned.
Lessons learned. I guess because we didn't approach it the traditional JV or mergers or partnerships, we had the opportunity to actually look at what we wanted to do, right? The DD was extensive. It took almost it was 2 years or so. It was extensive DD. Wow. So the lessons learned are not so much as, oh, we wish we had done this better, because I'm not sure. I think we just did. Grace, blessings, we got it, But what I do say, and I would say to those who may be looking to this kind of structures or platforms or engagements, is DD is key. That's one lesson. You must ask questions. That's another lesson. Get your best negotiator on the team. That is a lesson you must learn. Your best negotiator on the team, because you're going to negotiate documents, arrangements, cost sharing. There's so many things you're going to negotiate. You need your best negotiator on the team. Another thing is understand that as much as you need them, they need you. We are both at the table and we're both playing the same game, right? In terms of no one is superior to the other. So we had all of those things and we fully understood what it is that we were doing. I mean, there were things like, if it doesn't work for us, it doesn't work for us, right? But on the other side, as much as that was it, what would happen was also important to. Negotiation is also a give and take, right? So there were some middle ground positions that we had to take. But what really helped us is that we didn't want a JV, we didn't want a takeover, we didn't want a merger. It was important for us to retain 100% control of our interests, our equity, our decision making, and our finances. We don't share profits, we're a distinct, separate legal entity just under that Swiss Variant brand, and platform. So for me, again, as I would just say, due diligence, get your best negotiator on the team. First of all, have a clear vision of what you want to achieve and whether this particular structure would achieve it for you. Look long term. Don't with the immediate effects of, oh, I'm going to join the global, practice and all that. If it takes 3 years, then it takes 3 years. It took a long time, and then we also had to go through getting even the partners on board. That's also important. None of your partners should be left behind, because it's a decision that would affect each and every partner and then the members of the firm at the next level. So in a way, that is how I would say those are the lessons you could learn from doing this thing right. And always speak up. Communication is key. If you don't understand the meaning of as simple as go. Let me even make it that simple, Go, G-O. Ask those questions. Because in the biggest picture, that go may actually be go, come, turn around and flip. So it's important to get to the bottom of it, and nothing should be hidden and there should be full disclosure. That's the way I would put it.
Thank you, Taiwo. Joke, lessons learned?
All right, thank you for me. I'll share 2 broad lessons, and I think one is communication, and the fact that it's extremely important to communicate very clearly to the markets. Half the markets, some people don't know what a Swiss Variant is, and so they don't even know what has happened. They don't know whether it's been a takeover, it's a merger, exactly what it is. So it's important to communicate clearly to your clients and to the market. And sometimes that communication is missed, and it could have, some serious impact, because you probably have to step back a bit and then push it forward. So market communication is key. People want to know what exactly has happened, what's the impact of what has happened, what has changed, and what should we expect. So that communication is key. I think the second thing is just to generally manage expectations, and to know that, well, we've talked about different forms of different international, strategies, but to remember that it's not a magic wand. So the fact that today you've joined a network or an alliance, or you've started another firm in another jurisdiction, doesn't immediately translate into your bottom line. It doesn't happen that way. It doesn't happen overnight. And apart from that, you need to make it work. So you may be in an alliance and nothing changes. You need to be very clear about what you want, and drive that objective within the alliance. No one is going to do it for you.
You need to make it work I think that would be the PF line for this panel. Please, Hada to, Taiwo, absolutely.
Yes, you're very correct. Hello? Yes. Market communication is key. So, all of that is important to face for the external facing side of the deal, of the transaction. So there's the internal facing side, and the external facing side is the communication that you set to your clients. And you also talked about managing expectations. I'm sorry if I'm going to dash a few of your hopes. There is no magic wand, and it's not a money pot in the first 1-2 years. That's just it. You have to play the long game, arrange your finances, but keep your eyes on the goal and the target and what you want to achieve, and eventually to become a success. Thank you.
Okay. Harriet?
Well, I guess my own lessons will be radically different from.
But it's still a lesson. It's still a lesson, and it's relevant to the
yes. But I think the important thing is, for me, like I've said earlier, is about relationships, because alliances don't happen just because firms are connected under a banner. It's because lawyers have formed that relationship. That's why the alliances work. So for me, the number one core is forming that relationship even before you need it. So whichever country I find myself in, even if I don't have a need, I try to look which lawyers can I engage and interact with. It is through that we can be able to solve the problems for our clients.
Okay, thank you. Can anyone just speak to internally, right? I mean, we talked a lot of things about managing people externally, but then when you look internally in terms of your lawyers in-house, how have you managed them, through your transitioning and then into, was that something special that had to be done? Taiwan, okay.
I wouldn't say something special in the sense of, 3 meetings, 4 meetings, and all that. It was just important for us to communicate to them what we were doing. So that was very important. It was also important to let them know what the benefits of the association or the platform or the Swiss Verein would be, so that it was important that they see that we're keen into a much bigger thing, a much bigger space than ourselves. Also important was to manage expectations. As I said, even for the lawyers, one of the things that we had to address was, and sometimes these expectations are not expressly stated, but the buzz and the excitement of you are going to be part of Dentons and all of that, you sort of expect that tomorrow, if you join today, tomorrow you're suddenly, the best of the best in terms of, you have access to everything that Dentons has to offer. No, none of that. So we had to manage the expectations that it's a process. It was also a phased approach in terms of the services that we had access to and the human capital development that we also had access to. Communicating with them and managing expectations were 2 key things we did. And we also, as the firm and the management, had to drive that process and then keep an ear open. It's important to listen and get feedback. So we did get feedback from members of the firm that, look, one of the reasons I'm here or staying here is because of Dentons, and, I expect ABC to happen, and then you talk to them, engage with them to ensure that, they really understand that it's going to happen. Some are low-hanging fruit, some will take some time. So communication is key. Yeah.
Thank you. Okay, Pisa, please.
Thanks. Okay, so I think 2 things with our associates. They were pretty excited about the prospect, especially in terms of benefits like secondments and everything. But it came with a burden. They had a lot more work to do. We had to support London as well, and that was that was an issue. Now, to be honest, London doesn't even rely on us as much. So they are doing a lot more work on their own, and they have grown, and so that's been a thing. But in terms of, and this is, I guess, there's a good problem to have, but they've sort of started cannibalizing some of our work, because sometimes when clients, want both London and Nigerian lawyers, and they say they're a bit sensitive about putting both law firms together, they have been choosing, in some instances, to put the London lawyers, the London firm, on their panel. So that's less work for us.
You mean a London lawyer who's Nigerian? Or what? So
no, the London firm, so the UK firm. So a firm has a transaction that they want to put lawyers on their panels. And they need Nigerian lawyers and they need UK lawyers. But they don't want to put both Olaniwa Ajayi Nigeria and Olaniwa Ajayi London.
Okay.
So they say that we have to make a choice.
And then they go.
And they choose London. So that's one of the issues we've had.
Okay. All right. Thank you very much, everyone. The note says we're out of time, but can I give you a few minutes to questions? Has anyone got any question? Okay. I think I will see 2 questions, and then. So when you ask your question, just say who's directed at, so that.
Good afternoon. My name is Farouk Obisonya. My question is to the managing partner of Amoligo. So I want to be sure that are you relating with individuals in those countries, or you are relating with them as a firm? Secondly, did you do your due diligence to the point of structure? For example, if you're relating with an individual, I mean, what happens in situations of, say, nature, act of nature, anything happens, and you have a client who has engaged you, you've engaged someone in Ghana, and something happens. So what mechanism do you have in place to handle such situation?
Okay, thank you. Farouk, right?
Yes.
Thank you. That's a fantastic question. And really, when we look at these alliances and collaboration, they're two-pronged, right? At the firm level and the individual level. But the individual level comes first before we go into the firm level. A lot of the panelists that have spoken here have spoken more in terms of defined structures that requires them to be either within a certain, either a variant structure, either within a certain defined network. But our approach is more collaborative and a bit more agile that allows us to deliver on the client's expectations wherever they are able to deploy or go after. And at the same time, it gives us the ability to be that superpower that says, oh, we're going to Ghana or we're going to Tanzania, and we'll immediately place a call and solve that problem. So for us, really, collaboration is not about we come and just do work together. It is really the core of our operating system, and we don't leave it just as a firm level. Even for our associates, we encourage, try to find collaborations even within Nigeria to be able to sort of accelerate the work that we're doing, because no individual lawyer or no individual firm can be able to do every single thing, but you must at all times be able to be positioning yourself as the trusted legal counsel for your client. So for us, really, the core of our expansion really is not about location, it's more in terms of people. That is what we see as really what is missing in terms of building for the future in Africa. Because you're Farouk alone, I won't just come and meet you and collaborate with you. I would have to also know and understand which firm are you with. But I won't just wake up and go to a Denton's in Accra. I won't just wake up and go to an ALN network firm in Kenya, or where probably I might call Madam Joke and ask her who to engage with. So for us really is making sure that this, I don't always like to call us boutique, small. My colleagues say, don't call us small. We're not small. We're more boutique, but it gives us that level of agility, and also clients have that level of experience that perhaps they don't get in other bigger, more structured, dynamic situations, because the arrangement will be different. You had cannibalization. So in our system, in our structure, there wouldn't be any conversation of cannibalization, because the client is almost receiving, even if not the same experience, they kind of feel you still have your back.
Okay, next question, please.
Okay, good day, everyone. My name is Uju from Summit Field. So my question is not particular to any particular law firm, it's generally to everybody, since we have the big law firms here. So it borders on the little law firms, integration, will I say nationalization. How does it affect the little law firms? Let's say, will you go for expansion as opposed to collaboration? For instance, Olaniwa Ajayi has an office in London. You go to London to do a work. Instead of internalizing or collaborating with other law firms in London, you go to Olaniwa Ajayi in London. How does that expand international practice? How does that affect the little law firms? Thank you.
Okay, I think that there's space for everyone. That's my view. And there's no right answer or maybe I should say there's no wrong answer. It's pretty much a question of what works for you, right? And where you are at any given time. We've shared a number of alternatives and options here, including Harmon Legal, who has shared our experience, working with individual law firms. And in terms of relationships amongst law firms, sometimes they transition. You find out that you're working with a law firm who is a best friend, right? And so anytime you have work, you describe them as best friends. So if you have instructions in another jurisdiction, they're probably your go-to person or your go-to firm. But it's not an exclusive relationship. And because they are best suited for that type of work, you are better off giving it to a firm that is best suited for it. I don't encourage national firms to advise on English law or German law because that's not really your area of expertise. So if you do get that kind of work, the proper thing to do is to ensure that it is, referred to the right law firm with the expertise. And like I said, those relationships transition. So in ALN, for instance, which is a network that we joined in 2022, in the same year that we joined, there were a number of law firms from the Francophone countries that merged within ALN, right? So you find that sometimes firms transition from best friends relationship that are non-exclusive to a more exclusive relationship to probably a merger going forward. So you need to ask yourself what works for you. Some things are important to certain firms. For Alucanoye Bode, for instance, a firm that has been built over 30 years, we know we've invested in our brand and it has become, globally recognized. So a merger is something we would think twice about, right? Independence is important to us. So you need to ask yourself, what exactly is important to you? Because whichever structure you choose, there are trade-offs. So you need to ask yourself, what are you ready to trade off and what are you not ready to give up?
I think, okay. The question you need to ask yourself is, what do you want to achieve, right? And that would drive every decision and everything you do, right? For us, as I said earlier, it was a question of we needed to globalize and on a scale that we could not achieve as quickly and as effectively if we were doing it organically. So it was important for us to join up with Dentons and the Swiss Verein. And the access to 12,000 plus lawyers. Harmony was talking about the personal relationship. Imagine having access to 12,000 plus lawyers. And we have an open door policy in Dentons. So if you're in New Zealand, I can actually pick up my phone and call New Zealand. Nobody's going to say, I don't know you, you can just send a mail, pick up your phone, send a chat, so you have that access. So that, determines a lot what you want to do. But I suspect that your question is, and help me if I'm right or wrong, are you looking at it from a point of view of if all the big law firms are doing this, where will this leave the smaller law firms?
That's
and
question.
What market will they have? And what clients will, I think that's your, am I correct?
Sorry. So I'm also trying to reverse it. So let's say the big law firms from New York or London, wherever they're coming from, they come here. Instead of partnering with, say, Aluko Onyebode or Olanuajayi, they establish their own law firm. Where does it leave us? That's my question.
Wow. First of all, and I could hear the murmurings, well, not murmurings, but the comments. They can't, right? They can't do that. But I must point out that, remember that there was, I don't know how many will remember that, we did have these best friend law firms with certain of the big law firms who would fly in the lawyers, right? And then they would do the work and all of that. So for us, what we decided was that we didn't want to do that, and it was important for us to take advantage of what was being offered to, or well, what we saw that we could do in terms of that. Now, for the smaller law firms, I'm not sure I have an answer. Maybe Harmony will be better.
Okay. I think that's a fantastic question. And I think the reason why you're struggling is because where do I even fit in this dynamic? Because if I'm doing a Swiss variant, I probably don't have all the metrics to be admitted into whatever Swiss variant. But I think we're at a point where technology has changed a lot of things, even within the practice of law. So we need to rethink new models for JVs, because what is really being shared is beyond a referral system. We should be looking at the new law firms, we should be looking at collaborations as sort of supercharging our level of innovation and our level of growth within the system. So we may need a completely new type of playbook for these generations. All of the firms here were created probably before both me and you were born. So the dynamics of the thinking, is completely different. So it is time for a new playbook that looks at what are we focusing on? Are we just doing a referral system, or we're sharing intellectual property? We're building an innovation company that powers all of us, that does not even require extreme level of regulation within the bar systems. Yes. So we need to rethink what type of playbooks are we using in terms of building our firms. And our thinking should move beyond designing JVs for our clients. We should begin to think, this concept of JVs we design for all of our clients, how do we apply it within our own law firms and within our own systems?
Thank you. And that's one more question. Okay.
No, it's not a question. But I just want to say to the lady who just asked the question, immediately after lunch, we are going to be talking about the top tips for smooth operation. So the question you asked will be answered during my panel discussion. So please, join us after lunch. And please, everyone, join us after lunch. Thank you.
And on that note, I think this panel session has come to an end. Thank you very much.
All right then, so that's it. Thank you, Sadatu.
Pictures,
Thank you,
pictures.
Joke, Taiwo.
Pictures.
Mabisola, yes.
Pictures.
And Mikal.
I can't be
Lunch break for just 30 minutes, please. Lunch break is 30 minutes. Please come back on time for the next exciting panel session. Thank you very much. Lunch break is 30 minutes. 30 minutes. Thank you. Thank you very much. Please, those at the back, can you move forward a bit so that the speakers can get to interact with you more efficiently, please? Those at the back, please, can you move forward a little bit? At least the third row. At least the third row. Please, can you move forward? Thank you, thank you. I know it's an inconvenience. Thank you so much. Thank you so much. Thank you. Our friends in glasses, please, can you move forward? Okay, I think we'll just start. Okay, so this panel session is focusing on working with large international law firms, expectations of local firms, top tips for smooth operation. We'll have a discussion session, but before this discussion session, we would have a presentation by Mr. Ian Sanford, Chair of the International Bar Association, BIC Committee on International Trade in Legal Services, and is a partner at Foley & Hogue, Paris and Geneva. When he takes his presentation, seated here with us, virtually we have Mr. Paul Harris Ogbole, SCN. I think he also came in physically. He's not here. Okay. Then we have Ms. Ayotunde Owegbe, partner at Banwa Nigudalo, who's seated here. Please, a round of applause as I call their names to encourage them. We have Mr. Adeleke Alex Adedipe, managing partner, Duale Ovia and Alex Adedipe. We have virtually Mrs. Buchi Douglas, Senior Associate Principals Law Partnership. And then we have seated right here, Mr. Ian Sanford, like I mentioned earlier. So Mr. Ian Sanford will take the presentation. And no, I'm not finished. Mr. Ian Sanford will take the presentation, then we'll go to discussion session. The discussion session will be moderated by Ms. Sholakwe Peters, partner at GLA Piper, Nigeria. Thank you.
Thank you very much. I will lead off. There's a presentation if somebody can bring it up, but maybe just as we're waiting for the slides to go up on the screen, I will start my little countdown timer. And I'll also just make an observation. So the last session, which I found really, really interesting, was partly about the benefits and about how to work within networks or varines or the different options for lawyers to kind of, for want of a better word, associate with foreign firms, with firms from outside the jurisdiction. My talk now is actually going to be looking at a similar issue, but from a different angle. So it's much more about lawyers working with lawyers across borders, and what works, what doesn't work. Now, I take a point that was made by the President in his opening remarks earlier today about foreign lawyers sort of coming in and lecturing about things. I certainly don't plan to lecture anybody. What I plan to share is my own... Okay, is that better? Yeah, sorry. I really do hate microphones, and I always get them wrong, so forgive me. But what I was saying is I'm not sort of planning here to kind of give any particular advice or to lecture anybody. What I'm trying to share really is a data point for you to take into account based on my experience as a lawyer who's worked in large international firms, but also as a lawyer who's worked in a national firm in Australia, which didn't have an international network, but where most of my work actually came from referrals from usually US law firms. So I've kind of sat as the local lawyer, to use that term, and I've also sat as kind of the lawyer in a bigger American organization that from time to time looks for counsel in a particular jurisdiction or in a particular project, and I work with them. So that's what I bring to the discussion. Could we advance the slides, please? I'm actually going to go I'm actually going to jump ahead a little bit. So next slide, please. Could I have the next slide, please? Okay, I may not have slides today, so I'm gonna say a few things. Oh, great. Please, let's. Okay, and could I have the next one, please? I'm going to skip that one. Okay, So in making comments today, I have been asked to focus on 4 key questions, which you see on the screen. They're about local council growing relationships with international firms, about structuring those relationships, about working together with mutual respect and professional confidence, and about the kind of tactics, the specific tools that are used to make sure things work well with clarity and alignment. Let me ask you, the audience, whether those are those the right questions to be asking? Are they good questions? I generally see some nodding, which is great. So the audience, do you have any thoughts on any, just single words really, on key things that are going to help answer those questions? What are the key things in relationships between lawyers across borders? Well, actually, there's a hand up, so I'm gonna take the answer. Okay. For sure, that's definitely a question at the starting point in any relationship is, who's the client, what's the project, does one of these law firms control that relationship in a way that they're actually bringing somebody else in? That's definitely relevant. I was actually thinking at an even higher level of abstraction, and I'm going to ask to advance a few slides, please, to slide number 8. I'm going to skip over all these things which make the point that there's a lot of trade in legal services, there are a lot of opportunities out there, some of the numbers are big, and no market really is completely open, so there's always a need for lawyers to work across borders. That's what those slides said. On this one, could you just push the button one more time? Okay, and this is my point. To answer all of those questions, when you're working with other counsel, whether they be international counsel or local counsel who you, for some reason, collaborate with, you've hired a barrister or you're working across borders out of your jurisdiction into another one. These things are always about trust because if you are associating your professional reputation, your fees, your way of working with somebody else, you have to trust them. And so the key point that I'm going to make this afternoon, I'm going to talk about this and expand on it a little bit, is all of these things need to be done in a way that builds and maintains trust. And that, of course, is one of the benefits of the networks and the varines and the associations that we talked about in the last session, because there's a degree of contract in each of those relationships, and there's a degree of due diligence that our colleagues spoke about that kind of increase that level of trust. They get over that trust deficit, so it means that if you're a lawyer in Nigeria and you happen to have an issue in New Zealand, great example that somebody gave, I loved it because I'm from New Zealand originally, if you need that lawyer in New Zealand, even if you don't know them, that network can give you that degree of trust because the relationship has been pre-vetted, and you can have a degree of confidence that it's okay to put your client's problem in front of this New Zealand lawyer even though you haven't worked with them before. So trust is really key. Can we go to the next slide, please? So there are several ways in which you can be forced into a situation, or you can choose to get into a situation where you're working with counsel in another jurisdiction. It can be client-driven. So your client may come to you and say, we need the Nigerian part of this transaction done here. I've got a Rwandan lawyer doing the Rwandan part of this transaction. You guys need to work together. You still need to work together, but the client's driven that. Another way it can happen is that, you may have best friends. There may be a multi-jurisdictional pitch. There may be an international, a genuinely international law issue in play. And you may choose to put together a team of lawyers from different places in order to work together. So you might pitch the work together, and you might be successful in getting that pitch, and then you've got to work out how you do things together based on the relationship that you've formed at that stage. Or it could be that one law firm or lawyer owns the relationship or has the relationship with a client. They have a project ongoing, they have a client need, and they'll go out and select counsel to work with, counsel in another jurisdiction in order to actually meet the needs of their clients. But in all of those three situations, the relationships are really key. And so my first kind of pointer in my initial presentation here, which we'll kind of elaborate on in the session, is building relationships. Usually, I find, in my experience, personal relationships are the best ones. So, ideally, I've worked with somebody before, they've done a great job, and so I feel comfortable in working with them again. And I've got a few relationships like that I sort of regularly refer work to. Sometimes they'll send things back to me, so there's like a degree of reciprocity which builds trust. Sometimes I don't know every lawyer in the world, and sometimes I have a need in a jurisdiction where I don't know anybody. So the first port of call there is I'll usually send out, as all my partners do, a message starting with, pardon the interruption, do you know a good anti-dumping lawyer in Saudi Arabia? That's not a real question, but it's that kind of thing. Something very specific where you need help from somebody. You ask your partners. When I'm asked that question, I'll really filter hard in order to only give the recommendations that of people I genuinely trust, because I know that I am transferring a degree of trust when I make those kinds of recommendations. So relationships within my law firm are important as well. We've already talked about networks and alliances where there's a relationship between firms. And then on occasion, nobody knows anybody. And I don't know, I had a situation a few years ago in Timor-Leste where we just didn't know anybody my firm just didn't know anybody there, so we had to go looking. And there, things relating to, reputation and credentials are important. Very seldom do I consult, Chambers Global or anything like that looking for a lawyer, but every so often, if you can't find anybody else, those kinds of indicators of good reputation are useful. So, having those things available is good. Next slide, please. Okay, I've pretty much already done this one in terms of the benefits of relationships. There's just one thing here. So when I was thinking about how do you build, maintain, and nurture trust in relationships, obviously reputation is important. When you have a chance to work with somebody else, reliability is absolutely crucial. So, setting the right expectations and actually meeting or exceeding the expectations that have been set is really, really important. So reliability is absolutely crucial when you have the chance to work together. And then one thing, though, that is often overlooked in these kind of presentations, reciprocity is really important. So, most of my relationships are not one-time things. They are relationships that endure over time. And there is nothing that makes a foreign lawyer your friend more than actually sending them some work from time to time. So if you're receiving things, look out for things that you can give back in order to invest in that relationship. It could be projects. So if you have a transaction to share, that's a real kind of relationship winner. But even if it's just doing useful things from time to time, like sending somebody a slightly customized update on some development that might be relevant to their practice from the perspective of your jurisdiction. So, investing in relationships with a degree of reciprocity. Next slide, please. Okay, so the rest of this deck, and I'm not sure how much time the chair is going to give me because I've already taken 11 minutes.
Yeah, we have 3 minutes. There's a timer to your, to your left.
Great. I'm going to take that 3 minutes then. The rest of this deck is basically top tips. Where did I get these from? I sent an email around my firm, around my practice group in particular, saying, when you work with counsel overseas, and my colleagues in our international arbitration and litigation practice, where the focus is always on states, essentially representing them in international law cases or investment disputes, we always work with local counsel in the state that we're working with. So my colleagues have good insights. I said, what are your top tips for working with local counsel? And they gave me these things. So I've distilled them down to one word, but there's a quote that goes with these. The first one is respect. So if you're choosing foreign counsel, choose people you respect. And then if you're being chosen by somebody else, demand respect. You're entitled to it. Work hard to be worthy of respect by being reliable and ethical and all those good things. And show respect in the relationship as well. It's really important. Next slide, please. Okay, the next one, I've got a quote from my colleague about the optimal situation where at least somebody on our team at least knows somebody on the local council team that we're working with. That might be at the outset of the relationship, or it might be because we've made a point of actually putting some people together so that they can form that personal connection. It's really important, and you should seek out opportunities in those working together relationships to actually make that personal connection. If only through IBA meetings like this one. Next slide, please. Okay, another crucial thing that we all know is that communication is important. This one actually speaks a little bit to process as well. This quote from my colleague, talking about actually how to set up a system, a framework for communication on a particular matter. And you'll notice that it's quite deliberate in terms of the way it explains how to work together. And that's my kind of tip that I draw from it is, don't leave communication to chance. You may have a great relationship, you may be able to pick up the phone, but if you're working on a project, it's certainly worth going through it step by step to work out what the communication lines will be, who are the points of contact, at what degree, at what regularity are they going to check in, and how are you going to work together on an iterative basis to actually generate the work products that need to be generated through your common endeavour. I've got 36 seconds. Next slide, please. Okay, a related point to that one is being clear in terms of the tasks and deliverables. That's partly a communication thing, but it's also partly a planning and a management process. Somebody within the team needs to be kind of project managing things. They don't necessarily have to be the person who owns the client relationship, although it could be, but there needs to be somebody, and that person needs to be identified and needs to be accountable to the team for putting in place those structures. Next one. Thank you. Budgeting, crucial, absolutely crucial. There is nothing worse when you are referring work, or at least asking a professional colleague from another jurisdiction to join your team. There is nothing worse than having them mess up your budget. It's already costing you a slice of your client's legal fees by actually bringing somebody else in, and so the last thing that you want is for them to erode that. That means that the burden is on the lawyer referring to make sure that budgets are communicated clearly and that there's a meeting of minds, and then it's up to the council engaged, if that's the relationship, to make sure you manage and meet expectations in terms of the financial part. My time's up.
Yes.
Let's just look at the words on the next slide really quickly. It's the last one, ownership. Ownership, this is another point, particularly if you're referring work out, you need to give your collaborator ownership of the work they do. You can expect them to be accountable for it, but you need to give them the lead that's required to perform well. That's all I want to say. I'm sorry.
Thank you very much, Ian. And apologies that you had to rush through that. We are running behind schedule. Good afternoon, ladies and gentlemen, and thank you for your attention. I'm saying it in advance because we've come right after lunch, so I know that I'm competing with pasta and rice, and I think I saw some people eating swallow. So please, lend us your ears. We promise to be as engaging as a double espresso. We promise. Okay, so Ian has essentially started by giving us the blueprint for how best large international firms collaborate. I mean, I think the word that has been peddled this morning / afternoon, we started off by referring to Nigerian firms as local firms, and then I think the last panel we moved to national. My word is domestic firms. So how international firms collaborate with domestic firms. And Ian has given us a great start to the conversation. And for the benefit of those who joined us late in the room, I have with me partner at Bawani Godalo, Ayotunde, also a classmate, so friends from many years, and I have a powerhouse on his own, Adeleke, Alex Adeleke. So we will be talking through the conversation today. Oh, and I beg your pardon, and our panelists joining us online, if our technical supports could just project them so that we know that they're with us. We have Mr. Paul Harris Ogbole, SAN, Leonard Silk, and then we have Oyebuchi Douglas. They're joining us remotely. I see Oyebuchi, but I don't see Leonard Silk. But we will start the conversation. I had hoped to start with Leonard Silk, but if he's not online, then I will start with Ayotunde. Okay. So let me start by asking, given your extensive role in Bawani Godalo, what factors do you think shift from one-off instructions to a steady flow of instructions? It's on.
Okay. Thank you, Sholakwe. I hope this works okay. Good afternoon, everyone. Glad to be here. So, Sholakwe's question is to help us unpack why and how a one-off transaction today could lead to an enduring relationship in the future. And there are several factors. I've been privileged to do a lot of cross-border work in the last 25 years. And even if they're not written down anywhere, they're easy to decipher over time. The first one is, what's the nature of today's client? The real clients who have real legal budgets today are probably operating across jurisdictions. They're probably multinationals, or even if they're not multinationals in the traditional sense, they're looking to expand into other jurisdictions. And as you can imagine, it's not their day's job to engage legal counsel. They would want that one-stop legal shop, and hence they would have that international counsel as that one-stop legal shop. And I think any international counsel who wants to properly and actually provide that seamless service globally, ensure consistency. You're doing a global transaction. You don't want Nigeria to work and then there's a problem in Kenya. The timeline above country is the timeline above country. So in those two jurisdictions, due diligence must go according to the timetable, you know, and regulatory approvals must happen when they should. So that international counsel will do well to ensure that as much as possible, I mean, if it's not broken, don't fix it. You work with Sholakwe today, it goes swimmingly well. You start to build that relationship and you see that shift. So that's one critical need. The client's needs, I beg your pardon, one critical factor, the client's needs and their expectations would naturally drive that shift to collaboration as opposed to one-off transactions. I think another one would be efficiency, right? And related to that closely would be risk management. And it's from the basic things like, we like this particular type of due diligence reporting format, or we like this particular type of data sites for reviews of documents. Efficiency, how can we standardize processes? We did a deal with you, so if I did a deal with Ian 2 years ago, and hopefully I made him happy, then he'll be like, Ayo already knows how I work, let's go back to their firm. They understand how we use a risk matrix to report issues, and so they standardize processes. You have agreed risk protocols. You know what is allowed and what isn't, and all of those efficiencies are very beneficial. You also get a sense of each other's risk tolerance. You know, it's things like in litigation, we have a case management strategy, for example. So I think the need for efficiency and risk management will typically drive a shift to collaboration as well. And there's several others, but in the interest of time,
we'll come to that. And thank you very much, Ayo, for setting the tone, essentially. And I think this would be a great point for me to tell a quick story about DLA Piper Africa, Nigeria. And what underpins, as Ian spoke about at the start of his presentation, is trust. Now, DLA Piper Africa is a Swiss verein, and we talked about that the last panel, we are an indigenous law firm, and we're very proud of the Olajide Oyewole name, which is the name that our founder gave us when we were set up over 60 years ago this year. Now, what underpins the reason any international law firm is going to want to partner with a domestic law firm is, as Ian has said, trust. We worked with DLA Piper for over a decade. So it was a best friend sort of relationship before we formalized it in a Swiss verein. So we're independent, so our finances and our operations are independent, and that is the nature of a Swiss verein. But what is important is, as Ayo has also mentioned, the trust, reliability, and understanding what the client's needs are. You are not going to be able to partner with international law firms if you do not deliver on those key elements. Simply put, you are not fit for the alliance. And once you've established that over a period of time, and what is also very important is understanding what your strategic objectives are. The question that was asked before we broke for lunch was, what about the smaller firms? Sadatu used the term, I don't want to refer to myself as a small firm, but for the firms with smaller staff structures, it's important that you clearly identify what your strategic objectives are over 3 years, 5 years, so that you know at which point you may need or want to consider an alliance. And I know Denton spoke about that in the panel. So I thought it was important to set the tone given the DLA Piper story. And I would like to say, with the other alliances and vereins, they started in 2021, 2022. We actually became the exclusive Nigerian member for DLA Piper in 2017. So we've been at the forefront of collaborating with international law firms, and the benefits are immense. So I would like to come to this point to Mr. Alex Adeleke. So Ayo has spoken about what the key elements are for moving to more constant instruction. So let's talk about positioning, right? So how can local domestic counsel position themselves as strategic partners rather than reactive advisors?
Thank you very much, everyone. And it's an absolute pleasure being here. I wish I had the privilege of being the anchor of this session. Maybe I would have marketed my firm so perfectly like Sholakwe did. But again, I guess it's part of the cakes that come with being the anchor, right? I mean, just to add to what Ayo and Ian had mentioned earlier, I think the most important thing and critical thing for us as domestic or indigenous practitioners to make ourselves viable for opportunities that come our way in cross-border transaction is, number one, to me, would be that we need to develop ourselves adequately. Sometimes you find out that there's a lot of development that goes on with international firms and their lawyers within, and we need to keep ourselves abreast of most of these developments, and also ensure that we are very detailed and good enough in different areas of expertise. I think that once you're there, then you're technically fit for purpose, right? So another thing for me would also be that lawyers in Nigeria, for us domestic lawyers, using Sholakwe's lingua, we tend to be very lawyerly. So I think we should also ensure that we have good commercial context of clients' needs, right? So if you're put on a transaction, for example, and if you want the client to come back, like consistency flowing from Ayo's last response, is that the lawyer on the other side or the client wants to see that you understand the context of the deal. If you're in telecoms, for example, they want to see that you're not just talking about the pieces of or legal issues, you're also diving into the commercial context of the transaction. And So imagine a universe in which you are fit for purpose. That means you're developed, you're good, but you're not even visible enough to be seen. So I'll give a good example, and I think some of my guys are here. We were looking for lawyers in Kuwait to give a legal opinion last week. I guess the closest place we could go to is to go to Chambers or go to Legal 500 or one of those directories. And again, that's what visibility does for you, because you need to be open to those opportunities. And also on the flip side, you also have opportunities where people say that I found about you in Legal 500 or I found about you in Chambers. I mean, I don't think that you can quantify the benefits directly, but again, it's one of those things that you rather be there than not be there, right? Yeah, so that's also another thing that I also see. Trust has been talked about. You need to build trust with those that you find those opportunities with. They're best friend law firms that we work with, and they're global. And you get instructions from Israel, you get instructions from different parts of the world, and that's because we've been able to build trust initially with the London office. And those are the kind of things, including many other things that that we'll talk about much later. Thank you.
Thank you very much, Leke. So visibility, just to touch on one of the many important points that you mentioned, visibility is key. If you can't be seen, then you can't make yourself available for the opportunities. I'd like to take the conversation online. Is Leonard Silk on? Okay. Leonard Silk, I don't know if you can hear us, but if you can, the next question is directed to you. So the question is regarding systems, processes, and internal structures. So what are these systems, processes, and internal structures that tend to enhance credibility and reliability of domestic counsel in the eyes of international clients? Could you check? He was online. Yes, we saw him. He is online. Leonard Silk, if you could just take yourself off mute. Okay, in the interest of time, I'll move to Buchi, who is also online. Buchi, so from your perspective, and we've been talking a lot about cross-border collaboration and aspects relating to reliability, visibility. So let's change gears a little. One of the joys of cross-border collaboration is working with different time zones. I know every lawyer in this room can relate when you're working on a deal with a lawyer in Hong Kong, one in Australia, one in New York, and one in London, and you are sitting here in Nigeria, and what a joy that is. Joy in quote. So I'd like to ask you, Buchi, in cross-border deals or urgent matters, how can domestic counsel handle time zone differences, urgency, and deal pressure consistently and reliably?
Good afternoon, everyone.
You.
Okay. I'm sorry, can you hear me?
Okay, yes, please go ahead.
Okay. All right, so I think everyone has already laid the groundwork for that there has to be an understanding of the scope of work you're doing, of what is being expected of you. So once that is done, you have to get what are the foreseeable issues, like you said, the time zone issue. Sorry, can you hear me? Hello?
Yes, if you can speak up a little.
I said, once you understand the scope of what you're doing, the next is to look at the foreseeable issues that could arise, one of them being the time zone issue. Can you hear me now?
Go ahead.
Okay. So looking at the time zone issue, I don't think it's a one-shoe-fits-all kind of situation. It depends on what works for your firm. I know that there are some firms that do 24/7, so this is not an issue for them. But if you're not one of those firms, then you have to look at what would work that will help you function efficiently in this scope. You have to be able to time your meetings at a time when it doesn't overlap with other things, and it's convenient both for you and for your foreign partners. Are we here? I don't know if anybody's hearing you actually.
Yes, we can hear you. Don't worry. If we can't hear you, you will hear from me.
All right. So once that is established, you have to break the work into different milestones. And this is important in setting timelines. And when I say timelines, you have to set reasonable timelines. Now, I know as local law firms, you deal with pressure every day, and there may be, the option of trying to overperform. The option of trying to overperform. But if you do not put realistic timelines to your little milestones, you get yourself boxed in a situation whereby you're stressed, you do not perform as when you said you would, and then you end up not giving the best of your work. And this affects the reputation you're trying to put forward to your foreign partners. It puts you under pressure, it makes you feel incompetent, and it's just not a good look for you professionally. So you have to put realistic timelines. Then talking about building trust and reliability, when you actually put a timeline, put your best foot forward, meet up with your timeline. You're having a general outlook of having a long-term relationship with someone and not just a one-time transaction. So everything has to be in view in your work. And then communicate clearly. I know everyone has been talking about communication, but it can't be overemphasized. Communication is key in maintaining long relationships. You have to carry your international partners along. They have to be there at the beginning. They have to know where you're going. They have to know why you're taking this decision. And this is important because when issues do arise, they are aware of what has happened. So they are not taken by surprise so much, but they trust you to actually deliver as when you have said you will deliver. So when issues do arise, you can actually communicate to them and tell them, okay, this is what we're going to do. You may not have the solution right now, but you can give them a time or an alternate, option of when you will be able to give them that solution. And that will actually build trust to a long-term relationship.
Thank you, Buchi. So Buchi has given us the blueprint. Under promise, but over deliver. Don't do the reverse. Thank you very much, Buchi, for that. We are having some technical difficulties with connecting to Leonard Silk. So, Ian, I'd like to come to you, if I may. We didn't get the chance for you to talk through feedback loops, real-time updates, and how that can be managed between international law firms and domestic law firms. Buchi has touched a little on it. I summarized it as under promise, but over deliver. Do you have any perspectives that you'd like to add?
This is on, excellent, I can hear it. Yeah, look, I don't actually have much to add to those sort of really, really key insights. I think there certainly is something in the idea of managing expectations in a way that ensures that you maybe sort of set them low. Actually, a little aside, somebody said to me a couple of years ago, and this changed my life, so I share it with you as a gem of wisdom. Somebody said to me that the secret to happiness is having low expectations, and it's a bit of a joke, but it is really key because what you want to do is you want to manage expectations in a way that obviously gives somebody what they need and what they want, but allows you to deliver, to over-deliver, and to actually exceed those expectations. It's a winner every time. What we're talking about in terms of this question, though, is some of the specifics. And I always answer things at a level of general principle rather than very specific, because I think that in my experience as a lawyer, and I work in a fairly narrow niche, but I still find, even within my niche, every project is different. And so every project requires management in a slightly different way. And while I have some kind of rules of thumb and some documents that I use as precedents and some techniques that I use for project management, I always customize it. And so one of my answers to your question is always think about the specific problem, then the specific relationship, the specific transaction or problem you are solving. think about what's required to ensure those relationships work well in terms of feedback loops, in terms of processes. But, and this is my abstract point, make sure you manage it. So one of the points I tried to make was that actually it comes out of a few of the top tips I got from my colleagues. It's good for relationships if somebody is kind of taking control and saying, this is the expectation. We're going to, I'd appreciate it if you would give me a call once a week or at the end of every day or once a month. I would like it if you could, give me a report on budget in real time at a certain period in order to keep my expectation right on that. So the idea that somebody in the relationship is going to actively and deliberately manage the process, I think is really, really important when you're working with somebody who is not tied to you by contract or by the fees or the profits that you will make and share at the end of the year. If it's an external relationship, you're not insulting anybody by telling them exactly how you want things to work.
Very much. That's fantastic. That's a great tip to project manage each instruction so that you have clear objectives for each instructions rather than taking a one-size-fits-all or a generalist approach. Thanks for that, Ian. Ayotunde, I'd like to come back to you. Could you share, I know we talked about this, while we were prepping for this session, but could you share from your experience any case studies or examples of successful long-term international domestic council partnerships and what, in your opinion, made them work? I mean, I'm right here, so you can feel free to talk about DLA Piper.
No, I wouldn't dare. Is this working okay? Okay. So I think I'll start first with my firm because it's not the typical. So I work with Banwa and Igodalo. We do not have partnership or alliance in the traditional sense. We have deliberately not entered into that. But we have certain, is it best friends you call them, close friends, and I would use one in particular, but I won't mention the international firm, but I will describe what we do. So since 2010, 15 years ago, our firm and another, in fact, it started in 2008, and it just started off as there was a one-off transaction, and we said, we could do much more together. One client from Nigeria had taken the bold step of issuing what we call Global Depository Receipts, GT Bank at the time, in 2007. And, it just opened the eyes of not only the other banks in Nigeria, but us, the advisors, that you have to follow the client everywhere they're going. And so there was the International Council on that deal, and there was us. And so what we did in 2008 was to get all relevant stakeholders in the room, and together we had like a very big seminar. We found the investment banks, we invited regulators, and of course we invited the potential guys who we thought were going to go to do these transactions. And lo and behold, since 2010, every time the Nigerian sovereign, I hope the man on the street doesn't hear this because they don't want us to borrow more money for Nigeria, but every time the Nigerian sovereign has raised a Eurobond, BNI, my firm, and this firm have consistently been the two firms on the transaction. No traditional alliance, no partnership, but the ability to say to a client and show them how we can deliver from two ends without any hitches. And so sometimes you have it in traditional transactions like that, and that's why that international firm and our firm have done most of the transactions in that space. It started by being deliberate. So there are those types of relationships. And then there are the types like DLA Piper that Sholakwe described. Like I said, I'm not party to those, so I'm not the expert, but I like to believe that, it's for the reasons that we are discussing that they have worked. I like to believe that when DLA Piper works with Olajide Oyewole for 10 years and very naughty points, like things that could be kinks in the road, like how do we get regulatory approval when the regulations are not very clear? How do you do land perfection when the law was written in 1978? How do you sort out communal issues without people going up in arms? I think when domestic counsel can show demonstrable, ability to solve problems that would otherwise stop transactions in their tracks. It's always better when international counsel are initially overwhelmed by what they see.
You know, I like it because then I know that I'm going to overperform. Because they're going to be like, you mean perfection? It has to be a condition subsequent? And I say yes, and it might be 3 to 6 months. We can't do that. Oh, you will. All the precedent deals have. You know, so you need those kind of relationships, and you will go back to those firms that achieved that. On the flip side as well, domestic counsel, you're not someone who's being done a favor, okay, because you have that value to add. But guess what? You also should pay attention to what you can benefit. You're getting high value work. If you're paying attention and you're strategic enough, you're getting FX for it and preserving your currency devaluation risks. You're interacting with them and seeing how they use technology, how they train their people, and so it's mutual. I think those types of relationships and those types of interactions are probably why those things work. And then there's almighty technology, you know. I've had to literally, it sounds funny now, but we're having a transaction. Some parties were in the US, Sholakbe, and they insisted that they use only Google Meet. Google Meet, you know, and the regulator here says it's not going to happen. I don't know Google Meet. And lo and behold, I was getting calls, my phone was being blown up, I beg your pardon, solve the problem, you know, and something as mundane as the technology platform could have upended things for like 2 weeks. And so I had to get on a plane, go to Abuja, and show the critical person that Google Meet is as secure, just not as popular, you know, and the International Council were already fretting, and that problem was solved. I know that people use different words. I think ACAS calls theirs, you call yours a you use collaboration. When you check what Denson say, they called it an alliance or vice versa. I've seen something about UUBO. I've seen Bowman's on their website mention UUBO. That's the most opaque one. You don't really know what's happening there. There's no public information. Ozofu is smiling, but you know, there's that. And then there are the curious ones like Alukanebode in ALN after G. Elias left ALN. So you have different types, you have different structures, but the things that make them work are the same. Trust, relationships, maybe even friendships. Always ensure that this
Thank you
this
very
go well.
much. Thank you very much,
you.
Ayo. We are out of time, but I do want to ask this last question before we... I don't know if, let me look at Madam Chair, if we have time for one question. I know we're out of time, but before then, Leke, can you just, we've been talking a lot about positioning, reliability, building trust, the importance of relationships. So I think this question has already been answered, but I would like to hear your perspective. What do you think international firms prioritize when selecting and evaluating domestic counsel? From your experience.
All right, thank you very much. I think one thing, and I'm happy that if you look at the demography in the House, there are quite a lot of young lawyers here. And it's an opportunity for them to also realize that one of the things that I've seen from my experience is responsiveness. And that we don't get to see a lot of it these days. I mean, not to say that young lawyers are not responsive, but they must also appreciate the impact of responsiveness, right? I mean, the universe in which you receive an email and you wait till the most convenient time for you to respond, I don't think that that's good. I always tell my guys that, see, all you need to do is to acknowledge receipt. And the guy on the other side knows that, okay, you've seen this, you just want to deal with it. Something as basic as that can actually influence how the other guy feels about you. And you really don't know whether they are forum shopping, right? So that mail may have been sent to 5 different law firms. Somebody goes ahead of you, he picks on the work, and he runs along with it. Immediately they abandon you, and you wonder why they are not responding thereafter. Of course, without saying too much, the quality of work is absolutely very important, right? Ayo mentioned technology. How do you innovate within a deal, within a transaction? Are you creating a separate kind of platform for a due diligence review? I mean, I remember when I was much younger, not like I'm old now, but when I was much younger, we would write due diligence reports that would take you days to read, right? Like this bulky. But now today, even if you have that document, the client is not going to read it. We've all managed to color code, find different things to risk management, and all of those things. I mean, you are innovating. It's not just in technology, you are also innovating different processes that makes the work faster, swifter. To sound like Donald Trump, is going to be very swift, right? So you make it very swift for the client to be able to read and make and also make their own decisions, right? I think those are some of the very critical things that we've seen, and those abilities have helped to improve the relationship between us and those. Maybe I didn't say. Everybody's mentioning Olajide Wole, BNI. I walk into Aleo and Alexa Dedigbe. So, I mean, those kind of things. And also the ability to network and keep those relationships is also very important. Yeah. When you don't hear from them, how often do you send them what is going on in Nigeria, updates on Nigerian laws? There's so many policy changes going on now. Are you sharing those things with your clients abroad? Are you sharing them with those international firms? Are you keeping them abreast of what is going on in country? Yes. And I think lastly for me would be consistency. Relationships are won and lost on consistency. How well are you consistent with these clients? Don't yo-yo with them. You have to stay the same level or get better. Don't go down. You just have to keep it going, and that's it. Thank you very much.
Thank you, Leke. I would like to go back online. Leonard Silk, I think you can hear us now, and I see your hand is up. Can you hear us? Just if you could just confirm, Leonard Silk.
Okay. Good afternoon.
Good afternoon, and thank you. Apologies for the technical glitch earlier. We're fast running out of time, so I'd just like to ask what I think will be the final question. How do you see the role of domestic counsel evolving beyond simply providing technical or legal advisory services? And I think that would be a good place to wrap up this conversation. So Leonard Silk, over to you.
Okay, thank you so much. I believe you can hear me.
Loud and clear.
Okay, thank you. My name is Oluwaseun Olisa, and I'm a counselor in Chambers. Last week I had to step out to attend to an emergency at the Court of Appeal, and so just told me to continue in his stead. But I'll do well to respond to the question accordingly. So the question asked is how local counsel can evolve. If I could get the question again, I would really love that.
The question is how you see the role of domestic, we're not using the word local, domestic counsel evolving beyond simply providing technical or legal advisory services. How do you become more to your client?
Okay, thank you so much. To start with, it's important to say that the role of a domestic counsel goes beyond just providing solutions to the clients. And one important thing to state is keeping relationships, because relationships, when kept, can lead to more productive engagements. So rather than just have the idea of just getting the job done for the purpose of being paid off for the work, it's important to keep that relationship. We don't just burn bridges, but maintain healthy relationships. And most importantly, it's important to state that the domestic counsel must ensure that in providing those services for the clients, it must put in place best practices, ensure that there's timely communication, don't wait for unnecessary questions from the clients asking for updates, ensure that the communication is proactive. Also, the counsel must do well to have a commercial problem-solving orientation in dealing and dispensing the work that has been assigned. That would mean that you are approaching the work with not just a mindset of doing it, but to address the situation that has been given. And finally, I would love to say that there is need to ensure that confidentiality is maintained. The confidentiality of the clients, the information, the best practices globally must be upheld in dispensing your duties as a domestic counsel. And those are things that would make the relationship with the clients go beyond just commercial purposes and even do much more together. Finally, transparency. It's no news that there could be some bottlenecks in dispensing with issues locally, domestically, Nigeria, what have you. But it's good that the clients are informed ahead of time to keep them abreast with the eventualities that can arise. So when those things eventually arise, the clients are not often disappointed because there has been timely disclosure of unforeseen events that could come in. But in all that we do, my final word would be, whenever we have the opportunity to render services to clients, we should do well to see to it that relationship is maintained, is preserved, and that will be done in the course of dispensing our job effectively. Thank you so much.
Very much. I think that's a great place to end this conversation. Become a trusted business advisor. We're not just legal counsel. You have to understand your client's business, understand your client's needs, understand the timeline, maintain confidentiality. You must be legal counsel that can be trusted. Otherwise, you will not grow beyond where you are. And for those who are looking for strategic alliances, who are looking to grow beyond being a firm in Nigeria or a firm on the continent, you want to grow and have a global reach. The only way you're going to be able to deliver that is what all my panel members have discussed: trust, consistency, positioning, maintaining, not under promising but over delivering, and as we close out, in maintaining confidentiality. So I'd just like to thank all my panelists for their time this afternoon, and for the audience who stayed throughout the discussions. I don't know if we have time for one question. We do not have time. So thank you very much for your attention, and enjoy the next session.
Photographers, please. Please, can we have the virtual participants show? The engineers at the back, please. Please, a round of applause for this wonderful panelists. The applause is quite cold. Please, let's give them a resounding applause. Thank you so much for putting the energy. I know we are all tired. We've eaten and we're tired and it's very hot, but we are at our final panel session, which is a very interesting panel session. The topic of this panel session is AFCFTA, Business Opportunities for Lawyers in International Trade Agreements. Before we go into the discussions of this session, Mr. Segun Awolowo was supposed to come and present today, but unfortunately he passed away about 2 weeks ago. In honor of his memory, I would like us to stand up and observe a 1-minute silence in his memory. Please, I'll need the hall to be quiet. 1 minute silence. No movement, please, in honor of the memory of the departed. May his gentle soul rest in perfect peace. Amen. You can all have your seats. We're meant to have a presentation and then go into the discussion session, but for want of time, we've been directed to move straight into the panel discussion. And so I would like to invite forward the following people. Firstly, we have Dr. Fatima Bello, who is Deputy Team Lead for Trade Enablement and Coordinator for Policies, Regulations, and Laws at the Nigeria AFCFTA Coordination Office. She'll be joining us virtually, Dr. Fatima Bello. Physically here is Professor Sam Erugo, Senior Advocate of Nigeria, partner Sam Erugo & Co. Please a round of applause as he comes forward. Please, let's give him, I know we are tired, let's give him that, he's a Senior Advocate, please. Anyway. We also have Nankunda Katangaza, Director Hook Tangaza. Please, I hope I pronounce it correctly. She's the director at Hook Tangaza. Virtually also we'll have Hawa Kaka Usman, Registrar General, Nigerian Chambers of Commerce Dispute Resolution Center. Please a round of applause. She joined us virtually. And to moderate this panel session, we have Onoyemi Adetola, CEO Norbase and Chairman NBA SBL International Trade Law Committee. Please a round of applause. This panel session will just be for 30 minutes. 30 minutes, please. Thank you very much.
Good afternoon, everyone. All right, we'll jump right in. Can the technical guys confirm that the guys virtually are connected and can hear us? I don't seem to be able to. Oh, you're saying they can? It'll be great to be able to see them too. All right, so this is a great sequel and follow-on from the last panel. What we will be spend the next few minutes talking about is cross-border transactions, our opportunities for lawyers, and I'm excited to have those that are on this panel. I'm physically joined by two persons here. I'm physically joined by Professor Erugo SAN and Ms. Nakunda from Ukantangazi, both persons that I am very familiar with. Interestingly, he was previously chair of the International Trade Law Committee of the NBA SBL, so that's which I now chair. So great to be on the same panel with him. And then myself and Nankunda are now running a joke about how many countries we've been on panels together on. We kind of do this thing in different countries and different jurisdictions. For context, a lot of the work we'll be talking about and things we'll be talking about relates to the AFCFTA. And I was fortunate to have spent a lot of my career negotiating that actual agreement as Assistant Chief Negotiator for Nigeria. And more recently, also helping draft the Digital Trade Protocol for the continent, which was adopted by the heads of state. So when we get to have this kind of conversation, I'm very excited because it means people are at least listening to some of the things that we're saying and trying to get done. But I'll just jump right into the questions because we're running tight on time. A range of the conversations we're having relates broadly to regulatory and policy implementation, opportunities that exist for lawyers, and the rest. So I'll start very quickly with the question is who will bail the cat? You know what? SCNs first. They always get privilege in court, so let's drag them out here first. So Leonard Silk, I think the first question I want to ask you is, from a regulatory standpoint, and as someone who is a big part of the Nigerian bar, what do you think are the biggest obstacles preventing Nigerian lawyers from practicing seamlessly across the continent? And the reason is that with the AFCFTA, it's going to work the way we want. It means that we're going to have more cross-border deals. Nigerian lawyers are going to have to do more work advising across the continent on Pan-African deals. What do you think are the biggest obstacles that you see affecting Nigerian lawyers for being able to practice seamlessly across the continent, particularly under the AFCFTA? I think there's a mic there.
Okay, good evening, everyone. Tola, we worked together on this for some months now. I want to start by saying that there are so many obstacles. Probably that should be enough for this discussion. But let me start from the most pressing obstacle, which we all know, the issue of sovereignty. The issue of sovereignty of states, issue of we Africans wishing that nobody should interfere in our affairs. You found out that with the balkanization of Africa into nations, Nigeria happens to be very lucky to be this large. You found out that all these countries, as soon as you become independent, you want to keep everything to yourself. So I would say the issue of sovereignty is the first one. And that, of course, means that we'll have international law backing that issue, that you must keep everything to yourself. So, of course, we have local domestic laws. Very relevant here is the Legal Practitioners Act, which, of course, we know will not allow non-Nigerian lawyers to practice here. In the same way, we Nigerian lawyers will not be allowed to practice across our borders. That's the first major challenge. And even as we speak, it's very difficult, even with the treaty regime, it's very difficult to address. Let me take just one aspect to it. Of course, in the case of Nigeria, as the big brother we are in Africa, much as the Legal Practitioners Act, I think it's Section 2, restricts those who could practice in Nigeria, it still leaves room. It gives room for those that could get warrants somehow. I don't know to what extent that is working again today. But it also gives room for those who can get certificated and get called to bar. I dare say here that to that extent, Nigeria is still playing the big brother role. You find out that some African countries, their citizens, like Cameroon and some other countries, they still attend Nigerian law school. And if they pass the Nigerian law school, they will have qualified to practice in Nigeria. Correct. Because the body of benchers will not have any choice but to allow them to be called to bar, which means that those countries' nationals, if they go through a law school, could practice in Nigeria. But I'm not sure we enjoy similar privilege from the other African countries. Even those ones that are recognizing us now as having helped them get independence. I'm not sure we get that kind of privilege. So that's the first challenge we have. So it's supported by international law, issue of sovereignty is supported by domestic laws. So if you ask me, that's the major challenge. The second challenge, of course, I see is the competence of the Nigerian lawyer. Of course, for you to practice beyond the borders, you need to be competent. You need to be sure of what you are giving out. I listened to the last panel session where people were discussing the issue of what you have to give out. It's not enough that you want to partner with other lawyers. You also need to show what you are going to give in the arrangements. That's number two. Of course, even now that there are this AFCTA regime, not much has been done to that extent. Probably looking at Legal Practitioners Act, there is issue of reciprocal arrangement. It could be possible, the bar working, to have mutual arrangements. But of course, that still boils down to regulation. So that's the major challenge I see.
And that's a great point, because I remember when we were doing the actual negotiation for the AFCFTA digital trade, AFCFTA agreement, we got to the point where we had to submit what is called a schedule of services, commitment of services. And I know that we had invited the Nigerian Bar Association to actually indicate if they wanted to liberalize legal services. And the Bar Association said no. Right? The NBA, and I remember because we had sent it electronically, and I remember because we sent it electronically, asking them to send in their recommendation. They sent it physically. They sent it in, and they flew down to Abuja to say, in case you didn't open the email, we don't want. Yes. Right? I remember the meeting. It was we want our legal services closed off. You know, we want the highest levels of standards of protection. And I found it very interesting, right? So whenever I'm in these meetings and Nigerian lawyers say, oh, Pan-African trade, I'm like, you guys are the ones saying, don't come into my service space. Yeah. But I'll go to you, Nankunda. You advise a lot of the regional groups. You advise a lot of, the bar associations. What models have you seen work, particularly for firms that want to be able to do practice across the country? We've seen the popular ANN type model where people have like this one group and people have, almost like what we have with the consulting firms. But what other models are you seeing work and what are you recommending for the continent, particularly as we approach this whole new era of trying to do business cross-border?
Thank you. Thanks, Tola. I hope you can all hear me. I would say that the one example that I have of innovation in regulation of cross-border practice is actually from a small country that's sometimes the so-called big brother seems more scared of smaller countries than not. And this particular country, I would say maybe was a necessity is the mother of invention or innovation, was Rwanda. Rwanda had just emerged from a genocide. There were 16 legal professionals left after the genocide, 16. And that included judges, lawyers, magistrates, you name it, 16. So they urgently needed to build a new profession. They needed people to practice law and to fill the courts. And they were trying to run post-genocide tribunals, right? Because they had the Gacaca system in the country before the tribunal at Arusha was set up. The way they did it is they initially recruited anybody who was a professional, trained professional, so a doctor, a nurse, somebody who had some kind of regulatory framework background, so they understood their rules and you had to follow them. And they trained them up in the basics of lawyering or judging. Most of the judges in Gacaca courts were sort of local wise men and women. And they started with that. And that led, when they finally had a new Legal Practitioners Act of equivalence, it was much more relaxed. They had to build a new law school, etc. But from then, the openness to who provides legal services had already been set up. It had been established. This needed to happen. So Rwanda today is one of the most open jurisdictions. There are no nationality requirements. And their law school is extremely popular. They have people who train there from other jurisdictions who are admitted as Rwandan practitioners because that's the natural path. Unfortunately, some of those people now struggle to be admitted in their home jurisdictions because the home jurisdiction says, well, you didn't qualify here. That's a separate issue. So Rwanda's experience for me shows that sometimes you can actually do these things if you want to. And it also influenced the East African Common Market Protocol, and its provisions for free movement of services. The Rwandan model was very influential in terms of that. But I think because it came out of urgency, they were able to almost create a new thing. But beyond that, I would say the EU is a good model for recognition of cross-border practice. And we have to remember the AFCFTA is not yet another demand. I know it's very easy in this jurisdiction, say, oh, foreign lawyers want to come here, and they're usually talking about off-continent. But on-continent, and we have to talk about that, Nigerian lawyers, they too have services provided. The biggest profession. Why would you not want to provide services elsewhere? So if you block yourselves off, then you're blocking off your own opportunity, right? So I'll talk a bit more about EU later, but I'll stop there for now.
So what I heard Nankunda say is, Nigerian law firms, why are you guys not going to practice in South Africa or Rwanda or Namibia? And that's an interesting point. But I think that what I'm curious to know, and because my guess is that for the more established parts of law, think corporate transactions, think property law, it's probably a lot harder to get people to change their skin. But my guess is that with the newer areas of law that we're moving into expanding, talking of things like AI, emerging technology, it seems like there might be a lot more, in a sense, openness to allowing people practice. And I say it because in my former life when I was in King & Spalding in Geneva as a lawyer, one of the things that would happen is that I realized that we're actually still doing work on the continent without getting, in a sense, the qualifications. Because fundamentally, when it got into complex transactions, you did not particularly need a local lawyer for some transactions. Because in those cases, the local lawyer didn't even have the context, right? In some cases. Or a domestic lawyer didn't have the context. But I think what I want to hear from Dr. Bello is, as we move into all these expansions into places like investment, digital trade, intellectual property, cross-border dispute settlement, what areas do you think are the fastest growing opportunities for practice for African lawyers, and how do you think people should position themselves? Dr. Bello.
Well, thank you very much, Adetola. And also, before I speak to that, I'd like to thank the organizers for inviting us to participate in this, in this very important event. And I'd also like to thank the moderator for honoring our late senator, who is very passionate about what we are discussing here today. So for me, I see. Can you hear me, please? Can you confirm if you can hear me? So I. Okay.
Yes,
so
we can.
For me, the areas that I see potential for our lawyers is we have the digital trade. Digital trade is an area, and then we'd also I also see potentials in intellectual property. So for the digital trade, recall that there are lots of things that need to be put in place. On the one hand, the digital infrastructure needs to be put in place. You need to have the legal operation, the legal framework, as well as other operational instruments and operational ecosystem. You need to develop basically the ecosystem. So for that aspect, you need lots of legal services, for example, in ensuring that you have the necessary framework for data management to build all those data centers and the rest of them. And then you also need lawyers to ensure that you have a very sound and well-functioning electronic transaction framework, as well as to operationalize same. That's on the one side. And then on the other side, you do have opportunities to ensure that the clients have access into that into the market through the digital platform. So in that area, you have things like ensuring that you understand the lawyers. The lawyers, I think, need to understand the operating environment. So at the continental level, they need to be aware of the fact that we still have there's this fragmentation, in the sense that again, we come back to the issue of domestication. You have quite different countries being at different levels of domestication. You have a lot of instruments that need to be put in place for efficient implementation. So at the continental level, the lawyers need to be aware that what obtains in one country may not necessarily be the same as what obtains in the other. And then at the national level, they need to also be aware that some of the domestic instruments, that they'll be operating in an environment where, like the panelist from Banwan Igodalo, when she was giving some examples, she mentioned what do you do when you have an obsolete law. So you do have domestic instruments that first need to be that are obsolete, basically, that need to be updated and all that. So how do you work around that? How do you advise your clients, and how do you ensure that those do not form barriers or prevent them from acting? And then you also have the intellectual property, which to me, I think there's a vast opportunity for lawyers. They look at ensuring that you advise appropriately on trademarks, on patents, and then the innovation that it opens up to, and the industrial designs and the rest of them is just, for me, like a blank canvas for the lawyers. So I think it's an area that they need to familiarize themselves with. Thank you.
Dr. Bello. And I like that you started particularly with the AFCFT Digital Trade Protocol. That was, I worked on that. That was adopted by the heads of states in February 2024. The 8 annexes were adopted by the heads of state again in February of this year, actually. And like you said, it opens up an entire new sphere of the activities that would exist on the continent. But I think one of the things that we start to see in that regime particularly is this issue of how then do we deal with disputes that arise out of the AFCFTA. When we're negotiating the digital trade and the AFCFTA agreement, one of the controversial areas was dispute settlement. We had a protocol on dispute settlement, and the question at the time was, do we copy more of what exists within the WTO, where we have a panel and an appellate body system, or do we try something that allows for state disputes? And I remember that a lot of member states, I wouldn't mention any member states, fought strongly against the idea of states and investor disputes. They wanted it to be state to state purely, or investor to investor, but not the mix, right? And one of the big conversations now that we're trying to operationalize that protocol on dispute settlement, and now there's supposed to be a panel, member states have been told to send in all their panelists. That has been constituted. I think they had a bunch of meetings all of this year. I think one of the things that's interesting is that there is a big gap that exists for investor-state disputes under the AFCFTA, because the current protocol and annex only caters to state disputes. It literally says if you're not a state, don't come before the panel of the AFCFTA. And so the question for me, for Ms. Awa, seeing that you are Registrar General at the NCC DRC, the National Chamber of Commerce DRC Center, I'm curious, how do you see ADR institutions like yours playing a role in becoming dispute resolution venues for AFCFTA related commercial disputes? Is that something you think is important? What kind of dispute do you think would arise out of it? And how should we, at least as legal practitioners, try to look for opportunities with thinking of this space more broadly?
Good afternoon, everyone. Thank you. Can I confirm that I can be heard?
Yes, we can. You froze for a second, but we can hear you now.
All right, thank you very much. Let me take this opportunity to thank the organizers of this very auspicious event, and to say that this is particularly very critical at this point. And for institutions, and then let me quickly dive into the question that you had asked me. For institutions like the NCC, DRC, and other neutral ADR institutions, I think it is important for us to understand at this point, and from the background that you have laid, Mr. Tola, that we can play a pivotal role in bridging the gap that we talked about. Panels have been established, but there is a gap. And for institutions like us that act as a national center, even though independent and neutral, it will be important for us to particularly position ourselves as neutral and credible institutions that can provide dispute resolution services. It will be important for us to also understand, and of course, the kind of disputes that we're going to be seeing are disputes that Dr. Bello have mentioned, issues as to supply chain management, issues as to issues that will affect digital platforms. And institutions like the NCC DRC will better position itself in this instance to show that they have the credibility and the specialization through its panel of neutrals to cater to the dispute resolution services of organizations, companies, and even lawyers that will be practicing within the field, within that sector. Just last week, I was in an event when I attended the OIC Arbitration Center Dispute Resolution Week. We talked about having a unified system of dispute resolution services across OIC regional centers. And I think this is also something that will also be applicable for the AFCFTA. When we have opportunities to have to liaise and collaborate with other regional ADR centers within Africa, to create a network of maybe recognized AFCFTA dispute venues. And this will help in promoting reciprocal enforcement of awards across African jurisdiction. And I think it will also be important for us to come together, make ourselves available to the AFCFTA Secretariat and to other institutions that will be practicing within the region, that we have opportunity and the capacity to provide for dispute resolution services through specialized and experienced neutrals who basically at this point should be thinking about how to upgrade and expand their horizon in terms of knowing the kind of nuances that are, or the kind of dispute nuances that are within that sector. Understanding that issues such as specialization in trade law will be an important aspect of what our neutrals should be looking into. Of course, advancing the arbitration and ADR skills, which obviously will be the avenue for resolving disputes in this instance, rather than litigation. So, cross-border commercial practices, understanding that there are diverse legal systems across Africa, especially the civil law jurisdictions. For us, for instance, in Nigeria, that are most commonly that are using the common law system, it will be important for us as dispute resolution centers to understand that there are other jurisdictions, there are other systems of law that we have to train our disputes or neutrals to understand and be able to put themselves out there, that they are able to provide the kind of credibility, the kind of experience and expertise that is required within the system. And I think it will also be an opportunity for us as Dispute Resolution Center within the AFCFTA region to provide, for instance, a joint training or secondment and capacity building programs together within the African countries so that we can build a verified ADR identity. So we could have, for instance, a model case management protocol under the AFCFTA that we practice within our own region. That can be adaptable by each center and then guided by a unified system, which will provide like a procedural benchmark. So I think this will be, these are those kind of things that we should be looking at this point.
On to you, Professor. I think the question I want to know is, if you were designing a new curriculum today, and maybe it's two sides to that question actually. If you're designing a new curriculum today, what would you be focusing on preparing an AFCFTA ready lawyer? And what are your thoughts around the lessons we can learn from how to harmonize professional standards for lawyers? And I say that for 2-3 reasons. The question is, in the world we're heading to, our professional rules in Nigeria are still valuable. For instance, we have the rule against, advertisements, all right? We have that you can't advertise, even though, never mind. But you can't advertise under the Nigerian law, professional standard rules, right? Or there's even issues on champerty, right? You can't offer to, champerty. There's also the issues around you can't do a case and offer to be paid afterwards, right? All those things, are they still substantively accurate in the world we're moving into? That's why when you're going to start competing with an AI lawyer, potentially, right? But what exactly does it look like to be writing a curriculum today for an AFCFTA ready lawyer? And what lessons should we be thinking of from other jurisdictions that think about harmonizing professional standards across the continent?
Thank you, Tola. I don't know. You are looking at professional standards now from the aspects that should benefit the lawyer. But let's also look at it holistically. Yes, of course, in the new regime, issues of like advertising will be liberalized, whether we like it or not. All that you mentioned will have to be liberalized. But on the other hand, too, the Nigerian lawyer will also learn to abide by the ethics Your initial questions to me, when looking at what the new curriculum should be, of course, for me as a teacher for some time, we've been emphasizing ethics, professional ethics. The average Nigerian lawyer is very good in knowledge of law, in the drafting, in every other skill. If you ask me one area where we must look at again is the area of professional ethics. And of course, you know that the African regime will of course require harmonization of the rules of professional conduct. You talked about what we can borrow. That is one thing we can borrow from the EU. You have the EU standard, you have a professional standard. And in fact, that's the beginning of thinking of continental practice. We have to harmonize the rules of legal practice for every lawyer in Africa. That should be the starting point. Of course, the ones that benefit the lawyer, like advertising, will have to be liberalized. The second aspect, second competence we now look at is, like Madam rightly pointed out, we in Nigeria, we also now have to know that we are of common law. This thing, we have to think of the French civil law system. That is one area where MBA is good that this regime has furthered the issue of continuing legal education. If you ask me one area where the average Nigerian lawyer should start thinking of now, luckily AI is also helping, is to have an idea of the other code. Secondly, I thought one skill should be language. You know, most of us in the university days, you know, they are tempted to introduce French language. Mm-hmm. We joked about it. I personally have tried many times and couldn't succeed. So if we have to go continental, we have to think of at least we can start with French language. That is one that we need to. Thirdly, information technology. I don't think you can practice law even within Nigeria now without very good knowledge of this. You agree with me that the average, most Nigerian lawyers are not IT savvy. That's why even going virtual in corporate, so many lawyers, they say they are conservative lawyers. They're opposed to that because they are not ready. So I think these are some of those things we must think. Of course, Madam has beautifully illustrated some of these other areas of law that we are not used to, which, of course, will become more relevant as we move. Things like those of us that are good in property, land selling, those ones are not the areas of law now we are moving into. We are moving to, just mentioned them, she listed all of them. We are moving into areas that require you to be IT savvy. Yes. So, you know, I started by saying that the Nigerian lawyer who wants to go continental must be prepared to be retrained. Correct. We must be prepared to retrain. And I commend the MBA for the initiative. This regime, CLEA, much as I believe it has to be harmonized, this every day now you see one program or the other. I think we should queue into the IBA, MBA programs and learn more skills if we want to go continental. Thank you. I'm not sure.
No, you excellently.
Okay.
And I think you laid it up for my next set of questions excellently. So, you know, just last week I was at the Philippines, right, advising a bunch of governments on the cross-border transfer rules. Nigeria just joined as an associate member of the CBPR, cross-border privacy rules, and I was advising on that. And one of the things that you learn very quickly is some of the things you're saying. Technology is going to be an important part. You know, you're having examples already of strong AI systems with retrieval augmented generation, playing strong parts in how we think about law. You're having, you know, a clear case of people having to do language more seamlessly. You know, one of the things I'm hearing from Prof is that the next of this we should be conducting entirely in French, and everybody should, you know, have to figure out how to set up their skills. But I'll go to you, Nankunda. If I came to you today and I said, I'm a mid-sized or large-sized Nigerian law firm, or even a firm, and I want to be globally competitive for cross-border mandates, what should I be investing in over the next 12 months? I'm saying training, technology, partnerships. What are the critical parts that I should be setting up myself to become able to do Pan-African work, cross-border work over the next 12 months?
Thank you, Tola. I think I'd say there's one thing that seems to be missing from this conversation, and it happens all the time with lawyers: the client. Nobody talks about the client. It's all about us. What do we need to learn? What do we need to do? What does your client want? And how are you going to find out what your client or potential clients' cross-border interests are if you're not talking to them? If you're not going to the places where they hang out? Are you involved in your local chambers of commerce? There's so many chambers of commerce in most countries that are, Nigeria X, Chambers of Commerce, Nigeria Y, Chamber of Commerce. Are you there? Are you hearing who's there? Are your clients in those rooms? Can you find out about new clients? Are you learning about AFCFTA? You should read the agreement, sorry. You should read the Trade and Services Protocol, Trade and Good, just read it, bedtime reading, understand what it's about, but be interested. I think this conversation here has so often been about reacting. For decades, I know there's the fear of the international law firm coming to Nigeria to take your work. It's never been, actually, we have something to give, and I've said this already. So understand your continent. Don't think Nigeria equals Africa. It does not. You must know that there is a bigger continent out there with more people who might want to invest in your country. Are you there to help them come here? Are you going to AFCFTA private sector events? They have them. Are you reading Tola's newsletter that comes out regularly that's talking about regulatory change? Are you understanding? You have to actually make a deliberate decision to find out. Because your expertise, which you already have, you'll quickly see where you might fit in with the services that you can provide. Your client here might want to go to Malawi and say, Malawi, and if you go, I don't know anything about that, end of, well, that's the end, right? Say, sure, let's go to Malawi. Find out who you might know, who knows someone in Malawi. You may not be able to do, and I think this also comes to the point of practicing law and what that means. You're not practicing Malawian law. You're finding a Malawian lawyer who you can hand your client over to them, etc. I think it's really important to think of it that way rather than think of it in a reaction way. On the point of harmonization, and I know there's an issue about standards and that, and I always find that conversation to just be kicking things into the long grass. I don't really believe in harmonization per se. I think there's such a thing as mutual recognition of qualifications, which we talk about it within the context of trade. And the AFCFTA certainly is in the process of designing a framework, which we are actually working with them on, for mutual recognition of qualifications in the services sectors. This is really important. This is what happened in the EU context. It took ages, but everyone believed their standards were the highest. Everyone thought they had the best standards, and everyone else thought those people don't really know what they're doing. So you had to reach some middle ground, and it took time to get there, but they did get there because they were part of this agreement. So I think for a mid-size or small, even small Nigerian law firm, I mean, we had earlier Sadatu who was speaking about her firm, Hamu Legal. They're a tiny firm in Abuja, but boy, do they punch above their weight. They're all over the place. They started off with their tech stuff, and they've specialized, and they have made a point of building relationships. So I think that's what I would do. It's really start at that point. You want to do cross-border stuff, you're interested in the AFCFTA, and actually, by the way, you're already in ECOWAS. What's happening there? Forget about AFCFTA. What about ECOWAS? You're in ECOWAS. That's the biggest West African trading bloc. Start local with one that you're in that already facilitates movement, and that's then where you move into the bigger continent. So I will stop there. I know that you're being given notes.
Yeah, that's fine.
Yes.
Thanks, and that's very helpful. And like you said, today NOBE supports 58 countries, all right? And what you realize very quickly is that it's not that difficult to do transactions across the continent once you start to set up your firm to do that kind of work, all right? It's echoing, I think. Yeah. Just because we're kind of done with time, I would quickly rush 2 questions through to Dr. Bello and Ms. Usman. Dr. Bill, I think the question I want to ask you is, for firms that want to support clients trading under the AFCFTA, and based on all your policy work you're currently doing, right, what exactly are the specific legal or regulatory gaps that you're seeing that Nigerian lawyers have to understand? Yeah. I don't think we can hear you. I think the audio. Okay, we can hear you. We can hear you now.
Can you hear me now?
Yeah, we can hear you.
Can you?
We can hear you now. It's fine.
Okay, great. So first of all, I think some of the gaps we need to bear our mind. The law we need to bear our minds to, like I mentioned earlier, the difference. And then what the entire panel has spoken about, like the way Prof mentioned it, and the way all the speakers mentioned, the diversity in terms of legal culture, and then you also need to understand the fragmented the fragmentation within the continent in terms of the legal in terms of the laws, given that we don't have any uniformity, so they need to bear that in mind. And then when you come to the national level, like I mentioned earlier, they need to also bear in mind that we do have obsolete legislations, and then because of the fact that we need to first of all domesticate the agreement itself and some of and its protocols, and even at the continental level, ratifications need to go on in terms of some of those areas that have been agreed on. So those are the kind of things that could impact whatever advice they decide to give their clients. So there are gaps in that some of those are not yet in place, and then they need to find a way to work around some of those issues that are persistent.
As we move into this cross-border entire system, what do you think about enforceability of cross-border contracting, right? As people started draft dispute resolution clauses for transactions spanning multiple African jurisdictions. When I was advising on the NESCON deal, we had 80 investors spread across 28 countries, and you need to draft a document that works for that. How should we think of those kind of transactions, for instance?
All right, thank you very much. A lot has been said today about collaboration, about crafting and drafting of agreements. And I think it is important for drafting cross-border enforceability for us, either as lawyers or even as business people, to understand that this means that we have to anticipate where relief will be needed, even before we begin to draft. And this will help in making the pathway to recognition and enforceability as frictionless as possible. So practical drafting protects the remedy even before the dispute arises. And it is important that lawyers begin to think about dispute prevention, dispute mitigation, if it eventually happens, rather than dispute escalation. And part of what we should think about in drafting this dispute resolution clauses, I think, is to require that there should be good faith negotiations followed by mediation. So drafting a multi-tier dispute resolution clause, for instance, can be a way to anticipate dispute prevention or mitigation. So it is important that we draft or craft a dispute resolution clause that sees a dispute go through negotiations to mediations or to arbitration. And this can help to both preserve relationships and create enforceable awards, like you said. And it is also important, and I think this session that spoke about arbitration in the morning was particular about or emphatic about the issue of seat and venue of arbitration. So it is important that when we are crafting or drafting the dispute resolution clauses, we pick a governing law that is familiar to parties. And I can thank Miss oh, I'm sorry if I'm unable to pronounce her name, but she talked about thinking about the clients themselves at the point where we're drafting the agreement. And it is important for us to choose a seat that parties will feel comfortable, will feel reliable, either because the court system is such that is arbitration friendly, and also for enforcement. So this is very important. The New York Convention is there. It is important that we look at those countries that can offer reciprocal enforcement avenues, probably countries that have already signed the New York Convention and have ratified and document it as it were. It is also important, I think, to include issues like emergency arbitrator and jurisdictions where you could find consolidation procedures. Let me also add that, okay.
Yeah, you can finish the sentence.
I think
You can finish the sentence, and then we'll have to wrap that up. Yeah.
Okay. All right. Just permit me to include that we have to look broadly at the dispute resolution clauses and ensure that gaps are covered, so we don't have a situation where dispute arises and it is even difficult to bring parties to the table. So it's always important to be proactive in drafting those dispute resolution clauses that ensure that all the basic rudimentaries to the dispute resolution is covered at the beginning. And so it's important at the beginning to make sure that parties, when drafting, or lawyers when drafting the dispute resolution clauses, put in mind such reciprocal avenues for enforcement at the beginning. Thank you very much.
Thank you very much. And as we wrap up the panel, I think the thing to leave you with is this is an inevitability. Cross-border transactions are going to happen over the next few years. They're already happening at scale. The face of what legal profession today looks like is going to change and evolve. And I think the thing is to invite lawyers to participate in that process. It means getting abreast to what the law would look like, encourage your clients to do more audacious deals, supporting them in that process. And like someone says, knowing the law enough that you can advise your clients even as they creatively try to make transactions happen across the continent. I think the lawyers are in this very interesting place where they can be a very big part of how prosperity is created on the continent over the next few years and around the world. And I invite you all to come and play your parts as lawyers, as deal makers, and as those that make transactions come true. Thank you so much. That's our time. And we'll be wrapping up our panel. I think we'll just take pictures, I think.
Photographers, please, for group pictures.
No, wait, sir.
Please, can you allow the online participants show in the picture? All right, a round of applause for this final panel session. So very quickly, we have come almost to the end. We'll take closing remarks from Stephen Richman, Chair, IBA Bar Issues Commission. Stephen, just to confirm that you can hear us and you are able to take the closing remarks.
I can hear you. Can you hear me?
Oh, yes, we can hear you. You can proceed. You have 5 minutes. Thank you.
Well, I won't need 5 minutes. I know we're running late, and I really want to thank the Nigerian Bar, its president, officers, and committee, as well as the panel chairs for working with us to make today possible. We do this program every year, and it is always well received. And this year, we were pleased to return to a model of working in close connection with the local bar. And again, I congratulate the Nigerian Bar Association and our own ITILS committee and its leadership for all the work and success that went into this. I had the privilege of attending and speaking at the Nigerian Bar Association annual meeting some years ago, and I would have been in Lagos today except for some logistical issues that developed. But as we've talked a bit with technology, it's possible to be present and participate, even if it means getting up and being online at 4 a.m. This is the price we pay for being globalists. And it's important. The issues we discussed today recognize the global nature of legal practice. Somebody earlier on the last panel mentioned oftentimes we forget to think about the clients. The clients are global as well. And a conference like this, with the important issues discussed, cannot just be a one-off. We want to work with you and with others throughout the year, through our committees and through the entire commission, to get your input and voice as we work on various projects, including the ones discussed today. We've talked a bit about artificial intelligence. We've talked about arbitration. The IBA and the Bar Issues Commission prepare guidances for bars, and it's very important for us to have input, not from just the usual sources. We want to engage, as we've been doing more frequently, with the bars on the African continent, recognizing you're not monolithic, of course, but there are certain common denominators, and we want that voice to be heard. So I encourage you to reach out through our leadership that's present there, and also directly for anything that we can do together. And certainly, we will be in touch through this year. Thank you very much for the honor of having been able to participate with you, and have a good evening.
Thank you very much, Stephen Richman. A round of applause. Now to give a conclusion, I'll be inviting up the chair of the Nigerian Bar Association section on business law, Mrs. Ozofu Ogemudia. Please, a round of applause as she comes up to give her concluding remarks.
Okay, I think that Stephen has done a good job of concluding. So I'm just here to give vote of thanks. On behalf of the IBA, BIC, ITLS, the Nigerian Bar Association and the Nigerian Bar Association section on business law, we appreciate everyone that has spent today with us. We'd like to thank all our officials that have been here since the beginning. We'd like to thank all our participants and especially thank all our faculty, our resource persons for today. We wish you safe travels to your destination, and we look forward to meeting you at the next edition of this event. Okay. All right. So last set of photographs, please. Thank you.
Okay, thank you so much.
And thank you to our compare.
You're welcome. So we have come to the end of today's session. Thank you all for coming, and do have a wonderful evening. Thank you. Bye, everyone. IT, please, we want Steve back on the screen. IT, please, we want Steve and Richard back on the screen.
I can be your substance. It's easy when the love don't hide. No, I had to learn from my mistakes. Company creates companions. So right, yeah, yeah. Baby, both say I love your smile. Girl, I love it when you smile. Go line, I love your laugh, yeah. I love it when you smile. Say I would do anything for my love, yeah, yeah. I would do anything for my love, yeah. Oh Lord, run inside the building up your flames just to be with my love, yeah, yeah, yeah. I would do anything for my love. Oh Lord, yeah. We could do this all night. Love me cause it feel right. Say you need me in your life, your whole life. You do whatever I say, you would never hurt me. Loving made me feel amazing inside. Oh, you're the only one I need and the only one I see. Love the way you talk to me and I love your energy. Cause you make it look easy. My everything, babe, believe me. There ain't nothing I won't give, there ain't nothing I won't do. You're the only one for me, and nobody else but you. Cause you make me feel lucky. You know it's yours, baby, just me. Trust